Well, good evening. Good evening. Happy Friday. It is Friday, Friday, September 20th, and it is 8:30 p.m. 8:30 p.m. Happy Friday, everybody. I hope you guys are having a wonderful end of your week. And we're trying a new thing, and it's called being on time. And of course, because we're on time, there's like 300 of you here versus what we usually see. So, how we doing? How was our week? We had some interesting developments this week, didn't we? Just a bit. I would say that this week was a little more exciting than I thought it was going to be. hmm So, what are you guys doing? Where are you tuning in from? right now, right now, the chat is killing me. Look at you starting on time. Holy ass, you started on time. This is a time warp. What? Oh, come on. Once, twice in a row. I know. On time. Look, you guys are, look at this. Look at this. This is how bad this is. What did I do to Rob? I'm still Rob. I'm just on time. I'm the on time version of Rob, which is very important. Very important indeed. Like I said, I'm never late for court, although I do cut it a little bit close. Anyways, like I said, we had a bunch of developments this week that we want to talk about. And well, one of them involves a case that we talked about last week, the case that we've been talking about. And it is with, I don't want to say satisfaction is the right word. It might be. I don't know. But Diddy got arrested. Diddy got indicted. Diddy got detained. Diddy is in a world of hurt right now. And we're going to go through that as well. So let's see. It's on time. Look, everyone, people are still shocked that I'm on time. People are dead that I'm on time. People are right. That's the news, apparently. You know, Mischief asked me, she goes, "You going to put up a poll? Maybe you could put up a poll that says, is he going to be on time?" I don't know. I didn't have time to put that poll up. I did have time to get my materials pulled up, though, for what I want to talk about today. At least Charlene Fine Art. I don't know if Ian's going to make it or not. We chatted earlier today. I know he was on with Nicholas. I couldn't get on with Nicholas. I had wanted to because Nicholas Stera was celebrating his 10,000 subscribers for his channel. He's been doing the YSL Young Thug coverage, and I just didn't get home in time to get on. So that's what it is. I ate half a sandwich after a full day of court, and here we are. Diddy is donezo. So, how was your week? What are you guys doing? What are you drinking? Where are you tuning in from? I love to hear from all of you. We've got Arkansas, St. Louis. Do I still have a top sheet? Partially, I still have a top sheet. For those of you wondering what that is, there was a poll last week as far as, well, poll asking whether you use a top sheet or not. And the chat was remarkably divided. I think I started some wars. I didn't mean to. It just did. So, let's see. I'm proud and surprised. Diddy's done. South Florida. Hey, Carol. The baby oil. Yeah, the baby oil is going to be interesting. Yep. I don't think Diddy's ever getting out. Who knows? Maybe. Newfoundland, Canada. Phoenix. Where's the jury? The jury's there. Some of them are in boxes. Some of them are there. But the jury needs this entire area behind me still needs a little bit of revamp. So that's what the weekends are for. I saw that Emily was there in the courtroom. I think that there's going to be an attempt to cut some deals. Who knows? Convinced Rob's been replaced by one of the robots. No, I have not. Linda tuning in from Vestal, New York, San Antonio, Texas, eating birthday cake. Happy birthday, Patty Hoffman. We celebrated a birthday in this household as well this week. Mini Mischief 1. So we had a 10th birthday. And my mom was also here. She was in town. So in town celebrating birthday, and she saw the disaster of a house. She had a very lovely nightstand set up for her. It was called Stacks of Boxes. But it was lovely having her here. And she made a pressing point of, the reason the 10th birthday is so special is because you go, it's the first time you're in double digits, and then you go 90 more years until you're in triple digits. So we had a good time. It was lovely. Atlanta, Chicago, Kansas, Jacksonville, Florida, Ireland, UK. Look at this. Everyone's all over the place. We'll talk about the Sarah Boone representation as well. Michigan and water. Look at that. Elizabeth, thank you very much for being a member. Hello, Rob. We like you anytime you come on. I'm glad to be here. I'm glad to share this time with you guys. Beth G, Coke Zero in Kentucky. Got Las Vegas, fall candy. Ooh, candy. Chris Cat Queen, what's a top sheet? You know damn well what a top sheet is. Central Coast, California. Fiona W, thank you for gifting memberships. Very cool. Let's see. So there were some questions about, how's the unpacking going? The unpacking is a disaster. It will continue to be a disaster. I'm convinced that, you don't actually get unpacked for like 10 years. And then by the time you end up unpacking, you end up having to pack again, because by that time you're moving again. I don't want to do this anymore. I hate cardboard more than I think I've ever hated any material I've ever seen in my life. I don't know where half of my stuff is. I mean, a quarter of my stuff anymore. I had to change suits the other day because I was looking for my black shoes and I couldn't find them. All I had was brown shoes. So I had to go back upstairs and change suits for court. These are the things that drive people insane and drive people crazy. I completely understand it now. The things we learn. Weekends are for FMF. They are indeed. Bring the jury. The jury is there. Do we want to see the bring the jury bumper? We can do that. A little happiness. They'll bring the jury. Let's see.
The court has said our favorite thing. Bring the jury. Bring the jury. Bring the jury.
So the jury has been brought, although it still needs to actually get moved to its proper home. For someone that I know I was waiting to jump on. For someone I know.
Rob, you messed me up by starting on time.
Did you see the chat? The chat lost their minds.
They were like, "Oh my God, he's starting when he's starting.
Why are you on time? Who are you? What did you do?" Yeah,
I was like, I've got time to get some food in, and then it's like, nope.
It's on time. Eaton County, Michigan. Hello from Michigan, Alabama. Let's see. Georgia. Oh God, we had some crazy stuff in Georgia. Yvette's in England, drinking some peach tea. Cincinnati. Is there really a place called Kitchener in Ontario?
Yes. That is not the weirdest place name in Canada by a long stretch. There's a town in Canada called Dildo.
We've talked about this before, and we are 8 minutes into a live stream, and we've already dropped the D word.
Well,
but
aren't we going to talk about Diddy and his 784 small Newfoundland towns?
I thought it was almost 1,000. Oh, you mean the counts? I don't know if you were talking about the counts or the bottles of baby.
I'm talking about the prosthetics.
Oh, God.
The small Newfoundland towns that he happened to have.
Yeah. It's gonna be this is gonna be one of those interesting ones. So, speaking of Canada, I had a visit from another Canadian this week.
Oh, that sounds like a mistake. Oh, no, I know who you're talking about.
Yeah.
No, he's awesome.
Yeah, I think he said I could say his name. Devin came and visited in the DC area, was here, and he brought some Canadian goodies and snacks. And I didn't have a whole lot of time, but we did meet up and go to the Udvar Hazy Air and Space Museum.
Oh, nice.
Dallas. That place is awesome. Got to see the space shuttle, all kinds of cool stuff, World War II planes. So much fun. I love that history. I love history. I just so fascinated by it. You know what's crazy? If you think about the concept of flight, right? We have only been flying for not even 100 years.
Yeah. And it's actually gotten super, super reliable to the extent that if you take a flight, like if I were to fly to Virginia, I'd be far more likely to get killed driving to or driving from the airport than on the flight. That's insane.
Yeah. You know what's not reliable? What they used to fly in the 1920s and 30s. No way. Nope. They were mechanical death traps. I am convinced.
When you got to the era where it was like a pilot who has had 3 successful flights is retired. Because there was an era where it was like, yep, that gets you cleared, and not a lot of people made it. So
what's crazy though is at Udvar Hazy right now, there is wait, hang on, what was I?
But you know what the most dangerous thing you can do when you're in a plane is?
120 years. What?
Talk shit about Boeing.
Oh, good old Boeing. But they have right now at Udvar Hazy, they have an exhibition going. They have an exhibit that's what did they call it? I want to see if I've got it here. I was just looking at it. It is not early flight. No. It was just scrolling. Oh, they did have why am my brain is just what's the one that went really fast? The commercial airliner that we had to retire. My brain.
My brain as well. Yeah, the supersonic insane one.
Yeah, and it was the Concorde. They had the Concorde they had the Concorde there in the actual museum, so you got to see it. Just amazing how costly that was. No, the one that blew me away the most was they had I think they called it clouds and bags, but it's basically just hot air balloons and balloons and the development of like balloon flight technology.
Oh yeah, yep.
Oh my word. When I tell you that some of the little boxes that people decided to hook up to balloons and go up in the air 30 feet. Ian,
sometimes not even boxes, sometimes just a like a harness.
Yeah, 39,000 feet. 1,000 feet in a tin can box that's no bigger than a phone booth, and there's no top, there's no nothing. You're just in this box.
Yep.
But I mean, I guess there's no difference between falling from 39,000 feet and 5,000 feet. It's the same thing. It's just
more time to think about it.
They also had on display that
a little
the
bit more
tallest
time for
skydive.
regret.
What?
Oh, if you're falling from higher, you've got more time for regret.
Oh yeah, they had the guy that jumped from the highest skydive in history, the record high skydive, the guy that did it for Red Bull.
Oh yeah,
you probably saw where he jumped out in essentially a spacesuit, and he was free falling for I think 4.5 minutes.
Jesus,
his body broke the speed of sound.
Impressive in a dumb kind of way.
I know, but it was still impressive. So took a
and
little
the
time.
chat is apparently very curious about what I'm eating. I had ramen, and that's eaten, but I also have zucchini with an insane amount of peppers on it.
Oh,
because
like dangerous peppers. Oh, and the person
I've got a mix of like Ghost and Carolina Reapers, which I sprinkled on the was sprinkled on these, so they are lethal things.
Look at this. Pants. See, the thing is, you learn so much about people when you interact with them all the time online. You learn that Pants, hopefully Pants' owner, not Pants the dog, former skydiver, having done 2,300 jumps. That's so cool.
Pants the dog unfortunately passed away.
Doing skydiving?
I don't think so. I think just regular way. But
wait, I'm sorry. You were saying, you said something. I thought you said someone passed away doing that. I was going, wait, no.
No, just letting you know that Pants the dog passed.
Oh, Pants the dog passed away. Oh no. I hate when sorry for the pupper. So, oh no, classic overthinker. No, you are not late. You are definitely on time. It is 8:45. I don't think people had it on their bingo card that I would be starting before 8:45. So, I think you're good. All right. So, yeah, we're talking Diddy tonight. Trust me, we're going to talk Diddy. It is going to be very interesting. But let's see.
Diddler.
Catch up. He is so screwed. He is so unequivocally, absolutely.
Yeah, don't
beyond any
videotape
reason.
your crimes, folks.
Oh, we predicted this back when the lawsuits, the civil lawsuits. So,
oh yeah, I said
we'll give a
he's
recap.
getting arrested.
Yeah, we'll give a recap when we get all the way there. So let's get caught up. So baby steps. Thank you for gifting memberships. Very much appreciated. Steve A says, "Who are you? What have you done with the real Rob? I am the real Rob. The real Rob is here. And actually, I have a stand-up desk, so I can stand up.
The real Rob right now is in a suitcase in the background.
But was it self-defense?
It's getting Sarah Booned.
That's terrible. Oh, well, another one of my predictions came true in that case. Remember what you and I were discussing about what she would have to say?
Mm-hmm. Yep.
So, Victor Mann, thank you very much. Everything kicked off because EDB was traveling. She was actually traveling to New York. So I know that she was there for that hearing. Sarah Gruber, thank you very much. Busy playing with my laser cutter tonight. I am busy being jealous of you playing with your laser cutter tonight.
I got a new webcam.
You did?
I went ahead and bought the Logitech Reach for hopefully trying to film leatherwork stuff.
Cool.
I will probably break that out in a bit.
Time in the shop?
Yep. That's the hope, is more time in the shop. But I'll probably at some point be like, I'm going to transition over to the shop and set up the webcam in there.
Oh, I love it. That's phenomenal. You've been needing to do that for a while.
Oh, I need to get stuff made for the charity live stream for auction. So,
I need to get stuff set up in my shop so I can make anything.
That is sad. You need a shop.
I know. I do. But I did do an install. Maybe I'll pull a picture of that up in a second. So I did an install of because this shop has less space, so I don't have space to f around with. So I got to get really clever about where I put stuff. And I didn't realize until I had a friend came over who tried to help me unpack a couple weeks ago. This friend has zero knowledge of tools, no knowledge of tools whatsoever. So he's opening boxes and pulling stuff out. And he goes, "What does this do and where does it go?" And it was like that for 15 million things. And then I realized in the process of him opening all those things, I have a lot of tools. And I can always use more. So let's see.
I mean, tools are good. I am also in a position to acquire some more tools. I got my business firearms license.
Fine.
Yeah. It enables me to buy everything.
That's been pending for so long.
It's been over 4 years. But yeah. Yeah, I can theoretically go buy a machine gun today.
Well, there's no time like the present. You know,
I could order one while we're on stream, but I probably won't.
Well, don't show it because I can't do that. Not a real one. A non-mouse. My mom is from Kitchener, formerly New Berlin. Very cool. Patty Hoffman. Wow, very generous of you, Patty. Thank you very much. Demonetization and Leo Treat Fund. Leo is still Leo. He is still crazy. Yeah. We take him to daycare, and him running into that daycare, holy crap. You think that and they're very smart about it at the daycare where we take him, or the vet where we take him, and the floor is the vinyl.
Is it slippery.
Oh yeah, so it's just like it's just you just see like the spinning wheel of dog. Yeah,
Nice.
he is quite the absolute character. Hang on, let me see. I was gonna pull up a picture or two. Oh, so cool stuff. I'll show you this. We went to a local fair that they were having like a week and a half ago. There was a contraption there that I thought was remarkably ingenious, and by remarkably ingenious, I laughed my ass off. That is a those are cages.
Huh.
So parents you can cage your children, you know, for their enjoyment.
Does it have like an attachment for a padlock?
It looks like it might.
It kind of does actually look like it might.
Saw this thing and saw children lining up to get in this, and I was going, is this a torture device or is this something that they enjoy?
You just need to like add a flame to the bottom. Like you just build a campfire and this thing becomes
it's a giant little rotisserie. It's a rotisserie thing, right? Like just with little boxes for there were parents voluntarily putting their children in this, and there were children who were like screaming to like not to get out of it, to get into it. So that was, you know, those are thoughts. But I laughed. I saw that and wanted to show you. There. Tell me that doesn't make you a little bit jealous.
Yeah, my organization is not good. My organization is piles on the floor.
This was to get piles off the floor. So
yeah, I'm envious.
it is still quite a process. And then
I need to get my leather stuff sorted.
Udvar hazy. So that's on display there. It's really cool. And then the last picture I took there, I didn't take a lot of pictures.
I could use a wash.
Yeah. Each one of those tiles are individually fabricated and indexed and serialized. I mean, it's so amazing.
Yeah, they don't fuck around with design on those things.
How cool is this? So, what you are looking at is a drone that has a skeletal frame of an X-Wing built around it. And you'll notice the drone is black. So if you fly this thing at night, all you see is the X-Wing.
How much?
I know.
Chat, I've determined what I want for Christmas.
It is unattainable, but it is so cool. I was staring at this thing for a little bit. So that's the end of show and tell for this evening.
I am sad.
I want a drone. I want an X-Wing drone. Absolutely. Or a TIE fighter drone. That would be so cool. Yeah. Chat's all in it. So before we get rolling on the Diddy stuff and the Sarah Boone stuff, have you checked out any of the Young Thug stuff recently?
The thing about Young Thug is that it's like coming into a comic book story that's like been running for 6 years and you're just gonna start now, and you're like, because you go in and you know that issue 1 is like this guy gets bitten by like a radioactive hedgehog, and then you go to like now and it is like an episode of The Boys with like all the terrible stuff going on. You're like, how did it get to here? And also, what the fuck?
How did your brain come up with that hypothetical? And also, what the fuck?
I mean, my brain just does this. I have to stop it from doing that intentionally if I don't want it to do that. So that is just how my brain functions. Functions being with a heavy asterisk.
That's fair. So we had a development or two of the Young Thug. Let me swoop to that real quick because it's going to be kind of funny. Let's see. So swoop to Young Thug quick note.
We got to put this up though.
Oh yeah. Okay. Hang on. Link. Where's my link? Link. Do they have a short link yet, or is it still this long one?
I think that there's a. Let me see if I can pull up a shorter link. There should be a short version. I don't know.
I know. Last year they had one. Here, I'll pin it to the top of the chat.
Yeah, I'm just trying to see if there's a. I think there's a slightly shorter one.
Wasn't it Ian Runkle or Runkle?
Oh yeah, there might be a way to get a smaller link even. I don't know. Ooh, page link, customize.
See, customize your page link, and then I can update that.
All right. Should I put it as Ian Runkle or just Runkle of the Bailey or what?
Ian Runkle or Runkle?
Let's just go with Runkle. Everyone knows who Runkle is. There are other Runkles, but they're not as good.
Everyone knows who Runkle is. Yeah.
Well, I mean, that's not necessarily a good thing for them.
It varies from time to time.
I'm just trying to, I'm not trying to say it's necessarily the best thing. I don't have a chat. Oh, I've got the private chat. I can put it in the private chat. So there we go. I just hit it in the private chat there.
Okay, let me put it in the. There we go.
And somebody's asking, will you take pledges? No pledges, only donate.
All right, so it's pinned to the top of the chat. You guys.
We also don't accept grumpies.
You are currently at 2,545.
All right.
As we are approaching the extra live stream, please, if you feel like you're like giving, please give to that charity. Please, very much. All right, so Young Thug, that's where I was.
Yeah, that is a diaper dumpster fire.
Well, and the prosecutor is, I don't understand. I just don't understand. This prosecutor, first of all, I don't understand why the case is going on for millennia. It will never stop. It will never end. And the waste of taxpayer resources for a trial that at this time is more a memeable trial than anything else is exhausting. Exhausting. So the prosecutor is getting on the judge's nerves. This is a replacement judge, not Judge Glanville.
The thing is getting on the nerves in a way that causes the judge to do absolutely fuck all because they're a prosecutor. They've got it. There's got
defense
lawyers. They were like, go directly to jail. Do not pass go. Do not collect $200. But the prosecutors, it's like, yeah, we'll give you a second chance here.
Yeah, and Kate's right on the money. This poor jury indeed, because holy crap. So every day though, there's always there's an interesting exchange between the ADA and a witness or the ADA and a judge. The judge just laid into the ADA today.
Passed that objection.
Is that too loud or is that okay? Okay.
Miss saying passed that objection. Miss Love, I think one thing that
Miss Love, I know. May I respond? Cutting the judge off, like when the judge is ruling and saying, may I respond before the judge finishes, that's a choice.
I think one thing that, no, you need to listen. I think that one thing that needs to happen is when an objection is made and you are given an opportunity to respond and I make a ruling, even if that ruling is, please clarify, that you then need to obey what my order is instead of continuing to argue.
Your Honor, when I ask for
this is not the time to continue to argue.
I believe that as an advocate and as a person who is actually representing the victims who have been victimized in this case and who is
False statement. She doesn't represent the victim. She represents the state, but this is a choice.
Presenting as much
Yep.
as actually more than an officer of this court, and I represent something. I believe that.
Did you catch that? As much as in, like, listen to what she says.
The victims who have been victimized in this case and who is representing as much as actually more than an officer of this court, and I represent something. I believe that the state has as much right to express, to request, and to ask for consideration and for an allowance to ask the questions that it wishes to ask as the defense does. I believe, Your Honor, the objection that was made, and I understand what Mr. Sharp said, but there are a couple of things at play here.
Wait, did she just say
One,
Mr. Sharp?
Sharp is well aware that Mr. Zachary has said that his client was.
Yes, I know.
Why
One
is
of the defense counsel's last name is Shard. But
I would
loves
change
to
that
post-
name. I would
mean-
change that so fast.
especially when it's being pronounced this way.
Was with him. He has said it in the interview that I'm holding in my hand. He is not being honest with the court when he is claiming that Mr. Zachary had no idea what I was talking about. I literally said Shannon, Demikion, and Muktum, and I asked him how close he was with each of them.
Right. And then we went from that to his girlfriend, and then it was not unreasonable. And the objection could just be, vague, but it was not unreasonable to object to make sure that it was clear what the question was, who the they was in the question. And when I say clarify, that needs to be the end of it. And you need to ask a different question, rephrase the question, and let's move on. And there shouldn't be an issue with it.
Yes, Your Honor. If the state is not allowed to ask for clarification or consideration, that I
I
understand.
don't know what you mean by that.
Your Honor,
Oh,
when I
she's
asked-
getting
Clarification of
whiny.
my ruling, is that what you
When
mean?
I asked for permission beyond what the court has instructed, I did not know that I should not do that.
You know what you should not do? Take
Ask
that
something
tone,
and cut the judge off.
like that tone was a whole fucking choice. And I can tell you that if I was that judge and you took that tone with me, we'd have some thoughts. We'd have some discussion. Yeah.
You'd be bringing a checkbook the next time you took that tone with the court.
Oh, you'd be bringing a checkbook wrapped around a fucking toothbrush.
Yep.
It's like, yeah.
It just makes me so angry just to hear it.
Yeah.
I just want to scream.
Shouldn't be an
If the-
issue with it.
Yes, Your Honor. If the state is not allowed to ask for clarification or consideration, that I
I don't
understand.
know what you mean by that.
Your Honor, when I
A
asked
clarification of my ruling, is that what you
when
mean?
I asked for permission beyond what the court has instructed, I did not know that I should not do that. So I won't do that anymore.
That's not what was going on. You're basically, it seems to say, I'm asking permission to do something other than what the court has just ordered me to do. And so if that's what it is, then no, you cannot do that. If you need clarification of a ruling, then of course you can ask that. And if you want reconsideration, then you can ask for that, but that does not need to go on in front of the jury. When I make a ruling, obey the ruling and move on.
Yes.
Uh-huh.
Mm-hmm.
That's a choice. I don't know that it's the right choice, but it's definitely a choice.
She's making some choices.
Well, it didn't end there. Of course, because why would it end there? Why would it end there? This one just made me laugh a bit.
I know why it should end there. I've got all the reasons why it should end there.
Mhm.
Your Honor.
Yes.
So I'll ask this.
Hang on, this one's way quiet. Let me pull this one down real quick. Boost that volume. At least this one gave me a chuckle.
But we're not laughing with you, Ms. Love.
Mhm.
We're laughing at you.
Your Honor,
You're not in on the joke.
I'll
You
ask
just
this question and if it's
are the
objection,
yeah.
but did they talk about Don nuts in the call?
Objection, Your Honor.
Sustained.
Your Honor, given that I'm not asking him anything for which I'm offering the truth of the matter asserted, and it's a subject, I don't think that it's hearsay.
Okay, well, appreciate that you don't think so.
She's
Appreciate
asking
that
for
you
a
don't
real.
think so.
She's asking for a real hard correction in front of the jury.
Oh,
is
yeah.
where she's fishing with that, because there's a point where eventually the judge just stands up in front of the jury and says something like, "We've talked about these questions being inappropriate, and yet you continue doing it."
She does
Which
that,
is
though.
basically the biggest judicial go fuck yourself that the
I know. The thing is, Judge Whitaker has every opportunity. I mean, if you go and just look at the clips on Twitter, if you're interested in the Young Thug trial on Twitter, Thugger Daily is Twitter
Oh,
account that follows it.
he's awesome.
If you go and just scroll those clips, you will be astounded. You get like a full day of court in the clips of the snapshots, and it is, I mean, holy crap. But the trial will never ever end, and ADA.
Oh, I
Love,
mean, it's going to be the world's most expensive mistrial.
it can't keep going. There is so many errors that have occurred throughout the entire trial. There's no way this thing gets all the way through, and then also, it's getting overturned on appeal. So I just don't.
Oh, I mean, if
understand.
there's a conviction, it's appealable. So appealable.
So that's about as much as I can tolerate of the Young Thug trial. So what should we do? You want to talk Diddy or you want to talk Sarah Boone? Or should we ask the chat?
Yeah, we can ask the chat. I mean, both of them are messed up. I think Diddy kind of makes Sarah Boone look like a big old teddy bear. Like if you had to pick one of them to date. Chat, tell me I'm wrong about this.
I would, well, that's a lose. I mean, that is the very definition, Ian, of a lose-lose situation. You have to pick one of them to date. You date Diddy and you get, well, you get all of
You
that.
get diddled.
You get the freak offs. You get the chase down a hallway in a hotel and beaten, threatened on a daily basis, constant abuse. You get Sarah Boone. You get locked into a. Well, you get the.
I feel like the
gaslighting and
suitcase
get
is
locked in the
preferable.
Suitcase. It might be preferable to the freak offs.
Like if you had to pick one of the two.
I don't think I could pick. Just
I'm on Team Suitcase.
Yeah, but if she writes that many letters,
Oh,
the
you don't have
judge
to read her letters.
explaining stuff, you know damn well that. Well, that's a very disparaging. No, it's not. It's pretty accurate because she probably brings that stuff and has these discussions in the context of a relationship with regard to everything. You know, my fairness has been deprived of me, and then you get argument by filibuster until you
Well, I
wanna
mean,
lock
she's
yourself in.
definitely the
That's
sort of
why.
person who, if you don't respond, you know, you like, let's say you go to a movie and, you know, you're just like, I just want to be in a movie on my own, have some me time. And you come out of that movie theater, I guarantee you have 62 texts waiting for you.
Oh, and they're not the text. They're like that small. They're the text that they have to scroll to read through it.
Yeah, it's like, you know, you're checking your notifications. It's like 62.
And one
Oh,
of them
crap.
is
Is someone
in
Yeah.
all caps, hello, like for the entire paragraph of the thing. And then she's there waiting by your car.
She buys it. You get up at the movie theater and she's
right
behind you. She's bought a ticket, come into the movie like halfway through
Mhm.
and just to sit behind you. And it's like,
I see that you didn't read my texts.
yeah, you're like, oh my God, what the But I think she owns less than 1,000 bottles of baby oil.
Which was the weirdest. No, not the weirdest thing.
That is not the weirdest thing.
It's not the weirdest thing. We learned a lot of.
This
A
is the
lot of
problem
weird
with this thing
things.
is that everything you might be tempted to say, that's the weirdest thing.
It's not.
There is something actually weirder in this trial.
Yeah, it's not. It's not the weirdest thing at all. So you know what? Before we lose our sanity, why don't we? Let me see. Let me double check. The chat's really split on this one. There's 498 votes. So I'm gonna give another minute or two to vote. So let's see how the Extra Life charity stream is doing. I had it pulled up. Where was it? You know what? While we're waiting on the charity stream, what are your thoughts on, is there a deal that's going to be cut with regard to Diddy? I am of the opinion that no. I think
Diddy?
Yeah, for Diddy. I think he's going to deal it.
No,
he's going to get a deal.
I mean, I could see them offering him a deal. I can't see him taking it because the deal I'd be offering him if I was, the prosecution would be something like, we'll agree to 30 years.
I don't even think the prosecution would offer him 30 because
I'd offer him 30.
This is the initial indictment. You know that they have the ability to bring a superseding indictment if they find additional things. And right now, there's only suggestions of
I'd offer him
folk
30
attending these things.
I'd offer him 30 on the current charges.
Mm-hmm.
The thing is 30, he dies in jail.
Yeah, maybe.
I mean, heck, if you're thinking that there's the younger folk in this one, and it looks unfortunately like that may be the case, maybe you offer him 40, which pretty much guarantees he dies in jail, on the basis of you agree to this now, and you take 40, and we don't go with anything else.
It's possible.
You get to keep that part of your reputation intact. And but you do die in jail.
This question is far too easy to answer.
Diddy, he's got money.
Diddy, 10 out of 10.
Yeah, he's got money. He's your guy. Also, he's much more likely to follow instructions. He's not been the greatest at following like some of the implicit instructions, like stop trying to mess with witnesses. But he actually followed instructions like go to New York, sell your aircraft,
sell your house or pay off the mortgage on your home.
Yeah, drop 18 million on a mortgage.
Yeah, you are facing an indictment. You need to have everything liquid because like you need to basically make sure that you've got not liquid. You need to make sure that you've got security for the largest bond I can hope for.
And the thing is most clients can't follow instructions on things like be at court at 9 a.m. and you also need to wear pants. Sarah Boone is not really an instruction follower. She is a why did I ever become a lawyer kind of client. Diddy in a heartbeat.
Yeah, that's the problem. Like Diddy, look, the case is locked up. There's not a whole lot.
The case is gonna suck, but you know you're getting paid in advance, and you know that your client is not gonna do something insanely stupid. I mean, he is doing stupid things, but he's not gonna do things like he's not the client I worry about like firing me the day of trial. He's not the client I worry about
going sideways on the stand and talking about attorney-client privilege communications.
Yeah, that kind of thing.
There's a predictability.
Yeah, he's the sort of person who, notwithstanding being, if the allegations are true, a terrible human being, he was at least able to function well enough in society to amass this empire. Most clients can't function well in society at all. So no, it's Diddy.
Poll was deadlocked 50-50. So I'm gonna use tie-breaking authority and do Boone first. Diddy is when we get into those allegations,
Diddy's late night material.
Yeah, when we get into those allegations and that it is gonna be not for the faint of heart. So
Or the faint of
Katrina
stomach.
Or the faint of stomach. Katrina, I did notice that. Thank you for that. Kim Chi, thank you. Imagine the breakup text Boone would send you.
Oh
I don't
God.
have to. I feel like we've read them. I don't know. I feel
Yeah,
like she broke
the
up with the
breakup
judge
text
and
she
the
sent to her
lawyers.
lawyer.
Yes, we've read the breakup letters to the judge, to the lawyers, to everybody involved. We know how it would read. Oh, just the thought of representing Sarah Boone is grating on me.
Oh, she's a huge headache, and just she's going to be a rough client for and that's the other thing is if you have to choose between who to take on as a client, the person who's on like lawyer number 52, if they've had more lawyers on this file than they've had years alive or than they have teeth, they're not the client for you.
Let's make some ketchup. Nanner, thank you very much, Rob. I need you to text CDB. Ruffles is bringing all dressed chips to the U.S. for a limited time starting today, but they won't taste the same. That's the difference. They're going to say they are, but they're not going to taste the same.
Also, I hope Emily's still sitting on I gave her like an entire trash bag full of
I don't know.
Canadian. I hope
teenagers.
she's still sitting on some. Oh, okay, they're gone already. They were gone in 15 minutes. Teenagers snacked them to death.
They might have. Thank you very much for watching, y'all. To get a bit smarter on the week. Thank you very much, Sir Merrick. Thank you. You should reach out to EDB and see if they still have the handwritten notes. I'm sure someone would buy them for Ian's fundraiser.
Which handwritten notes?
From, I think the handwritten notes from when she was at the Diddy hearing.
Oh, yeah, no, that might be a little awkward.
Did he do it or did he not? That's the question. I don't think that's a question.
There are some files where you're like, oh yeah, it's really in doubt. And the thing is everyone's entitled to the legal presumption of innocence. But we're sitting here looking at a case where they're like, we have all of this on videotape. And that makes things a little more awkward.
Yeah.
So
I want to try something. Wolf Kiara, will the real number please set up? Let me try something and see if this works. There goes the desk. So the desk is up. Yeah, I can stand up. That's actually not bad.
You got a standing desk?
Yeah.
I hate those.
Not bad. Doesn't bother me too much. Well, my back gets frustrated when I sit too long.
Yeah, I can't stand for long periods.
Kathy Hecht, thank you very much. Kathy at odds. Sarah Boone requesting her own glam squad. We're going to get to it. I didn't watch that hearing all the way through, so I'm going to watch as much of it as I can tolerate. Michigan Farm Boy. Now Ian just needs fun toy money along with pro bono money.
There are some moments when I just wish I had made the decision to pursue wealth as opposed to do way too much crap for, not wealth. Yeah, that's some of it. There's also a piece of land I'd love to buy that is out of my price range, most likely. And that makes me sad.
Still the same one?
It's a bit of hunting land. It is 400,000 Canadian. It's a lot of money.
So it must be a bunch of land for where you are.
It is 160 acres.
Yep, that's a lot of land.
So
a lot of land.
It's a lot, but it's enough land where you can just go and not hear or see anybody. And that is really kind of the ideal, just to be like, I don't exist in the world anymore.
Carol's asking if I watched any of the Carly Gregg trial. I did not. I didn't. I know that she got convicted today, though. I know almost no facts for that trial.
I think she was running an insanity plea and it got shot down, as like 99% of those pleas do.
Jillian Whelan, it's after midnight in Ireland. Technically my birthday. Happy birthday, Jillian. Congratulations.
Happy
on
birthday.
another year.
That is awesome.
Glad to be starting with all three or all of you guys. Cheers to you. Happy birthday, indeed. Yellow Pill, stuck at home feeling like trash with COVID again. My cats are such jerks and have been taking advantage of my fevers by constantly using me as a bed. Glad y'all are streaming. I'm sorry. That's brutal.
The thing is I've been sick and I really appreciated the puppies going, you know what? It is snuggle time. I'm like, oh, well, at least, you know, Zora's here to to be like, all right, I'm on your team here.
Yeah. They know when you're sick too.
Yeah, although Potter's also sick.
Oh, seriously?
Yeah, he's got some cough and it's kind of worrying but he is like 0% slowed down by it. So he wanted to like run around in the backyard. And I'm going, Pup, you're too sick to play like this. You know, you're coughing. You can't. And he's like, no, I am not coming in until we have had a proper romp. And so I'm like, well, he's going to tire out in 2 minutes. So I went out, you know, just like, okay, we'll play dog. And I'm just out in my socks. And he's like, no, we're going hard. We're like, you got to chase me. We got to do all the things. And I'm like, come on. Especially bad because he's like, you got to chase me through the yard and it's dark and I haven't put my shoes on, but he's insisting that I chase him. And I'm like, buddy, I don't know where your poops are. This is a really dangerous game you got me playing here. So it was a little bit of, you know, playing a little bit of Russian roulette, running around in the backyard with socks on going, God, I hope this doesn't end badly.
That's a really bad loss too. If you take that loss.
Oh, that was going to be like throw some socks in the garbage.
Yeah. And then soak your feet in acid.
Bleach. Yeah.
Yeah. Gina D, thanks for becoming a member. Bop It, X-Wing Fun. Thank you, Bop It. I talk about Bruno. Hi, Robin. Ian. Hi, talk about Bruno. Mischief is again reminding the chat that if you guys get the Ian's charity up to 5,000 tonight, I can have my top sheet back. Happy Friday.
Poor Rob.
Love you too, honey. Linda Santiago, thanks for making my Friday night fun. Rob and Ian, thanks for being here, Linda. Canonical Heat, thank you very much. Glad to have you both together again. Kind of like Butch and Sundance.
How did that end?
Snakes, not so well. Lucy, Snakes Will Hiss. YSL needs judge from the Carly Gregg trial. Toothbrush. I heard the judge got mad. I didn't see it yet. I have to catch up. I'll figure out. I'll go back and watch some of that. Maybe when I'm in the shop this weekend trying to clean stuff up.
I made a shirt that says the snakes must hiss, and I wore it to a 3-gun match. I don't think anybody got it. I was explaining that joke all day.
Well, it happens. Let's see. Canonical Heat, thank you for gifting 20 memberships. That's remarkably kind of you. Thank you, Canonical Heat. Vez, glad to see you. 2 years of adventure with Rob. Woohoo. Thank you, Vez. It's been 2 years, and I love seeing the chat. Gotcha, the Frankfurter just returned from vacation. Not only did I miss 2 Friday Night Frenzies, but Rob's on time now. Missed you all. Was on time. Maybe we're not going to get used to it because I think I set the bar too high by being like right on time.
You're flying too close to the sun.
Too close to the sun, indeed. Lori Leanne, please, how can this jury afford to live/have jobs? I don't know.
If they're not all retired, there's a lot of retired people who serve on juries. And this is part of why that happens. Because, you know, you just end up in a situation where it's like, okay, the only way anybody can do this is if they, you know, if they're on like a pension or something. Yeah, it sucks for the average person.
Yep, it's pretty brutal.
Can you imagine how homeless we'd be if they made us serve on a jury as long as the YSL?
No.
Yeah.
Like, I can't imagine what that would be like. I cannot imagine going to the same courthouse every day and listening to these individuals feel like bicker all the time.
I feel like if I was like, if we're going on like month 3 of a trial and I am on that jury, I'm just like standing up and just being like, judge, I'm going to convict or not convict, whichever thing pisses you off most. I have already, I'm going to coin toss this. Get me off this jury. And the judge will be like, I'll hold you in contempt. You're like, that sounds better than what I'm doing now.
It does. Judge Glanville held a juror in contempt in this case for trying to get out of it. Kathy Sawyer, finally catching a Friday Night Live. Go Wolfpack. Go Wolfpack indeed. We play Clemson this weekend. It's going to be interesting. Got to the Frankfurter. Thank you for gifting memberships. Much appreciated. Canonical Heat. Thank you so much. Do the things. The ones that count with YouTube. 2,000, well, now 471 of you watching and 810 likes. Make sure you hit the like button, folks. And if you like what we talk about, please subscribe to the channel. Hit the like button.
And we
please.
mean like the way we talk about it. I don't think anybody should actually like what Boone or Diddy are up to.
That is a very important clarification. Thank you for making it. Very much appreciate that clarification being made.
Just, yeah, I had somebody weird in my chat at one point being like, why are you like talking about this? This is bad stuff. And I'm like, I know, I am saying he's an ass. But okay.
Jillian Whelan, Rob, 2,000 for a top sheet. How important is it? It's not. It's just encouraging donations to a very worthwhile charity.
Rob hasn't Rob hasn't busted his checkbook out to write a $2,000 donation at this point
yet,
but he thought about it real hard.
There's a fleeting moment. I was like, do I just make the difference up? It's good. Yellow Pill, the only reason I'd offer a deal is so that those videos don't have to see the light of day and get played in court.
Yeah, and there is actually a lot to that. Often you'll have victims who don't want to testify. Like you'll have victims who are willing to testify, but would rather not if they had any option, right? Because
they don't want to relive the experience. Why would you? Like, you don't want to re-traumatize them.
Yep. So...
And you also want to forego the massive cost of this trial. This trial is going to be expensive AF.
Oh, absolutely. I mean, Diddy's going to come in with, he's going to have like 2 buses of lawyers.
Mm-hmm. Yep. I can imagine it. Time Lady, AR. I enjoyed the 4-hour stream last night, Runkle. It was a lot of pain, then lots of pain meds. But yeah, thanks. What'd you stream about last night? I saw that you were all going live. I didn't see what you were talking about.
So here's the thing. I was still rocking the flu last night.
Oh, God.
And I don't remember my stream.
Oh, my God. Seriously?
I think it was about Diddy. I think that was last night.
I feel like it was.
But I don't actually have a good memory of it. I know that by the end of it, I was really, really tired. And I told people that I would go and that I was planning on playing Satisfactory afterwards. I can tell you what happened actually. I fired up Satisfactory. I looked at it for a little bit and I was like, I don't even know what I want to do in this right now. So then I shut it down and I tried to sleep, but I couldn't. So I just spent a lot of time just kind of in that, I can't quite sleep. So it was not the best.
You did. You streamed for 4 hours and 22 minutes last night.
Yep.
That apparently you don't remember.
Yes.
The good news is there's a place where you can go refresh your recollection because it now lives on the internet.
I am probably not going to watch my own stream because that would, I feel like that would be a little self-indulgent.
Yeah, I don't do that. I hate the sound of my own voice, period. So
I like people are like, how much editing do you do? And I'm like, as little as possible because I hate listening to me.
I can't do it. People send like, and if I walk in and like Mischief's watching or my mom's watching or something, I turn it off, please. I can't.
Yeah. It's going through the like Supreme Court appearance was rough. And I know how that one ended. It's like it ended well, but it was still rough to watch.
Oh, yeah. Yeah.
So yeah.
Viper class. Just wanted to say finally got my ADHD diagnosis. Congratulations, Viper class.
Nice.
I don't mean to say it like congratulations, like yay, way to go. I mean, this is answers. These are answers that you probably have been looking for quite some time.
And also, yay, way to go, because I know that people with attention deficit, one of the things that could be really, really crappy is how do you get the diagnosis when you suck at doing things like booking an appointment with a psychiatrist? So for a lot of people, actually getting that diagnosis is a major hurdle. And, you know, so good for you for, you know, finding the ability to navigate that, because that's a whole thing, right?
Oh yeah, absolutely.
So
it's quite the achievement. Tyler Julian, thanks for becoming a member. Much appreciated. Nan R, good luck with donation. I gave as much as I could. Give as much as you wish to. I'm not saying give as much as you can, because I don't push your wallets, folks. And don't push your wallets.
And this is luxury spends. Like, this is if you are, you know, and unfortunately the economy sucks. If you're sitting there going like, hey, I got to make tough decisions about like what to spend money on. For God's sakes, I should not be part of those decisions. Like, like just no, spend it on,
however,
you know. So yeah.
If you are a small business that is, you know, maybe you did really great this summer and you're looking to get some deductions because you're worried about that tax liability, this is the perfect way to do that.
They do send a tax thing, but I don't know, because it's the Canadian stollery, so I don't know how that works with the US.
Consult your local accountant. I'm not a tax lawyer, and this is not tax advice.
Yeah, I'm the furthest thing from a tax lawyer.
Potion Master Danya. Tomorrow's the first anniversary of my dad's passing, and I was diagnosed with probably cancer yesterday. By far not the best time of my life. Looking forward to have some fun time here. I hope you're having some fun. I'm very sorry to hear about the diagnosis, but cancer, the horse you rode in on, and keep fighting it all the way. Don't ever stop fighting. Cheers to your pops. It's tough.
Cheers.
It's tough circumstance to be in. LJ Peach, Rob, they tore down the Daybell house yesterday, going to create a memorial for the kids. That is probably the most appropriate use of that property I can possibly think of.
That or parking lot.
I feel like the memorial's better. Parking lot is, yeah. Don't build anything else on it. Alita Lane. Either way, Boone or Diddy, it is awful. Defend it. It is. Heather, I feel conflicted. I want to support Runkle's charity, but I'm with Mischief on the betting. I imagine that Mischief will move that benchmark. So if we get close to 5,000, she'll all of a sudden change it to 10. Light Queen, good evening from Van Isle, Canada. FNF and diamond painting. I'm in for a great Friday night. Diamond painting is fun. I haven't tried it yet. I've always wanted to, though. Angel Baby 4210. Thanks for giving a member. LJ Peach. Again, they did it for the OJ trial for 17 months. I forgot that trial was that long.
Yeah, that's brutal and
absolutely crazy. Aurora W. First donation of this year made for the flat sheet. Also celebrating signing the LLC docs today. Thanks for the inspiration, Rob, Ian, and EDB. That's awesome. Yeah. So you incorporated. That's phenomenal. Congratulations. I know that's a big step. So way to go.
Here's the other thing. I don't use a flat sheet.
I figured you wouldn't. Savage.
Like
CDA,
flat sheets are like pineapple on pizza.
God. Mary Swanson, Rob, I drive by your alma mater, Nova, all the time. It's grown into a huge school. Go, Ian. Go. You've got this. Torin took me to 55 to get my diagnosis, and after 2 months, doc took away my ADD meds, and I'm finding out they were really
Oh.
helping more than I knew.
The shortages of meds right now that are causing doctors to not prescribe or people having trouble filling, that just sucks.
Yeah, it's tough. It's tough. And when your brain starts working properly, and like when the wiring is connected the right way and you're functioning properly and you're doing all the things and things are lining up, to have that taken away and to go back to something that frustrated you is really hard. So I hope that that gets remedied, my friend. I really do.
This is actually one of the reasons I'm so bad at taking my meds, is because I really hate the period afterwards where it's like, okay, I've been, like doing the things, and then it's like, and now I have to like give all of that back for a while. And that just sucks, especially because like, you'd think it's like withdrawal or something like that afterwards. And it's like, no, this is actually just how my brain is.
Mhm.
And like realizing how much it sucks to be sort of bored in a painful way all the time is like, it's like, oh, right, this is just how I normally live. Great. Yeah, it makes it a little challenging sometimes. So
It very much so does. The chat is still talking about this. I'm going to put this poll up again because you weren't here last time when we did it.
uh-oh.
Do you sleep with a flat sheet or no?
And my answer is no.
Team flat sheet. Team what? Just comforter?
Yeah, team blanket. Comforter always sounds weird to me. It's like I'm
And I
just going
asked,
to sleep.
what's a
It's like
flat
I'm not
sheet?
having a breakdown.
I'm not weighing in and trying to say anything on the poll. I got accused of swaying the poll last time, so we'll see if that thing works. EFAS 4824. Thank you. I'm pretty sure I just broke my foot. Oh my gosh, sorry. It's dripping over my husband's boot. Refuse to miss you guys. Staying put. Hang in there, but may pay for it. Priorities. No, the priority is not tripping over your husband's boot and breaking your foot.
Also, like, if you need to go to the hospital,
Go to the hospital.
Go to the hospital. The other thing is you could like bring a phone and some headphones and listen to us in the hospital. And I can guarantee it'll help because hospital waits suck. So yeah.
Take care of yourself though. Get off the foot. Ice it.
Yeah, don't suffer for this. I know we're hilarious, but we're not like, we're not worth it.
All right. Let's swoop to Boone. So last time we talked Sarah Boone, the topic came up of her intention to use battered spouse syndrome defense.
Yeah.
And one of the topics, one of the issues we talked about is it's still the same 5 pillars of self-defense. We talked it through and reviewed the case law on it. Talked about how it really is an act of self-defense. You have to say that you did the act. So Ian and I had a bit of a disagreement, although Ian kind of saw where I was coming from on this one.
I mean, it is theoretically possible to run the alternative defense of I didn't do it, but if I did, it was self-defense. I don't think Sarah Boone has that available.
No, and I don't think I honestly think under these facts, there's no way.
I don't think you could easily do it on a battered spouse defense either. Where that comes up, I think, is going to be something like somebody got attacked in an alleyway or something. Somebody says they got stabbed in an alleyway. That might be possible. Or like, were you caught on video in this fight? That kind of thing. I don't think it's at all possible on Boone's argument, because she needs to actually, to do battered spouse, you need to say why it happened, right? Not just that it happened. You need to provide a whole history. And I mean, I guess they could try to get her history of abuse in through like a psychiatrist, but it'll be given very little weight if she doesn't testify. So, and the thing is her testimony is going to be awful. It's going to sink her, but she doesn't have any other choice.
It was definitely you did the action, right? You can't have engaged in something that you are saying was an act of self-defense. Like, I am saying I did this because I was acting in self-defense without acknowledging I did this. So yeah, she has to acknowledge it. Now, I don't know if that means that she has to testify to it. So let's see what was discussed at this motion.
The thing is it goes, like, for battered spouse, it goes beyond just self-defense, right? Because you have to explain a state of mind. You have to explain an ongoing history. Yep. There's so much more stuff.
Why you perceive the threat to be imminent in nature, even though it had been ongoing, or the last incident might have been weeks ago.
Yep. How you perceive there was no way to escape, even though the person might have been, might have been locked in a suitcase, right? Because what you might say is, okay, this guy's abusive, but you've got him in a suitcase, call the cops, right? And then, he's not a danger to you while he's in the suitcase. Flee and call the cops and say, you got to go unzip this guy, and not in the way that he likes.
That was said. Okay. You got it.
I'm sorry. It's just my brain.
No apologies necessary. There were decisions made. Let's see. All right. So Judge Kranick, there's a motions hearing. It's an hour and 49 minutes. We're going to see, I'm probably going to crank it up to probably 1.5 speed. I'm going to go ahead and put the audio or the quality at 480. So hopefully we don't get too many spinning wheels.
Can I just say, I love this judge.
I do too. The temperament's awesome. I'm a big fan.
He's been so patient with her shit without like giving her, like, he's been patient without like letting her run the show.
Moving the case along to the extent he can.
Yep.
Not
just like
disregarding her motions, actually giving her the time to argue her motions, giving it thoughtful consideration, not scolding the letters being written and everything else, like letting her.
Yeah, he's like, you are here as a self-represented person. You're going to have every chance to make your arguments, and sure, they might suck, but you get the chance to make them. And I'm like, good on you, son.
I'm a fan. I'm absolutely a fan.
Yeah, I think this judge, judges can't take tips, but if they could, I'd be like, all right, I'm just gonna leave a 20 here under this plate.
Yeah, see, that would get me in a whole lot of ethical problems. Just judge, here's a tip. It didn't really work that way. So let's see. Let's catch up on this hearing.
I did watch a lawyer at one point say, "Judge, I have a tip for you." He wasn't referring to cash, and he probably would have done better if it was literal cash, because the judge had some notions about being told how to do his job.
If I'm a judge, I'm going to put a literal suggestion box in front of my bench.
This was a guy saying, "Judge, I have a tip for you," and the judge was like, "Oh, really?" It was the most hilarious thing, but yeah.
All right, let's see how this hearing goes.
Do you want me at the podium? However you feel most comfortable, sir. But because we have your co-counsel appearing virtually, I would ask that you direct any argument into the microphone so that they might be able to hear it, sir.
Judge, as you know, I filed on behalf of Sarah Boone this motion for statement of particulars. And in my motion, I quoted the language in the information that she was charged with. And the pertinent part charges Sarah Boone on the 23rd day of February of 2020 in said county, Orange County, violated statute 782.04, paragraph 2, by an act eminently dangerous to another and evincing a depraved mind regardless of human life did kill George Torres. Judge, that's about as bare bones of an information as you can file in a case. I know anytime there is a weapon used, it's usually shot with a firearm that was used, that type of language, that is as bare bones. It doesn't even spell out all the essential language of the jury instruction, which I followed. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, the victim is dead. 2, the death was caused by the criminal act of the defendant. Now, there is no language in the information that alleges what criminal act Sarah Boone committed that caused the death of the victim, Mr. Torres.
Lock
This
him
is
in
a
a
unique case,
suitcase.
Judge. It does not involve a firearm,
Yeah.
which I believe many of these cases do. I'm sure you're well aware, the state's well aware, the defense is well aware of the report, the videotapes in this case, and the overall general facts about the suitcase and Mr. Torres being in the suitcase asking to be let out by Ms. Boone. But the state, in their charging document, has failed to say exactly what it is that they believe is the criminal act that caused the death by Sarah Boone. Some information that the defense could receive from them so that we could properly prepare a defense for Ms. Boone. In count 3, the unlawful killing of the victim was an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. It goes on to define an act as a series of related actions arising from or performed pursuant to a single design or purpose. We have no information, no particulars in the information that explains a series of related actions arising from and performed pursuant to a single design or purpose. None of that language is in the information that would let us know what it is they're claiming that she did or series of acts that she committed that constituted the cause of the death of Mr. Torres. The definition goes on to explain that an act is eminently dangerous to another or demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. What is the act or series of acts that an ordinary person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury? 2, is done with ill will, hatred, spite, or evil intent. What acts or actions by the defendant did they present or will they intend on presenting in the trial that would tend to indicate that she had ill will, hatred, spite, or evil intent towards Mr. Torres? And 3, is of such a nature that the act itself indicates an indifference to human life. Again, some explanation that give the defense, my understanding of the rule of criminal procedure, the defendant has a right to know the charges against them with specificity. Upon request, the state must provide specificity and clarification on the details of the alleged offense in order to minimize surprise at trial and ensure that the defendant's rights are protected. The rule requires that the information
I don't think he's wrong, but I
shall
hate
be
it.
plain, concise, and definite written statement of the essential facts constituting the offense charged. In this case, based on the bare bones information that has been filed in this case, it fails to inform the defendant and the defense counsel of the particulars sufficiently to enable the defendant to prepare a defense. Thank you.
Response.
It's not bad.
Yep.
Judge, the state stands by its written response that was filed on September 5th of this year. In addition to that authority that is cited therein, the state would also cite State versus Pajon, Pajon, 374 Southern 2nd, 1070, Florida 3rd DCA, 1979, and Sutherland versus State, 305 Southern 3rd, 776, Florida 1st DCA, 2020.
Can I have the second citation again? 305 Southern 2nd.
Southern 3rd, 776. And what all these authorities stand for, dating back to well before there were any discovery rules crafted in, I think, 1968, is the position that it's an extraordinary remedy to be given a statement of particulars in a case. The information in this case tracks the statute. That is what is required. There is nothing confusing about it. There aren't multiple allegations of second-degree murder on the same day, leaving her confused as to what we are talking about. There is no exposure to double jeopardy. There's no element of surprise. The state of Florida has provided discovery to the defendants in 2020. The state waived any opinion work product arguments that it had under Williams versus State in going ahead and providing the defendant exactly which exhibits we're going to enter in at trial, exactly which of the witnesses we've disclosed will be called at trial. And their motion does not set forth why it is specifically that they don't understand what she is accused of doing and how. In fact, opposing counsel cited the videotapes, the videos that were taken on her phone while the decedent was in the suitcase begging to be left out. And then what they didn't mention is what she said during these videotapes, which certainly would constitute the mens rea for second-degree murder. So it's our position that they have not stated why it is that a statement of particulars is necessary. It's an extraordinary remedy. They have all the discovery. Not only do they have all the discovery, they have the narrowed down list specifically as to what will be introduced. And they are clearly on notice of what constitutes the acts and the mens rea, because they have mentioned those videos that were taken on her phone. So it's our position that this is not one of those extraordinary cases that necessitates a statement of particulars. There are cases
Defense
where,
lawyer
for
here,
example,
just-
somebody
just
commits
tell them
multiple
why.
acts of battery against a victim, perhaps an hour apart, 2 hours apart, and comes back, and it's unclear as
wait.
to what the state is talking about. If
Hang on. Watch this. Check this out. I hadn't pulled this up in a long time, or I hadn't actually pulled this up. I hadn't pulled the criminal complaint up. You want me to show you the criminal complaint? Yes, of course you did. That was a rhetorical question.
I was going to
This
say,
is a
what would you
criminal
say if I said no?
This is the criminal complaint, right? So here's a complaint that was filed. Okay, so it looks kind of bare bones right here, right? So kind of bare bones, second-degree murder. We're going, maybe there's an argument, but there's got to be some form of narrative, right, for the charge. There's the narrative.
Now, Rob, it's very unfair of you to assume that this lawyer can read.
This is a lot. Holy crap. When he was arguing about a statement of particulars, I was going, yeah, if they haven't pled anything other than she somehow ended the life of this individual, then maybe. But to say that they don't have notice of what it is they're charging, this is a novel.
What he's hoping is that they get the statement of particulars, and then the jury ends up with like, well, we do think that that she killed him, but in a slightly different way, so we got to acquit.
Paul, my brain is with you too. I need paragraphs. What is wrong with paragraphs? Why? Yeah. Look at this. It talks about the hide and seek. It talks about the zipping the suitcase up, the zipper in there. It talks about the interviews. It talks about the consumption of alcohol, the cell phone. It talks about all of it, every part of it.
In like a giant block of undifferentiated text. My favorite kind.
Yeah, he's like, doesn't describe what the criminal act is. Or Jorge or Torres, Mr. Torres is dead, and his death is caused by Sarah Boone's criminal act. Well, what's the criminal act? Oh, here it is. She zipped him in a suitcase, therefore proves the unlawful killing of George by Sarah's actions that were imminently dangerous and demonstrated depraved mind without regard to George's life. Or his life. I would say that zipping someone in a suitcase and leaving them abandoned is demonstrative of a disregard for human life.
Oh, come on, Rob.
That's just me.
What's a little suitcase suitcasing between friends?
So.
Oh, wait, that's not something you do with friends.
No, you don't.
1, 2, and 3, I'll say battery on X day. There are informations and indictments that span years that don't get statements of particulars articulated to the defense. In this case, the date is specific as to February 23rd, 2020. The metadata on the 2 videos that were taken from her phone are both from the 11 p.m. hour of February 23rd, 2020. given all the discovery in the case and the amount of narrowing down that we've already done, there is no need for a statement of particulars in this case. Thank you.
Thank you. Any response?
My understanding of the law is the court has broad discretion on this issue about whether to require the state attorney's office to give more particulars about the offense. And this is somewhat of a unique case. And the state attorney just mentioned where there was prior incidences of violence or battery that occurred prior maybe to the death and whether or not that was relevant or admissible. That's the case we have here. Judge, I'm sure you're aware that Mr. Torres suffered from some blunt force trauma that was unrelated to the death. The medical examiner who did the autopsy took photographs and described that there was blunt force trauma on Mr. Torres's body.
What? Why? I'm now confused.
That did not cause the death, that was unrelated to the cause of death. And that information has not been detailed whether or not it's relevant to his death, whether or not they're going to try to tie that in to Mr. Torres's death. And if not, if we're relying on the
I have 9 million.
medical examiner's explanation of the cause of death, which was asphyxiation, suffocation, then there's a question about whether that information
Is there anything that's missing under the statute? I understand your reliance on the jury instructions, but what's your response to Mr. J's position that it tracks the language of the statute wholly and completely, which it seems to?
I have the rule for motion of particulars then. If that's the case, then in every case in the country, you just have to track the statute. And at no time a court would ever order a motion for statement of particulars.
But the date's there, the time's there, where it happened is there, the underlying charge is there.
I
What's
understand.
missing?
And I explained that this is not a shooting where death would occur fairly quickly after multiple shots, that this was an unusual death, asphyxiation over a period of time, which we don't even know whether it was the day before or the next day. There's questions about that. The injuries, the blunt force trauma that the medical examiner is claiming that they're there, I believe is going to testify that.
Are you claiming that he himself got himself out of the suitcase after being zipped into the suitcase by Sarah Boone and then zipped himself back in the suitcase and there was some intervening cause?
I mean, to be fair, if that is what happened, then I'm just chalking this one up to death by misadventure, which
Yeah,
usually
that
means
sounds-
you were too stupid to live.
Yeah.
Oh,
Could have been there 24 to 36 hours before. We don't know when those prior injuries were. They're fairly fresh, but they can't state that they were close to the time of death. Again, they weren't related to the cause of death. So there are situations in the law based on the unique set of facts that a court feels compelled. Yeah, I have the discretion and I feel like for the defense to properly prepare for this case due to this unique set of facts that I think there are some details that you must give. There's blunt force trauma. We don't know exactly when it was. We know it was fairly recent. And the medical examiner says the cause of death is asphyxiation. He doesn't know where it was environmental or not. He gives two explanations. So there's a real question about that. And of course, we'd like to know what theory they're going under and whether or not they're intending to introduce evidence of this blunt force trauma that occurred sometime prior and what exactly they're claiming that she did.
can I just say this calls for a beer, but not a good
2-minute
beer?
video that everybody's seen, the suitcase video. Is it that?
This is-
Because there was a lot that occurred prior to the video. There was a lot that occurred after the video that's not on the video. So is that what they're referring to in this narrow window of just tracking the statute? And I go back to there wouldn't be this rule in the criminal procedure if there wasn't a time when a statement of particulars was necessary. Thank you.
All right, thank you, sir. The court has reviewed the motion, reviewed the authorities provided, including the additional authorities, State v. Pajan, 374 Southern 2nd, 1070, and Sutherland v. State, 305 Southern 3rd, 776. And relying on State versus Peel, if the indictment is sufficiently full in its allegations of fact constituting the crime charged to enable a person to plead to it, the greater part of the reason for allowing particulars does not exist. The application was not so much for a bill of particulars as for a detailed statement of the evidence by which the state proposed to prove its case. If the defendant was advised of the nature and the cause of the accusation against him and had notice of the dates on which the acts constituting the offense were committed, there was no necessity for the bill of particulars. All this information was given in the indictment. And that is at 154 Southern 2nd, pinpoint 912. It sounds
He's like,
like,
"Are
based
you
on your
done?"
argument, you're looking for the particular evidence as to the cause of death and the meaning of the death, which based on Peel is not something that falls under the ambit of a motion for particulars. So reliance on State v. Peel, understanding the age of this case as well, understanding there have been multiple lawyers who have filed responses denying the charges in their notices of appearance, your motion is denied, looking at the totality of the circumstances.
I just
All
want
right,
to say
question-
this is not a good beer, but man, was that refreshing.
Good. A question came up in the chat. It says, when would a bill of particulars be appropriate, or when would particulars be appropriate? Let me give you an example. So in family law cases, we have protective orders that get entered all the time, right? And there's a criminal charge for a violation of a protective order. And what you do is you end up seeing that charge is there. Sometimes the charge will be made that the protective order was violated, and it will give a day, right? It'll just give a day of when the protective order is violated. Well, we'll walk in with a client and say, well, Judge, that's a whole 24-hour period of time that you're talking about, a simple act that can be as simple as a phone call or a text message or an inadvertent wave or something to that effect. That doesn't put my client on notice sufficient that would allow them to plead to that charge. He doesn't know what they're saying constituted a violation of the protective order. What part of the protective order was violated? Was it the no contact, or was it the be 500 feet away? And how was it violated? Under that circumstance, there's a certain amount of specificity that's required to allow my client to know whether he has to plead guilty or not guilty. So a judge would say, I'm going to order a bill of particulars. State, you have to allege with some degree of specificity that enables the defendant to answer the charge. That's when a bill of particulars might be granted.
Or like, let's say there's a home invasion murder, and there's like a drug house and 4 guys in masks go in and kill several people in there. You might be like, which of these masked dudes are you saying is my client? I can't defend this until you tell me which person you think doing these things is my guy. I see that you've got him charged with several murders, but is this that you're saying that he was the guy who's the lookout? Or are you saying that he's the guy who's actually there with the shotgun? Like, which guy, please? Yeah, it's I sometimes do them here in Canada because they will file charges that say on or about the 20th day of September 2024 did have in his possession a firearm or a non-restricted, restricted, or prohibited firearm or prohibited device or restricted weapon or prohibited weapon, and did offer it for sale, store, transport, mail order. And it's like, which of these things? You're actually describing 60 different crimes here if we apply each to the other. And I need to know which you're saying my client did.
Yep, exactly. So not this case, though. Let's see.
Yeah,
what's
this
next
one, it
motion.
seems pretty obvious.
So right now she's 0 for 1. Let's see where she goes next.
Moving now to, a moment. And I think we could probably address these collectively. The defense's motion for additional discovery filed September 2, and the defense's second motion for additional discovery filed September 6th. Similar to the first motion, the court has reviewed all the authorities and those motions. Mr. Owens, you may proceed, sir.
Can I approach the bench?
Yes.
He's like, sure, it's not going to help, but go for it.
Thanks, sir.
Judge, we're going to handle these both collectively, and I believe we should. The first motion for additional discovery was filed on September the 2nd at 8:30, and then the second motion for additional discovery was filed on September the 6th. The first motion refers to the rule 3.220F for additional discovery. On a showing of materiality, the court may require such other discovery to the parties as justice may require. Specifically, the defense is requesting the Office of the State Attorney to provide a written policy of the Orange County Sheriff's Office relating to in-house interrogation procedures, in particular the policy in place at the time of the interrogation of the defendant at the Orange County Sheriff's Office, which was back in February of 2020. And then the second motion for additional discovery, specifically, the defense requests the Office of the State Attorney to provide the standardized Miranda rights written policy, the form, and the card of the Orange County Sheriff's Office relating to Miranda rights form utilized
they want to
directly
toss
to
their
any suspect
confession.
before the interrogation.
Interesting.
The argument by the state is well taken.
That's
The
an
defense
interesting
does have a duty
line.
to try to gather the information independently of the state attorney's office. And we did make a request to the Orange County Sheriff's Department back on September the 10th. And the request was for the written policies and procedures of the Orange County Sheriff's Office relating to the in-house interrogation procedures, in particular the policies and procedures in place in February of 2020. And the written policies number 2 and procedures of the Orange County Sheriff's regarding Miranda rights, written policy, the form and the card relating to Miranda rights utilized and read directly to the suspect before the interrogation in effect in February 2020. So as you know, Judge, I don't know if you've actually watched the 2-hour interrogation, but the day after this event, she was asked to come down to the Orange County Sheriff's Office under what my client believed was something other than an interrogation. When she got there, she was directed into a room. And I don't know, like you said, you haven't had a chance, but there are some serious issues about whether or not that was coerced, whether or not Miranda rights were fully read. I do not believe they were. I believe some of the statements that the lead detective said before she started the Miranda rights are coercive. She was in a room where she could not leave with 2 homicide detectives. One was wearing a firearm, and she acquiesced to authority based on an improper reading of Miranda. I wanted to file motions to that effect. We've got trial coming up October the 7th. I wanted to wait to get those policies. I wanted to wait to get the Miranda rights forms. The homicide detective actually reads it from a card. And I believe she read it incorrectly, and she left out the main question at the end.
I don't hate this
So
argument.
the proper thing to do is to get that information and make sure it's verified before you file in good faith a motion to suppress her statements. Well, the state attorney has tremendous power. I've made this request, what was it, September the 10th. Now it's, the 19th. And I'm in line with other public records requests there at the Orange County Sheriff's Department as to when I get this information. The state attorney could have gotten it the very next day if they would have made that request. That's why I filed the specific motion for the additional evidence. Time was of the essence. The court denied my motion on September 3rd to continue the case. We've got about 18 or 19 days left for trial. I'm still waiting. I've still got to receive that information. I've got to file the motion. I've got to set it for a hearing. I've got to subpoena the 2 detectives, the 2 homicide detectives. We've got to have a hearing with 18, 19 days left. I'm still waiting on this information from the sheriff. I've made a good faith attempt. Time is ticking. The state could get that information to me tomorrow. Thank you.
Response.
I don't hate I don't hate that.
I feel like the prosecutor's going to come in with brimstone. I don't know that what he's reciting seems like.
I mean, he might come in and say that's all bullshit and that never happened.
And that's what I'm wondering if he's going to come in and say. I'm just looking at his motion. Second motion. So it was filed September 6th. Second motion for additional discovery. Specifically, the defense requests the Office of the State Attorney to provide the standardized Miranda rights written policy form and card of the Orange County Sheriff's Office related to the Miranda rights form utilized and read directly to any suspect before interrogation. Let's see. The state responds. And the state's response.
I mean, it could be that they say something like, "We already gave it to you, you idiot."
It's similar. It's similar. It's not that we already gave it to you, you idiot. It's that there's an easier way of doing it.
Your Honor, it's not Mr. Owens who's on trial, it's Sarah Boone. Sarah Boone was interviewed by the Orange County Sheriff's Office on February 24th and 25th of 2020. Now, some 4 years and 7 months later, there's this exigency not created by us, created by them. It's the defendant who has not done this for 4 years and 7 months. Now, turning to the merits of this, they are asking for discovery from a third party. Any discovery request, whether it is of the state or of a third party, has to involve allegations that this information is reasonably calculated to lead to admissible evidence or be pertinent to some analysis in this case. They have not stated why in their motion, and the arguments in court today do
Can you not figure
state
that
why
out?
it's pertinent either.
Maybe you're just bad
The
at
case
your
law
job.
does not say statements are inadmissible or only used for impeachment if the law enforcement officer violates policy. There's no case law that says statements are inadmissible or only used for impeachment purposes if
Yeah, but it is
they
relevant.
don't read from their Miranda card properly. What the case law states is statements are inadmissible if there are Miranda violations and only used for impeachment, or if statements are involuntary.
So he's not trying to
Basically through promises, then they can't be used for any reason.
This one I'm feeling like
I'm
the
getting
prosecutor is
frustrated.
being a little shitty, because the thing is, it does matter if they're violating a policy, right? It does matter if they have a card for what they're supposed to read, and like, because if you're assessing the seriousness of a violation, it matters whether they had like directions as to how to do it right. Like, this is relevant, my dude.
Yeah, but not. This is a different motion. What usually what you get this in is you get a motion to suppress, right? That's usually where this comes. You're talking about the actual the interrogation.
Yeah, but he's
statements,
saying I want
statements.
this for a motion to suppress.
He
later.
is. I don't know. I'm confused as to how the argument's being made, and I don't really like the response being given by the prosecutor of just, look, I get the whole it's been 4 years. Why is this coming up now? But
yeah, and it's
you have to
obvious
think
why. It's because
you know-
Sarah Boone sucks, and now she's got a lawyer who's like trying to, run his case.
And even this is the part that kind of pisses me off right now about the prosecutor. How hard is it to get?
Yeah, he's
How
just
hard is
throwing
it?
shit, right? That's the thing, is he's not running this is not difficult for him. It's not anything. He's just being obstructionist, and I hate that in a prosecutor, because we're supposed to get justice. Like, really, the prosecutor here should be like, yeah, I'll have that to you by tomorrow, because I think it's stupid that you want it, but okay, we'll do it. Just give it to him. It would actually be easier to give it to him than to stand up here and oppose it.
And
I see somebody
saying he can't file the motion unless he has the info. Yes, you do. You have the relevant case law. The case law is Miranda.
I also
you
see
believe
somebody
that-
saying Google it. The thing is you can't tender as evidence I did a
can't.
fucking Google search.
Yeah.
He
So
needs it-
it's
Yeah.
but he doesn't need it for the motion to suppress. He does not need it because the motion to suppress would be based on law, not policy. Policy doesn't do anything for the motion to suppress.
It can be relevant on, like, was it a mistake or was it that they violated a policy? Just fucking give it to him, man.
Yeah, let's see. I think it's.
But nowhere in this analysis does it matter to any degree what a standard issued Miranda rights card looks like, or what
Then
their
give it to
policy
them.
is on interviewing. What they do have, and what the defendant has had since February or April or whenever discovery went out in 2020, was a videotape of these interviews. There has been absolutely nothing stopping anybody from filing a motion to suppress if they believed under the case law relief could be granted under the law. And the law does not have any analysis regarding standardized issued Miranda cards or policies of law enforcement agencies. And I don't believe that's admissible at trial either. If they did not violate the Constitution of the state of Florida or the United States in compelling an involuntary statement or by violating the dictates of Miranda versus Arizona, then questions about whether they read from their right standard card or if they violated policy should not be admitted in trial, because it does not help the jury understand whether or not an element of the crime has been proven. It's not a part of the lengthy jury instruction now that we give about defendants' statements. There's nothing in there about, well, did they violate their Miranda card? Did they violate their policy? So first
Okay,
of all, the state's
Professor
position is they have
Baldspot, but would
not
it kill you to
asserted
just
materiality
hand it
needed
over?
to get discovery ordered by this court, which would be reasonably calculated to lead to admissible evidence.
The thing is, they're 5 miles ahead of this argument. The argument, like, they're arguing 3 motions ahead right now, and it's like, can you get back to what you're asking for? Like, I need to know why. God, this.
Or to lead to it being found inadmissible by the court. And then secondly, it's on them to conduct this discovery, and coming in and saying that I can snap my fingers or not snap my fingers and get it for them instantly isn't evidence either. So it's our position that their request should be denied, primarily because it's immaterial, and then secondarily because it's on them. She's been aware of these statements since February 24th and February 25th of 2020. Thank you.
Thank you. Response to the materiality, please.
Judge, I believe the prosecutor is wrong. One of the jury instructions, standard jury instruction in criminal cases said that essentially a statement has been placed before you that's made by the defendant. And I don't have the language here, but it should be weighed with great care and caution to make sure it was freely and voluntarily made. These are some, but not all of the circumstances that you should consider in deciding whether or not the statement that was made by the defendant was freely and voluntarily made. If you decide that it was not freely and voluntarily made, that evidence should not be considered by you in this cause. So even if we filed the motion, we got the information, the additional discovery that we need in good faith for me to file it, if we received the information, I typed up the motion, we had a hearing, the two detectives testified, and the court ruled that the statements were not suppressible, I could still bring those facts into the trial of how the mistakes that were made by this lead detective in the coercive statements that she made, as well as not giving the full Miranda rights form and getting a full consent from my client, that goes into evidence for the jury to decide whether or not to consider the statement at all. Thank you.
So where's the violation of the Constitution then? Assuming you're correct and assuming that the Miranda card, something was missing, what's the issue?
It's coercive. The statements that the lead detective, the female detective makes, there's 2 or 3 statements she makes.
Now you have to understand, I'm in a vacuum here because I haven't watched the video. I'm not asking you to play it.
I probably should have.
But I need a little bit more context as to these statements because I have unfortunately no frame of reference.
But she says that, number one, the date of this event, they seized her phone at the scene. She was told that they were going to bring her phone back to her.
That's not an answer.
He's doing his best.
It was a question the judge asked, and he did a
There's
whole
an answer.
So let me take you back to the day that no, there was a question.
And then I
It was
tied an onion to my
incorrect.
belt, as was the fashion at the time.
So, Judge, there's this phone. And you're like, no, the judge asked you directly, what was coercive?
Her back at her apartment the very next afternoon. The female detective called her, or Sarah called the female detective about the phone. The female detective said, I'm pregnant. I'm not feeling well. I don't want to drive out there to give you your phone. Would you please come to the sheriff's department so that we can give you your phone? Sarah Boone got there and saw that there was a desk or a place there to retrieve the items. And she saw the male detective and said, is this where I go to get the phone? He said, no. We got it back here in this room. Come back here in this room and we'll get it. When they walk back in there is when the video turns on, and now they're in the interrogation room. She's got a list. Sarah Boone has a list of things that she was wanting to ask them. And the female detective says, look, we got the autopsy back from the medical examiner. We've got to talk to you about that. 2 times she said, we must, I don't think it's must, we've got to talk to you. She goes, okay. So I got to read you these Miranda rights again. And
Again,
she had read them. There was a statement that Sarah Boone gave. Of course, she gave a general statement to the first deputy that responded to the scene. She
The
was
judge
wearing a body
leapt
cam,
onto
so
that.
Oh,
deputy
no.
had called the 2 homicide detectives, but it took them a while to get there.
Oh,
so
no.
she asked Sarah Boone what had happened, and Sarah explained that
he's
situation. After the detectives got
He's
there,
toast.
they took a general statement from Sarah, but at some point they got into one of the squad cars. And I believe it was Sarah Boone. I believe it was the female detective and the male detective. And she was read Miranda rights, again, incorrectly, and she gave a statement. So now the next day, she's back in the interrogation
You're
room
done.
with the 2 deputies, the 2 detectives,
Yeah.
and the lead detective says, we've got to talk to you about this autopsy. Giving her the impression that's what they were going to talk about. But I've got to read you these Miranda rights. And she said something, and Sarah said, protocol? Because they had told her in the first Miranda rights that this is just protocol. We have to do this before we speak to you. And she said, yes, protocol. So based on those statements that we've got to talk, you have to talk to us. We've got the autopsy. Led Sarah to believe that they're going to talk about the autopsy. In addition, then she starts in the Miranda judge, she made a mistake on it. I don't know if it's an honest mistake, but in her probable cause statement, she said, I read the rights verbatim. The constitutional Miranda rights, I read to her verbatim. That is not true. Fortunately, we have it on audio. Fortunately, we have it on video. there is a legitimate question about whether that statement, that 2-hour interrogation, is admissible in this trial.
Why?
That's what I'm going to show the court. I'd like to
Why?
get their policy just to see.
What does the policy have to do if those statements were inadmissible?
Exactly.
Yeah, this is
Why?
where he's running into
What does the
trouble.
policy have?
He's fried
Yeah.
again. You only have to read Miranda once. You have to be advised of your rights once.
And the thing is, he is saying that they did it wrong both times. But I think you could
Policy-
say, like, the policy goes to maybe this was intentional. That's a question for the jury. The jury can determine if this was something that was done on purpose in order to deceive or, or prevent the Miranda rights from being effective.
Let me tell you why the officer would use the word verbatim, because I'm currently reading the policy because it's publicly available information. I'm on the sheriff's office. I'm on their website for the sheriff's department, and I'm reading it. And the where is it? The deputy shall read the exact wording.
card. Yeah.
Yeah. Yeah.
And the reason why
I'm-
it says that is that sometimes people get creative.
Yeah. I'm reading the policy right now. But the policy doesn't mean
Anything to do with that analysis?
To see if they,
Because if you're saying you have a deposition, I'm assuming it's a deposition of the female detective. Said I read it verbatim, and you're telling.
that's the in the probable cause statement.
okay, it's in the PC affidavit. But do you think the PC affidavit is
Also, I love this.
Yep, that's true.
Because the initial messages on Nightbot are pretty aggressive. So, yeah.
So here's one of the points. So she was read Miranda both times. I understand that. You only have to read it. Like, the policy might tell you to read it every single time you interrogate a witness. The policy might tell you that, but that they were to read it the second time when Miranda's been read already. First of all,
Yeah, it depends on whether they're like, it isn't that you've been Mirandized once and they can just, this is a second interview, so they should have read it to her again.
policy does not make it. And when the prosecutor is saying, I don't want him getting up and saying policy, and I'm with the prosecutor on that one. I think that's misleading to the jury. You want to bring a motion to suppress, bring a motion to suppress. So,
Well, I think he's also entitled to argue to the jury that the confession isn't worth anything.
but it's not even, you're not even looking for a confession. You're looking for the inconsistent statements. Saying those were drug out of her. I
think she's sunk, but I think she should have a fair
Wait,
trial before she
hang on.
drowns.
Is this the contention? We're focused on this. Do you understand these rights?
It's an important question.
It is, but the answer to that question doesn't have to be given.
Thing is, if somebody does say no,
Statement.
Okay, that it was read. It was read verbatim. Okay,
Yes,
excuse me.
formulated the arrest report. It was a supplemental report or either the actual probable cause report.
And the representation in there is it was read verbatim.
That's correct.
Now, you've reviewed that interrogation. It's your position that it was not read verbatim. What does the policy have anything to do with that issue?
I think
That's a simple constitutional issue, right?
yes.
If there's a case law that buttresses that position, and that de facto is a violation of the Constitution, ergo, that confession or statements are not admissible because of the violation of the Constitution. What does the policy or the Miranda card have anything to do with anything if you have the video and the audio?
Well, the Miranda card is going to show that she actually omitted the last question. Okay.
What is that?
So the Miranda card is there for a reason. I don't know if they have them in
Yeah,
the
the
interrogation
judge is
room
not
or
with 'em.
every deputy
Nope,
or
you're done.
homicide detective is issued that card, but it's a small card. But I believe it's going to say on there that you've got to get the waiver. There's two questions at the end, which is, did you understand the rights that I've just read to you? And the next question, understanding these rights, do you agree to speak with us now? That question was not read. It was omitted. I don't know why. She's sitting there reading it, and
Does the fact that that question was not read impact constitutionally under case law the admissibility of those statements?
I believe so.
No, if you say I believe so, you're out of your damn mind. It does not. Under existing case law. No, not at all. Your decision to continue talking.
Hey, I mean, him and his client have a whole bunch in common there.
I can't believe he's about to say I believe so.
So along
doesn't
with
answer my
Both
question.
him and his
Respectfully, that
client
doesn't
should
answer
have
my
stopped
question.
talking a long time ago.
I understand what your belief is, but where's the case law that you can provide to the court?
I'm not ready for that, Judge.
Okay.
I'm going to file a motion to suppress, and I'll supply you with the case law, but I'm not ready for that. But the reason I
Oh, yeah,
wanted the
that's fine.
policy, getting back to
Wait,
your first question.
then what the fuck
is
are you
because I'm
doing
sure
here
the policy
today?
is going to say,
That's my point. That's what I'm saying. You're arguing 3 motions ahead. Why are we here?
Like, you're here to argue this issue and saying, I'm not ready for that today. It's like, then what the fuck are we doing here, buddy? Like, did you think this was your birthday party? Or, like, we're here to argue some law here, son?
you don't make any pre-Miranda statements.
is your
like,
motion.
We've got to talk about this autopsy. Those type statements are improper. That they're used to coerce somebody to talk. And I understand the detective. They had these videos, the 2-minute video and the short second video, and they had found it on her phone. So the homicide detective was chewing at the bit to get her to talk. So she was trying to induce or influence her to speak to them and to not exercise a fundamental right, not to speak to them without a lawyer being present. So she made those 2 statements preliminarily that I believe the policy is going to say you don't do.
This is a joke.
Okay.
It's
Mr.
joke,
J, anything else,
right?
sir?
Just the Orange County Sheriff's Office doesn't set the policy for what is admissible evidence in the court. The United States Supreme Court does, the Florida Supreme Court does, the 6 DCA courts do, and then ultimately, following their guidance, you will decide whether or not a statement is admissible in the state's case in chief or if it's only available for impeachment. But whether or not, let's say hypothetically, she read the Miranda card 100% accurately, she followed policy 100% accurately, the state of Florida can't come in and say, Judge, I know they violated U.S. Supreme Court case law, but they followed the sheriff's office's policy. So these statements are clear.
The thing is if that was the case, he
contrast
would
is exactly the
absolutely
same.
be making that
Whether or
argument.
not they followed policy or read the Miranda card accurately has nothing to do with the analysis as to whether these statements are going to be admissible.
Okay, now that pissed
or
me
only
off because
admissible
he
for
would
impeachment.
absolutely make that
And I
argument.
don't believe that under the case law, they can come in if those statements are admissible and argue to the jury. They violated policy. They didn't review, they didn't read everything on their card. They violated. How does that help the jury decide whether or not the statement's voluntary? It doesn't matter what the policy is. It doesn't matter what the card is. What matters is whether or not they say.
Because I can already
the
think of
words
how
that are
I'd write this
required by
cross.
the United States Supreme Court or the Florida Supreme Court or the 6 DCAs.
Yeah, but
That's
I'm
what
not being
matters.
policy.
That is what determines the bar for the admissibility in the case in chief or impeachment.
Okay, thank you. All right, thank you both for your arguments and your positions. In reviewing the authority provided by the state, which the defense has conceded is taken is what it is. I think state versus right is the guiding light for the court here. 803 Southern 2nd 379. In reviewing that analysis, the defense has put forth an effort to do so. It's not up to the state to prove up anything for the defense. At this point in time, both motions for additional discovery are denied in accordance with state v. right. Moving now to
Hang on.
the
Psychologist.
defense's motion to appoint forensic psychologist filed
Right.
September 2, and defense's motion to appoint crime scene reconstructionist and notice of intent to rely on the defense of battered spouse syndrome.
Oh, here
The
we go.
original writing, what the court file reflects, was a order entered back on August 3, 2020, appointing Mr. Sawicki as a forensic specialist. I have no idea if that order is still viable, but I'm just providing what the court file reflects in that regard. Lastly, that takes us to the notice of intent to rely on the defense of battered spouse syndrome. The original notice was filed September 6th. The state's original motion to strike was filed September 9.
Just to interrupt, I also have this defendant's motion for enlargement of time to address as well.
Yeah, I have that on my list, sir.
Okay.
Thank you. Thereafter, on the 15th, an amended notice of intent to rely on the defense of battered spouse syndrome was filed. On September 13th, the defense's response to the state's motion to strike defendant's notice of intent to rely on the defense of battered spouse syndrome was filed. And then I think it was this afternoon. Earlier today, the state's motion to strike defendant's amended notice of intent to rely on the defense of battered spouse syndrome was filed. The court has reviewed all of those and all of the citations contained therein. Mr.
So on the forensic psychiatrist or psychologist, the motion was granted. The appointment is granted. Dr. Brennan is appointed. Motion for cost, that motion was granted.
Owens, you may proceed, sir.
Judge, I wanted to
The motion to appoint crime scene investigator was granted. Let me pull out this.
start my argument, and then Mr. Henderson, who is on the screen, is going to respond to the state's pleading that they filed this afternoon.
Mr. J, you have any problem with that?
I know there's a rule in the circuit about one witness per one attorney. I don't know what the administrative rule says about arguments.
Oh, come on. Just
Okay.
say I
He's-
don't give a
he's
shit.
arguing That one motion that they filed this afternoon, that I've been working on these. He was working on that motion, so it's a separate motion.
The motion to strike.
The last motion whatever motion they filed today, Mr. Henderson, Tony Henderson here in the screen wants to respond to that. I'm going to respond to the ones that were filed prior to today.
All right, I'll allow it. All right, go ahead, sir.
Judge, as you know,
Hang on. I'm going to try and switch.
I filed my notice of appearance.
That was some
on August
douchebaggery
30th.
by that
I'm
prosecutor.
going to try and switch the stream. So that, because I downloaded it, maybe I can make the spinny wheel go away by switching the stream to this one. So
Am I
let's
wrong about
see.
that? That prosecutor's being a
What?
douche?
About not letting the two lawyers argue it, both of them.
Yeah.
That's a dick move. It's a legal argument. Let them argue. It's not.
Yeah,
it's
it's like-
not two lawyers for one witness. That's not what it is. It's just let them argue it. I don't see a problem with it.
Yeah, he's just trying to throw shit at the other side.
And
it's
it was
like,
done in a
that's-
it's done in like a condescending little backslap way. It's stupid.
Yeah, I don't like that at all.
So
It gets me to, if I was a judge, I'd be like, seriously, is this the kind of game we're playing here?
yeah, it's Angel Baby 4210. Is it me or is the lawyer sound more like Sarah running the show? No, the lawyer's running the show. He's filing every motion he can. He's trying to be obstructionist and he's throwing stuff at a wall, see what sticks. That's the job of the defense counsel. I just think his arguments kind of fell apart pretty quick. And he's
doing his best.
and he prevailed on a bunch of them. He got the forensic psychologist. He got the crime scene reconstructionist. So he looks like the motion for enlargement of time was granted in part, denied in part. Granted is the filing objections to the state's evidence. Denied is the remaining portions of the motion. So he's got the payment of costs. So he's doing fine. It's just the ones that we would kind of consider the big ticket ones. Really,
And a lot of the big ticket ones are like your stretch goals, right?
Yeah,
It's like,
they're
okay, he wanted to raise 50,000 on Kickstarter to get this going, but he had a stretch goal of 100,000 and he hasn't reached the stretch goal. So would we call that a failure, or would we just say good on him for trying?
I want to hear the motion to return property thing too. So I'm gonna listen to this one. I think the motion to return property is a little bit later. But
What property does he want back?
I don't know. Oh, a couple other stuff.
Does she want her cell phone?
Yeah.
No, you're not getting your cell phone back.
Motion for return of property. The motion for return of property is yeah. She wants her cell phone.
For what?
She's saying that neither she nor the attorneys have had the opportunity to review the cell phone or to have it analyzed by an independent person or the defense team.
Okay, so that's a discovery request.
But you don't get the
Fine, as a discovery
Yeah.
request, yes,
You
I
don't
got
get
no
the
issue with
phone.
that. But like, otherwise it's like you're in jail. Are you wanting this phone for like Tinder, or like what are you gonna do with the phone? I don't understand this. So
No, your cell phone's evidence. Cell phone stays with the case. Cell phone is. I'm sorry. No, you can get a forensic image of the cell phone.
yeah,
Now
I got
let's
no
do
problem with that. Like if she
Right.
says, I need, or even just, I need the original phone released to a tech to look
Uh-huh.
at it and, you know, make his own image.
And you know
Okay,
what
cool.
an order's going to say? The tech can show up at the sheriff's department in the
Make an
evidence
image
locker,
and
make
then
the
leave
image, and
with-
then leave.
Yep. And the phone stays behind. I got no issue with that either. But, and I mean, yeah.
So,
What are you doing?
I don't know. Midnight L 2008. The vids ruined the battered spouse defense for me. If you are that afraid of him interfering for your safety, why would you mock him and risk him being angry and possibly violent when / if he gets out? It doesn't. It's not that ruins it.
That's going to be what ruins it for a jury. She just seems like she comes
It's-
off
it's-
like the Wicked Witch
her
of the
demeanor.
West in those.
Yeah, it's her demeanor. It's her. It's just her nature entirely. It's so the videos are given additional context by some of her interview statements, right? So the videos are bad, but if the videos were standing alone, if the videos were all you had and you had no other interview statements or nothing else, you had a psychiatrist come in and testify to all of the abuse that she'd been through, then yeah, the videos don't ruin it. But the videos viewed in context with the other interview statements that she makes and her other behaviors are pretty damning.
Oh yeah, she's.
So.
I mean, this is not a case I would want to defend.
So Lego Law Life and Libations, formerly known as MLS, is asking, so Rob can convince Runkle to join us for a Lego stream. I'm pretty sure that Ian would join happily.
I have to do it.
It's timing.
One of the big things is like I have to actually get off my ass and shop for Lego. Because like I can't do a Lego stream without like Lego. So I keep getting people saying I should make an Amazon wish list. Maybe I should.
I was in Target 2 days ago. The Legos they have, there's a lot of cool sets, dude. You need to get out there.
There's a Dungeons and Dragons set.
Yep.
And I kind of want to do that. Like that's kind of where I'm like, all right, that's what I want to do. The problem is getting off my ass and buying it. And getting all that together. So yeah.
So I imagine you reach out MLS, and if you need help reaching out, just let me know and I can put you guys in contact. And then Kate may be I'm grabbing the ones that are relevant to the discussion for here so that they're not losing context. How do you prove mens rea? It might be a silly question, but do we ever really know what's going on in someone's head? Saw the Carly Gregg verdict, and with Boone's defense, it got me thinking. So proving mens rea, no, you never really know what's going on in their head, but you have a pretty good idea based on the statements they make, the conduct they engage in, how they move about the house, how they move about the different things they're doing. I mean, you prove someone's consciousness by proving what they're doing on a given moment.
And a lot of mens rea is not that hard.
No.
Because there's, at least in Canada, I assume it's the same in the States. There's sort of a rule that you intend the ordinary consequences of your actions.
Yeah.
And so, like, and also the mens rea for things, a lot of people really misunderstand the necessary mens rea. So, like, let's say I'm accused of, like, stabbing Rob. You know, the mens rea isn't that I, like, expected Rob to die. It's just, like, did I actually intend to, like, do the motion with my hand, right? It's in some cases people can be surprised at like how little is required because it's just like a matter of okay, yeah, that's all that's needed. I feel like people really misunderstand mens rea a lot of the time.
Well, here's a good example. Let's say that we're at a Halloween party, right? And you have come dressed up as, you know, Mike Myers, and you've got the knife, but the knife is spring loaded. It's a fake plastic knife, right? But it looks really real. And you know, set it down, grab your beer, and someone else at the party, without any knowledge that you have, replaces it with the real knife. And you, in the process of grabbing your beer, you grab the thing that was replaced for your spring loaded knife with a real one, and you come up to me and you stab me. At that point in time, you have not formed the actual mens rea to commit an intentional act of harm on me. You haven't formed the intention to murder me. Because
Correct.
you subjectively, as would every other person in your position, would have believed that that knife could not have done the thing that it ended up doing. And it was only by the intervening act of placing this actual knife in the place of where the spring-loaded toy was, that was, the foreseeable consequence of that is likely that, yeah, the person that picks up the actual knife is going to stab somebody with it on accident, thinking it's spring-loaded. But you could not have formed the intent. So that's mens rea. That's lacking mens rea for a intentional homicide.
I'm just thinking of some other examples here. Like, let's say I really hate, Joe. And so I see Joe walking down the street. And so I'm like, fuck you, Joe. And I throw like a full can of beer at him. And it turns out it's not Joe. It's actually Rob. He borrowed Joe's hat and his coat. And I thought it was Joe. I'm still going to have the mens rea for that assault with a weapon, to wit can, because I meant to throw a can at a dude. It was the wrong dude, but the mens res, applies. And there have been cases like this where there's one case where a guy shoots at somebody, misses the dude, hits somebody else entirely, and the guy goes down for murder. And you might say, wait, he didn't have specific intent to kill that other guy, because in Canada, murder requires specific intent to kill. But he specifically intended to kill the guy he shot at. And we also have a doctrine of transferred intent. I shot at the guy in front of me and I hit the guy behind. My intent to shoot the guy in front of me transfers to the guy behind. And, I have a real bad day when I end up taking this all to trial.
Yeah.
It's
mens rea is you intended to do the action that resulted in the death. The action in this particular case is alleged to be zipping up the suitcase, not opening it. And I don't think you have a difficulty in mens rea there. She zipped it up.
I mean,
she didn't.
You can have different levels of mens rea. It can be a thing where it's like, so let's say somebody is charged with, and I'm going to be using the Canadian standard, which is very different than the US standard. But let's say somebody's charged with first-degree murder. In Canada, first-degree murder requires not just premeditation, but planned and deliberate, which is a much higher standard than the US standard. Right? So let's say they charge me with first-degree murder. Planned and deliberate means like you actually have to have put some planning in it. The US, it's like, did you form the intent to kill before you killed the guy?
That intention can form immediately upon pulling the trigger.
Yeah, it can be you formed the intention to kill as you pulled the gun out of your waistband, whereas in Canada, that's second degree, right? Like, let's say some guy comes up to me on the street and he spits in my face. It's offensive. I'm angry, but it's not like a self-defense situation. If I pull a gun and shoot the guy, and I say, I say before I draw the gun, I'll kill you, pull the gun and shoot the guy. In the US, we've got first-degree murder because you formed the intent to kill him and then you pulled the gun and you killed him. And you don't have a valid self-defense argument because you just don't, because you're not allowed to shoot a guy for spitting at you. In Canada, that would be second degree because you need to have planned and deliberate to get to first degree. And planned and deliberate is a whole larger thing. But so let's say, planned and deliberate might be like, I spent a week thinking about this and planning it out. And I showed up at the guy's house with a gun and a shovel and like some bags of lye and zip ties and all of that stuff, right? That's like, I got a plan. I had some time to think about this. I had some time to decide that this was a good idea. And you, like, the mandatory minimum sentence for that is life in prison with no possibility of parole for a long time. But let's say they can't prove that it was planned and deliberate. then you end up with a second level of mens rea. A different level of mens rea is, did I form the specific intention to kill this guy? And maybe that's established by, I did a thing that would obviously result in his death, right? I shot the guy with a rifle. You should know shooting a guy with a rifle is going to kill him. Therefore, you know, but maybe I didn't shoot him with a rifle. Maybe I hit him with a crowbar. You know, I went all Gordon Freeman on the guy. Then maybe they can't prove that I had the specific intent to kill him. And so maybe we end up in a situation where all they can prove is that I committed an unlawful act that resulted in his death, that I intended to hit him, but I didn't intend to kill him, or they can't prove that. Then we're at manslaughter. So you get those different levels of mens rea. And in fact, that can be all that differentiates those two, like those multiple crimes with very different sentences, is just, you know, what level of intention did you have? So we have crimes that are like differentiated like that.
Yep.
That is kind of a long-winded divergence, but it does, I hope, explain mens rea a little better.
It ties back in. We've got it. Okay, here we go.
On to the state's pleading that they filed this afternoon.
Mr. J, you have any problem with that?
I know there's a rule in the circuit about one witness per one attorney. I don't know what the administrative rule says about arguments. Discretion of court.
Okay.
He's arguing that one motion that they filed this afternoon that I've been working on these. He was working on that motion, so it's a separate motion.
The motion to strike.
The last motion whatever motion they filed today, Mr. Henderson, Tony Henderson here in the screen wants to respond to that. I'm
Okay.
going to respond to the ones that were filed prior to today.
Andy's aliens
I'll
coming.
allow it. All right, go ahead, sir.
Thank you, Jillian Whelan.
Judge, as you know,
Now I've got to build a Lego.
I filed my notice of appearance on August the 30th, I think 38 days prior to trial, knowing that the court had already made a ruling that you would not grant a continuance unless there was some type of exceptional circumstance. And Sarah Boone hiring or retaining or somebody pro bono coming on the case and representing her did not constitute exceptional circumstance. And so, as you know, we had the hearing after I'd filed the notice on August 30th. We had the hearing on September 3rd on my motion to continue. The court denied it. At that time, I explained to the court that I believed after my meetings, I think I'd had 4 with Ms. Boone, that she met the criteria for battered woman syndrome, but that I needed an expert. And we were vetting several experts at the time, 4 or 5 that we were vetting, and we needed more time to essentially pick somebody to go out and do an evaluation, an assessment of Ms. Boone to determine whether or not they would give an opinion that she suffered from that. Because, and I understand, the court denied our motion, so that left us with, we still had to give notice to the state attorney 30 days prior to trial of October 7, which I believe was going to be September 7, which fell on a weekend, which was that Saturday, I believe. So we got out of the hearing. I think the hearing was on a Tuesday. We had 4 or 5 days to file this notice, to timely file the notice. So looking at the file, I realized that Dr. Harper had the most time with Sarah Boone. Early on in the case, I think when Mr. Padilla was handling the case, she was appointed by the court to do an assessment and evaluation. And so I reached out to her, and she agreed to come down a couple of days after we had that hearing, and she met with and assessed Ms. Boone. I've retrieved all the notes, the prior notes, and then the notes from that meeting. And then on Friday, I spoke with her, that Friday, which I believe was the date that I filed this notice, September the 6th. That Friday, I spoke with her on the phone and immediately went down and filed the notice of intent to rely on the defense of battered spouse syndrome. We made allegations that Dr. Harper had formed the opinion that at the time of this offense, that Sarah Boone was suffering from battered spouse syndrome. And at that time, we gave the name of Dr. Julie Harper and her address where she could be found and located. And of course, the state has set her deposition for October 1. Now, the state has filed a motion to strike the notice of intent, alleging that we didn't give sufficient facts or evidence. But Judge realized at the time, I was simply trying to get it filed because the last day was the next day, Saturday. And of course, I had just
That argument never really goes all that well.
Judge Creighton, we have not finished reviewing all the discovery in this case. I pretty much shut my law practice down to try to do it. I've gotten my staff, and we're trying diligently to go through all the discovery. At the same time, we realize that we've got to establish corroboration of the battered spouse syndrome from eyewitnesses, from medical records, from potentially neighbors, court records, her phone and the information on phone. So we're diligently trying, number one, to review all the discovery, which still has not been done. At the same time, trying to locate additional evidence that we could utilize in helping to establish the battered spouse syndrome. In addition, the state attorney yesterday filed a notice that they're amending their discovery, and all the jail phone calls, or I think they have the ability not only to call, but they have a tablet and they can text back and forth with third parties, that they have disclosed that they have, I guess, 4.5 years worth of communications between Sarah Boone and parties on the outside, and that some of that may be relevant to the case.
Yeah, that's definitely coming in.
And we were advised that when I got in town that I was to bring a CD, and I did this morning. I went to the state attorney's office and spoke with the secretary and explained to her that here's my CD, I'll wait. And I was willing to wait in the lobby to get this additional discovery when we have 19 days for trial. She told me that there was quite a bit of.
Hold up. Who still uses CDs? Apparently the Orange County Sheriff's Department.
The law is full of like antique sort of things.
Yeah, but it's a flash drive.
You're like,
why are we
This is
whining
just-
about discovery? Get to the point. Like, get to the point of the defense. I mean, you took so much time about the discovery and the back and forth about how difficult it is to get the stuff. Just tell me what you're going to say.
That she would try to get it to me after the hearing or by the time of the hearing. I said, okay. I left the CD. I told her she had my number. She could text me. I was staying at the Hilton across the street from the courthouse. As soon as she had it.
why are you saying where you're staying
As soon as possible.
in an actually
Sometime
televised
later,
trial?
They have started, I guess, going through that material, and now they're sending discovery through email. I assume instead of the CD, they're going to do it that way. But we are receiving it. But it's just the volume of discovery that we have to begin with, we haven't gone through. The evidence we're trying to gather to corroborate our defense, and then additional discovery that we were noticed about yesterday.
I know I have no business
A notice
saying
had
it,
to be
but man,
filed.
does this
I
guy
had one more
tell
day.
stories
As
that
soon as
are
Dr. Harper told
long-winded
me on
and
that
just go
Friday, I knew I
nowhere.
had until Saturday. I filed it. The state knew. They've had it.
All right, Pot, leave the kettle alone. Long-winded stories, circuitous reasoning.
I mean,
4.5 years.
I get it, but you're talking to me and the public at large. You're not talking to a judge trying to make your point.
yeah, no, this guy needs to figure out what his point is in a real hurry.
They prosecuted the victim in this case, George Torres, at least 3 times. I think there's more like 4 or 5 times.
Oh no, we're doing this
But
again.
they opened up a file. They prosecuted him here in this county for battery
Jesus, are
and
you
violating the conditions of bond relating to staying away from Sarah Boone, but battery on Sarah Boone. They, if anybody,
I
was
mean, it
well
is
aware
relevant.
that there was a potential problem with the habitual nature in which Mr. Torres beat on my client.
Get to the defense. Get to the motion to strike the defense. Get to your response to the motion to strike the defense. They are not raising these fucking points.
In addition, my client expressed in the interrogation, which I know the court hasn't seen, please look at the videotape. Please look at my phone. Please look at the videotapes. Please look at the photographs. I need my phone to show you. He comes at me. It was ignored. They've had all this evidence. They had to be on notice that this was a potential issue. And the reason being is all the lawyers that have been through this have appointed different forensic psychologists to assess her. The prosecutor that's not here today, that was here on September 3rd, when I mentioned the problems that we were going to have, getting an expert this quickly to form an opinion, said, oh no, Judge, we're not prejudiced.
Motion for 1.5 speed. Granted,
Oh, fuck yes.
he's killing me. Get to the argument. I mean, kudos to the judge for not completely going like blank-eyed.
I'm surprised the judge didn't say something like, you got 5 more minutes.
Yeah,
We've already got
You
an
know.
expert.
this is painful.
We intend to rebut any said opinion by an expert that she suffers from battered spouse. We're ready to go. We've got our expert. Such that they said, we don't even need a continuance. If in fact he finds somebody and they file something, a notice of intent to rely on battered women syndrome within the time limits, we're ready to go. We don't need to continue it. We'll have our expert. And as you know, they're requesting that their expert now be allowed to go to the Orange County Jail and assess Ms. Boone, which they have every right to do, since we had filed this notice. But they indicated they would not be prejudiced.
Oh
How's
my
your
God.
sanity?
Oh my God. I need this video because I'm losing my mind. Can we just...
They indicated they were on notice. They didn't think it was going to happen 4.5 years, but it did. They knew all the prior abuse that Sarah Boone suffered at the hands of Mr. Torres. I did the best I could, Judge. I filed it. I felt like I had to have an expert. I explained in general terms that she was psychologically and physically abused by Mr. Torres repeatedly over a period of time that led to...
Oh my God, we have reached the point that he makes the argument. Thank you. Oh my God, you have reached the point.
this event. They filed their objections, which we believe is misplaced. The court, as you know, by that rule. Let me find it. It's apparent not only that the state was on notice, that we were going to rely on it, it was prepared to respond and was not prejudiced in any way. The notice of intent to rely on the defense of battered spouse syndrome comports with requirements outlined in 3.201, given the current circumstances of the case. And as you know from that rule, it says the notice shall contain a statement in particular showing the nature of the defense the defendant expects to prove and the names and addresses of the witnesses by whom the defendant expects to show battered spouse syndrome, insofar as possible. Insofar as possible. I did the best I could, Judge. In addition, as soon as we started going through discovery and gathering information about the prior events, the prior arrest of Mr. Torres, the prior prosecutions of Mr. Torres, we immediately amended the notice on September the 15th of intent to rely on the defense of battered spouse. And again, listed as many witnesses as we could based on the good faith belief that we had that corroborated either by witness testimony or physical evidence, photographs, videotapes, medical record, whatever we could find that would corroborate our defense. In addition, we've listed the ex-husband, Brian Boone, and the last paragraph, paragraph 14 says the defendant's investigation of evidence to support the defense of battered women syndrome is ongoing. The defense anticipates additional witnesses, photographs, videotape, medical records, court records, and other evidence gathered from the defendant's phone will be forthcoming. This evidence will be disclosed as it is discovered. Thank you.
Response, sir.
Yay.
The state is not surprised by any of the evidence that has been in the discovery for years. I'm not going to belabor the facts in
Yay.
the discovery, but suffice it to say that the decedent and the defendant had a violent relationship, and generally this violence seems to be fueled by alcohol. We're
So you're aware of everything. You got it. I see
So
no
what's
problem.
the issue now?
Why are we debating this?
completely aware of all of this domestic violence history, but that does not make a battered spouse syndrome defense any more than being mentally ill without showing more makes for an insanity defense. Their original notice was insufficient, and there's no reason to argue it since they've amended it. So turning to the amended notice.
Why am I pausing? Let me pause it for a second.
Is it because
Why
you
is
want to
this
do a
thing-
violence?
I want to do a violence, but I did a download of this. I'm doing all of it. The circle of anger. I just
deficient, and there's no reason to argue it since they've amended it. So turning to the amended notice, it still does not set forth what they are going to show that shows that she suffered from battered spouse syndrome. Was the decedent isolating her from her family and friends? Was he telling her that if she ever leaves him, he'll kill her? We have these instances of violence between the two of them. And when we get referred to the ex-husband, Brian Boone's deposition and statement, what he reports is that Sarah Boone would attack him, scratch him, punch him, and that she was a habitual alcoholic. And he would have to lay hands on her to restrain her. So we are going to potentially dive into all of this information in trial, but there are still the rules of evidence. And the cornerstone for the battered spouse syndrome defense, which is a misnomer under the case law because self-defense is defense, and battered spouse syndrome evidence is relevant to help a jury understand why it's objectively reasonable for a battered spouse to stay in a situation that puts them in fear of continued violence. The state and wherein our confusion lies is nowhere in any of the witnesses or any of the discovery that they have listed, exhibits that they don't even have been listed, medical records and so on and so forth. Nowhere does it set forth this cornerstone that is absolutely necessary before we get into any of this battered spouse syndrome evidence, before we get into any potential reputation for violence evidence of the victim, before we get into any potential specific acts of violence by the victim, before we get into the rebuttal evidence that is going to be offered against her for her violent nature in her drinking. The cornerstone is self-defense. Her statement to the police is not one of self-defense. It is one of accident. She repeatedly says there was no violence that day. So that is where the state's position is that their notice is deficient. It only sets forth that there has been violence between the two of them, and it's apparently exclusively alcohol related. But it doesn't go on to say this violence has caused her to suffer from the syndrome. And here's why. She was afraid to go meet with her family. She was afraid to leave. She was any of the things that make up what is actually battered spouse syndrome. And moreover, it doesn't set forth the self-defense claim, which is the cornerstone of this. None of this comes in.
He's lost me on this one because the thing is, the judge just grant their motion for a forensic psychologist to do a forensic. So what you're asking for is you're asking for the foundation for the battered spouse defense. That's going to be the report that's going to be prepared by this forensic psychologist. So I think it's fair game. Yeah, ask for it. You get the report. Once it's prepared, you get the report. Hell, you can depose the forensic psychologist. You can get a psychologist of your own. But you're asking for discovery. You're not asking for the defense to be denied right now. You're just saying you don't have enough information to know whether it's proper or not. That's fair. You get discovery.
Without a claim of self-defense. And so that's in part why we filed our motion in limine with that response is the court can and should not allow any mention of battered spouse syndrome come in until self-defense has been established at trial. And as far as I can tell, the only person that can set forth a self-defense claim, since it was just her and the decedent in the apartment that night, is her. So she'll need to testify, and then she'll be impeached unless there's a ruling that the statements that she made to the Orange County Sheriff's Office are not only a violation of Miranda, but are involuntary and unavailable for impeachment use. That's what we're hoping to avoid, because we can't unring the bell during trial. If they put on all of this testimony and evidence about battered spouse syndrome and about the past violence, and then we introduce evidence about her past violence against him and against Mr. Boone, it's hard to unring that bell. And even though King versus State at 2000.
Please, someone tell me how many times a prosecutor has been like, oh, darn, I have to unring the bell that I rung loudly and solidly in a case. I have no sympathy for him saying, oh my gosh, this poor woman's going to have to testify. You know, he wants her. Everyone knows she wants to testify.
Also, if this was a mistrial application, he'd be arguing that he could unring the bell all day long.
That's what I mean. This is a little disingenuous.
Prosecutors are expert bell unringers whenever a mistrial is asked for. They're like, you can unring the bell with a jury instruction.
Yeah,
Juries
Judge,
totally forget about bells the instant you tell them to, like.
You can cure me pointing at them and saying killer, killer, killer with a jury instruction. Judge, I can unring that bell.
Yeah, just forget bells exist. Jury, that's enough.
This is all right. I'm getting it. I get the point he's making. It's premature. They get a chance to get an expert to review her. They get a chance to put the report. You've known this issue was coming for years. How many times? That's where I have no sympathy. Like everyone, the prosecutor case has known.
The prosecutor just wants to drag the defense across broken glass for every inch that they, every inch that they get.
Yeah, you know damn well And honestly, no, you don't. The state does not get to tell her that she is required to testify. It is her absolute right to decide not to testify. So don't be the asshole and say, well, she has to get up and testify. No, you don't have to do that.
I mean, he can say, I don't see how she brings this argument without testifying.
Yeah,
but I'm
you don't
open to
get
be
tell her that she
surprised.
has to.
Yeah.
Case allows the state to point out the things that are promised in the defendant's opening statement, but then don't come to fruition. That doesn't unring the bell. So that's what we're asking for. We're asking for sufficient notice. The statement in particular.
I prefer Emily's phrasing of the poop is out of the horse.
There's a self-defense claim, and then there is going to be this shown beyond just the past violence between the two of them. Thank you.
Judge, they're scheduled to take the deposition of Dr. Harper October 1, so they're going to know fairly quickly what her opinion is.
What's your response to Wagner?
We're going to talk about Wagner, Judge, and I don't want to talk about that in a minute.
Your
but
Honor,
he's
I
leading
agree.
the
It's
argument in the state's
impossible to
motion
put the
strike
hair
defendant's
back on the
admitted
bald
notice.
spot.
And I would like for Mr. Henderson to respond to what he said about that.
You're terrible. You're terrible. Okay, let's see, Mr. Henderson. So we got Wagner. So the judge is asking a question about the actual what you have to demonstrate to prove battered spouse defense. But I think the lawyer came out swinging, basically said he's got a depo scheduled of the forensic. So,
But Judge, I agree. There's two different issues here. The first issue is the sufficiency of the notice and whether the notice is sufficient under the rule. The second issue from the court's perspective, is it applicable? And that's the hang up that I'm having.
That's not to be decided today. That's not Wagner, whether it's an accident or whether it's battered spouse and there was self-defense. That's not to be addressed today or not to be decided today. That's going to be based on the testimony from Ms. Boone about what was going on. But I like Mr. Henderson.
He just said she's testifying.
yes, he did.
I mean, he's not bound by that. They can turn around and not call her.
No, they can, and I'm also with him here, Judge. You don't get to make the decision that this isn't a defense right now. If you want to have a separate hearing on what testimony she's going to, if you want to go down that road, that's a separate hearing. You don't get to decide whether it's applicable right now.
No, I agree with that.
And I like that he came out. At least he got there.
Henderson, if you don't,
But that's not what Wagner stands for. Wagner didn't allow. Wagner struck after multiple amendments. And the court, and we can take judicial notice of if you want to, the court has pulled the file from the trial court in Wagner and has looked at the notices that were filed in that case for the battered spouse.
Damn.
That wasn't good news for him.
Defense.
This judge just went up like a mile in my book. The judge saw the authority and then pulled the trial court record to go and look at what notices were filed. That's badass.
Yeah, and the defense here is like, he's making the Lionel Hutz.
Oh shit! I'm reading the order. Wagner v.
Does the
State.
order call counsel a dickbag?
No, but Wagner v. State pretty much puts.
Did they throw out the battered woman syndrome defense?
No, it's in there, but the criterion.
This is the thing, is that you got to realize the court is going to be reluctant to toss what is clearly her only defense.
We're not gonna do
right?
it. Yeah.
The court's going to be like, we kind of don't want to toss the argument that she has.
ultimately, the female defendant in that case
pulled the file from the trial court in Wagner and has looked at the notices that were filed in that case for the battered spouse defense.
ultimately, the female defendant in that case claimed that the firearm discharged accidentally. Correct. And the court ruled, hey, you can't have it both ways. It can't be an accident, and at the same time be intentional that you committed as self-defense because you're a battered spouse.
Right. So how is battered?
He's like,
It's premature
so that's
for them to
my
be arguing
point.
the question of intent.
But that's not what Wagner says. What Wagner specifically says, although the trial court found the third legally sufficient, the court granted the state's motion to strike the notice and precluded appellant from presenting the battered spouse syndrome evidence at trial. And the DCA says that the evidence underlying in that case was all accident, specifically the located. battered spouse syndrome as admissible where the defendant claims accident rather than self-defense.
We're not claiming accident.
Well, then what are you claiming?
Oh,
But every case that you cite, Medina, Hickman, its progeny, all pertain to some act by the accused. And that battered spouse is an excuse, a justification, an explanation for those actions. How is your purported defense applicable legally?
That's the reason we asked for the statement of particulars, Judge, so we could find out exactly what they were claiming that she did, what overt act or what omission. The overt act, was it zipping him into the suitcase?
But
Was that the overt act that caused the
But all
death?
of the battered spouse syndrome cases talk about a defensive issue, not meaning defense your side of the ledger issue. I mean an action in defense. Wagner fired the gun. It was accidental. Hickman fired a gun. There was an act that was done by the victim or by.
dude, I love this. I need to slow this back down. This is good.
The defendant in those cases, and battered spouse was used as an explanation for why it is that they did. How is that applicable to the case at
I
bar?
assume they're going to say she overtly zipped him up in the suitcase. I assume they're going to say he was asking to be let out of the suitcase and she refused. She failed in a duty to act. Later on, she went upstairs and fell asleep. So it's either an act or an omission, but they're claiming.
Don't you hate when you need a nap mid-murder?
Yeah.
Like you're
Oh, no,
partway
you just-
through murdering a
you just
dude and you're just like, I'm
identified
tired.
several overt acts.
You're like, I'm tired. I need to have a nap midway through my
An
murder.
act or a series of acts
Just a little
led
kip.
to the death of Mr. Torres, which they have alleged was directly caused by Sarah Boone's actions or non-actions.
Here's the problem, though.
Wait, you've got it narrowed down to one?
No, I'm back with my original argument. The judge's focus here is premature. When he read the Wagner opinion, he focused on the appellant's testimony, like the testimony that was provided. He focused on actual testimony given at that point in time. I think in Wagner, it was a jury charge issue. I think it was taken away by the testimony. I don't know that it was taken away by the notice. I don't think I like because the focus in Wagner, because here's my reading from the actual order from today. The state relies heavily on Wagner v. State. In Wagner, according to appellant's testimony, as she bent down to pick up the keys with her left hand, the gun that she was holding in her right hand accidentally discharged. That she absolutely did not intentionally pull the trigger and that she was not aiming at anything when the gun went off. The bullet discharged and struck the husband in the lower back. The trial court precluded appellant from presenting the battered spouse syndrome evidence at trial. That's different. That's a self-defense. That's a Florida self-defense hearing. So that had to have taken place in an adjudication on the actual self-defense where in Florida you have this hearing before you're allowed to present self-defense, right? Whether you're allowed to use it or not.
Right.
At that hearing, testimony is provided as to the foundations or the thought process in the person's mind as whether it's imminence, whether the response was reasonable, etc. That has not happened, and that's not what's happening here. The judge has no clue what Sarah Boone's going to say, and the judge is trying to beat them to the punch.
I mean, maybe a little clue.
And let me tell you that why? Let's say there was one overt act that would not naturally cause the death or death of an individual, right? Honestly, let's say zipping him up in a suitcase. Is that immediately going to cause the death? No.
No, that took hours.
It took hours. So
Just gonna say, ladies and gentlemen, don't allow somebody to lock you or to zip tie you in a suitcase.
but then there's the argument of accidentally. right? So the judge says it can't be an accident. It has to be an intentional act. I don't think so.
Well, for battered spouse, yes.
But if she accidentally left him in there, she zipped him up on purpose. She made the remarks on purpose.
And then went upstairs and passed out by accident. Yeah. I don't hate it.
You know what I mean? Like the judge is trying to confine him to intentional conduct. And here, I don't know that it is.
I don't hate
I
it.
think you get to present the totality.
Yeah, no, I'm with you.
I think the judge has jumped too far ahead. I think the judge is we're not there yet.
Hickman, the defendant stabbed the victim to death. And the justification was battered spouse. In Terry, which you provided to the court, Terry v. State, 467 Southern 2nd.
Let me push back on this, but Owen says it's not an accident. He didn't have to. You can't both use battered spouse, which is that you intentionally killed your spouse, and accident. I'm a defense lawyer. I can use whatever the hell I want.
I was gonna say I can think of the alternative arguments.
And I
Like the alternative arguments I can see are, you know, she locked him in the, like, you know, as you said, she locked him in the suitcase intentionally.
and then accidentally fell asleep.
And then accidentally fell asleep when she should have let him out.
Now, is that believable? No. But is there a world where that could exist?
Yeah, I mean, the problem she's got is the laughing. Because if she didn't have that, she could argue, I think, fairly easily that, like, you know, yeah, I don't know.
But what the state is asking for here is the state's asking for information.
The other thing I want to note is I can see this. I can see this from like a legal sense. I can tell you I'd never run these as alternative hypotheticals in front of a jury.
No, too dangerous.
No, I mean, juries hate alternative hypotheses just in general because they're like, pick one, right?
It looks
what
sleazy.
did your client do? What happened? Juries want a story. More than anything, they want you to tell them what happened. And this is also part of why, as much as we say that you've got like a right not to testify, juries will sometimes punish the fuck out of your clients for not testifying. And that's because they want a story and they blame your client for not giving them the story, right? So, yeah, it can be dangerous. But yeah, I mean, jury's going to hate the alternative argument. And if that's
he's got to go with intentional conduct of putting it in there. I mean, that's the only way you can run this. With the videos of her laughing at him, that's the only way you can run it.
And I mean, well, the thing is I think this is a doomed case. I think this lawyer is a solid guy for taking on this case that has very little prospect of success. And quite frankly, if he beats this, like if he wins here, we should be calling this guy, you know, Captain Badass. But
I don't know how you win this trial.
I mean, if he wins it, he's a better lawyer than I am, because I can tell you, I know how to run this trial, but I don't know how to win this trial. And like I'd be telling my client, listen, you want to run this? I will go in there and I'm going to do the best I can.
Yeah,
but you need to be aware that the best I can is not gonna, you know, you don't walk at the end of the best I can here. Like, sorry, I'm just not good enough to get Boone acquitted here.
This is tough, but he definitely. It seems like I don't like the fact that he just put his client in a position. Yes, it's the client's right to decide when to testify if they want to testify right there in that moment. As a lawyer, you shouldn't automatically say your client's testifying. You shouldn't put that out there. Although we all
Yeah.
kind of knew it was going to happen.
I mean, I don't hate it just because we knew it was going to happen. And quite frankly, I think the judge would be sitting there going, you know, if your client's not testifying, then why are we here?
Yeah.
Right. So.
I think this should get a second here. I honestly think this gets a second hearing. That's, in my opinion, this gets a mini trial on the self-defense issue, whether you get to put that on.
Hickman, the defendant stabbed the victim to death.
Okay.
And the justification was battered spouse. In Terry,
That's a way better
Chief
argument
provided
than
to
it
the
was
court.
funny.
Terry v. State, 467 Southern 2nd, 761, it was firearm. What's the
Mechanism?
What is it?
They're the only ones that can answer that, Judge. That's why we asked for the statement
I
of
don't
particulars.
understand that circular logic. And the reason I don't is because it's your defense.
Okay. I'm assuming that they're claiming that she zipped him up in the suitcase
Yes.
against his will, would not let him out of the suitcase, and therefore he suffocated. So the act of zipping him up and then the non-action of not letting him out when he asked to be let out constituted the offense of second-degree murder. That's the only explanation that we can come up with based on the report, based on the evidence we have. But Judge, you remember Marsha Thompson, the Palm Beach County case?
But there was a firearm.
There was a firearm.
She discharged a firearm.
Remember Dr. Brannon said on the issue of imminent threat, it is in the mind of the battered spouse
But
woman.
right there's the words, imminent threat.
That's correct.
There was a threat. Now, I don't know all the cases. I don't know the facts and circumstances of that West Palm Beach case. I don't. I know snippets that you provided to me, but I haven't read any opinions on it. I don't know where it is on the DCA or appellate perspective, and trial court findings are not binding on another trial court. I mean, the case law is very, very clear on that.
Judge, the state doesn't know what happened the 2 minutes prior, or the minutes leading up to, the time leading up to the 2-minute video. The state doesn't know what happened after the 2-minute video. Only Sarah Boone can testify to that. That's for her to testify to.
Florida, the appellant has not cited, nor is our research located, any Florida case holding that evidence of battered spouse syndrome is admissible where the defendant claims accident rather than self-defense.
Who claims accident?
Are you claiming self-defense?
Yes.
Well, that's the first time that I've heard that.
Judge, I just
No, it
mentioned a while
isn't.
ago.
You heard it
Self-defense.
No, it's
already
not.
today.
Battered spouse defense is self-defense. Why are we talking past each other? Why is no one on the same page? Battered spouse defense is self-defense. When the judge is talking about imminence, battered spouse defense goes to the explanation of the word imminent. It's a caveat on imminence. We just talked about this.
Defense never came out of your mouth.
Judge,
Words that you believe that the state's position is, what you believe that they're going to try to establish, that we don't know what happened before and after that video.
He
The word
did say
self-defense has never been
self-defense
uttered this
before.
afternoon.
Judge, for the record, we're claiming self-defense. We're utilizing the battered spouse syndrome in conjunction with that defense.
Okay.
That's what it is.
Not accident, as they want to allege.
Okay. Does your compatriot want to provide response further? Okay. Mr. Henderson, good afternoon, sir. Can you hear us?
All right.
Wait.
It's like, wait, I was going to cover my ears, but then I've got earphones in. Apparently, he comes in real hot.
If you can hear me, sir, you need to unmute yourself. I can, but I have some concerns because it's getting reverb. You.
Put in your
No.
fucking headphones, dude.
We're not doing that.
Final positions
Okay, volume back up then.
To the state's argument, either Mr. Owens or Mr.
Well, just, I'll let Mr. Henderson go, but just as it relates to Ms. Boone's testimony, that's what jury trials are for.
Not in self-defense cases, not in Florida. I think this should be bifurcated.
Yeah.
I don't know.
I've asked.
think the
for
lawyer
some
should be
time. I think
bifurcated.
There was an order, I know there was an order that you had submitted to writing and that was filed with the clerk's file that indicated that you wanted some things from the defense and from the state by certain dates. And I think that's a typo in paragraph 3. I said August. If you
All
these
right.
people move, so we need more time, is my point.
The deadline expires who've just recently given go home. You don't need to show appoint clinical psychologist regarding Dr. Michael Brannon was filed. That was just filed yesterday.
Okay, psychologist. All right, that's enough for Boone. All right, so the outcome. Let me pull the order up. The outcome on the battered spouse defense, which I don't know if this is. I feel like. Hang on, it's. Yes, the defense gets to put on their defense. That was a really dumb way of saying it. Let me pull the order up. Mhm. Where'd it go? No, I don't want that. I want my Adobe. Adobe, where are you? Order on motion.
Oh, apparently we missed Sarah asking for a hair and makeup artist.
I will take the chat's word for that she asked for a hair and makeup artist.
Chat, does she get that? I can see the argument, but I can also see why the judge would probably say no.
No, you don't get to look all dolled up. You mean you?
I would argue for it. Apparently, it's the last minutes of the video.
Okay, I will pull it back up in a second. I want to get to the order. So here's the court's ruling. So the motion, the procedural history, the notice provides a statement of particulars showing the nature of the defense. That's what's required, right? The amended notice, among other things, provides the same statement of particulars showing the nature of the defense as the notice, battered spouse syndrome, as a result of the psychological or physical and psychological abuse the defendant sustained at the hands of the alleged victim, Jorge Torres, and the names and addresses of 6 witnesses. All right. So the court finds that both the notice and amended notice comply with the rules. Okay.
Nice.
I don't know that the court had to go this next step. I think this next step is premature. I think all you had to do was say the notice and the amended notice comply with the rules. Whether it's going to be allowed to be offered at trial is a different question. So as relied on, so Medina v. State, State v. Hickson, and Ladd v. State, as relied on by the state, all address exclusion or admissibility of expert testimony on battered spouse syndrome at trial, not the pretrial exclusion of expert testimony on battered spouse syndrome. Additionally, Aquendo versus State review granted. You got to address the introduction of battered spouse syndrome evidence, not the pretrial exclusion of the same. Okay, so we're framing our mindset here. The state relies heavily on Wagner v. State. In Wagner, according to the appellant's testimony, as she bent down to pick up the keys with the left hand, the gun that she was holding in her right hand accidentally discharged. That she absolutely did not intentionally pull the trigger and that she was not aiming at anything when the gun went off. The bullet discharge struck the husband in the lower back. A trial court precluded the appellant from presenting the battered spouse syndrome evidence at trial. At the hearing, no outright evidence of an accident was presented. Motion and amended motion are granted in part and denied in part. They are granted in that the defendant shall submit to an examination by an expert of the state's choosing. That's fair. Said examination shall take place no later than September 26, 2024. Okay. Motion and amended motion are denied in that the notice and amended notice shall not be stricken. State's request preclude the defendant from mentioning battered spouse syndrome in her opening statement is denied, properly so. State's request to prevent any mention of battered spouse syndrome until admissible evidence of a justifiable use of deadly force is admitted in the evidence at trial, and admissible evidence of battered spouse syndrome is admitted in the evidence at trial is denied. So it's not the worst order. And
No,
honestly, by written order, if we're following the written orders of the court, I don't think she's precluded from arguing. I would bring that back up if I had the facts for it. I don't know that I have the facts for it though.
I mean, I feel like this is a long shot at the best of times. Good for him for fighting it.
I don't know that I don't know the fight should have been that hard, to be honest. We can all see the framework for why it's being requested, right? Like we all get the framework.
Mm-hmm.
We don't believe it. But that's a question for the jury. That's not a question for the judge to preclude it prior to trial.
No,
So,
I mean, this is the problem.
people are telling me it's at the end, right? So let me see if I can't find this last clip.
Oh, and people really want to see it.
I can tell.
The chat is thirsty for this particular clip.
Why? Is it because she's the one asking for it?
I don't know. I assume it would be done through counsel. Unless she's crazy enough to like speak up midway through. That would be itself a weird thing.
Hear it.
I
Tell
will
me if it's
take it under advisement, the issues pertaining to the battered spouse syndrome, and provide a written order. You would advise there were some other issues that you wanted to bring up, sir.
What are the other issues? I guess the other issues would have to be the hair
Investigator
and makeup.
is working with the defense and his potential costs up to the trial.
Are these being hand filed now?
Mr. Lane handed them to me right before we came in, so I've got, I'm going to have to scan these in and file them.
Okay.
I wanted the court to be aware. If you want to address it at the September 26th case management conference, we can do it then.
Let's do that. Just do me a favor if you could, sir. Once they're filed, just forward them to Ms. Barrios
Okay.
so that I've got hard copies of them.
All right, I'll do
I'll
that.
give these back to you, sir.
Judge, the other thing was, of course, we got trial coming up quickly, and generally, when in a courtroom, I do opening statement, I maybe have some demonstrative aids, but I walk around, and I understand here that we've got to be in front of the microphone. Is there any way we can set up, maybe the defense can set up a system where we can wear a mic so that we can walk to some degree?
I will have to check with court admin.
All right. And then the other thing is, we would like Sarah to wear street clothes.
okay.
So do I need
So,
to file something?
I have,
That's normal. So here we are.
Yeah.
We're at the point. So that's normal.
get in touch with the public defender's office. When Miss Boone was representing herself, I had coordinated and communicated with the public defender's office multiple times in an attempt to obtain clothing. Before you came on board, Mr. Owens, Barry Click, BARRIECLICK, had provided the
We're off cadence here. Let's pause if we can.
total amount of clothing that they had that would fit Miss Boone, including shirts, pants, slacks, skirts. And that was the time where she would be.
Yeah, we heard that. And the street clothes,
That's normal. That's expected.
But you don't get street clothes for every hearing. You get it for the
allowed free
trial.
reign and was going to have the shock device on her lower leg. I would ask that you can email Ms. Click. You can find her information on the Florida Bar webpage, and ask her if the public defender would assist you in provided clothing. They were going to while Ms. Boone was representing herself, and I imagine that offer would still be extended.
Judge, and I anticipate 2 more pretrial hearings. 1 is the case management conference, and 2, if I file the motion to suppress the statement made during the interrogation, we would probably have to set a separate date. And she wears street clothes at those 2 hearings.
No.
If you could get it to her. So
Oh.
that's something you have to work with corrections. I don't know that they're going to let you do that.
Now, when it comes time to trial, we would like, she would like for us to have some makeup for her and somebody to fix her hair in a way that's presentable to the jury that she would like to be presented. Do I need to file a motion on that, or?
I think you're going to have to.
Yeah, that's
believe
the
that's
judge
all.
saying
Okay. All right.
that's not
Anything else,
happening.
State, we need to
No, you don't get the makeup. Like,
I could
that's
see.
just-
I'd make the argument.
I can see making the argument because you don't want them coming out looking. All right, how do I say this without sounding remarkably sexist? You don't want any client, male or female, coming out looking completely disheveled and. I'll give you an example.
Like your client looking like a bag of smashed assholes.
Yeah, you don't want the client coming out looking like Daryl Brooks. Just awful.
The other thing I'd argue, if it was me, is I would say, listen, juries have different expectations
Correct.
of men and women, and if they see that the effect of bringing out a woman who is in who's not been permitted to wear makeup is akin to having to trotting her out in the orange jumpsuit, the jury's going to make inferences. They're going to make assumptions, and it's harmful to her defense, and especially because it ties into sexist notions within society. So essentially it allows the prosecution to leverage sexism against her specifically.
Here's the thing is, I can see a judge if the defense team provides the makeup and if it's done and if it doesn't impact the time of getting her to and from court every day, right? They're going to transport her to court like 5 a.m. with everybody else. She'll be there for 3 or 4 hours before every trial begins every day. If the defense brings makeup back, I don't see any harm or prejudice in allowing her to have makeup put on her or to put makeup on prior to trial.
Yeah.
I don't see security risk to it. I mean, I do see the point of allowing the defendant to be presentable. Now, getting her haircut, I can see a safety concern there. And the sheriff's department is going to push back pretty damn hard on that.
I mean, they do haircuts in jail, right?
They do. And you don't get it styled. I think there's enough to provide her with the basic necessities that would allow any person to be presentable in court.
Yeah, it'd be like she can get a jailhouse haircut beforehand. She can wear makeup. But we're not giving her a stylist.
I think what the judge is doing by his motion,
put on her own makeup.
Yeah, when the judge is saying you need to bring a motion, or you need to file a motion, I think what the judge is saying is within reason. The judge is going to set the constraints, right? We're not going to just allow this willy-nilly. I'm not going to say I'm not going to say that you can have a stylist team go back there and meet with a criminal defendant, these random unvetted people. No, but within certain constraints that provide for safety. Yeah, I don't see a problem with that. That's not an awful request. Why is people were saying that she wants like a glam team? I didn't see that. Now, if you combine that with her prior pro se request when she was saying that she wants, a skirt and she wants to like the clothing, maybe.
I mean, I see no problem with her requesting clothing as well.
No, I don't have a problem with that.
She should have access to street clothing that is, because you don't want her coming out in like the prison orange, right? Because the jury does decide, oh yeah, this person looks totally guilty because she's wearing the guilty people clothing. You know, in the same
Yeah.
way you wouldn't want to have a trial dressed as Bozo the Clown.
Mm-hmm. Okay, so let me catch up
At
on
least
these
I
chats. So
assume.
we can get to the Diddy comments or the Diddy report. So let's
I
see.
forgot Diddy exists.
Recovery addict Boone now has a legal defense army. Well, she's got 2 attorneys, 3. No, she had 2. She had 3 at the table, and then 1 on Zoom. So it looks like she's got defense. But thanks, Scott. And you've been a member for 12 months, bud. That's awesome. Darlene says crocheting homeless masks from plastic grocery bags. That's really cool. Appreciate your legal reviews. Love you both. Top sheets all year long. We'll end that poll in a minute. Marmar lost the family friend. Glad to hang out with you too. I'm sorry for your loss, Marmar. Glad you're here. Hope you're finding a little bit of happiness. Elizabeth Walker, thank you. Team fitted, flat with hospital corners, and a comforter. That's a lot.
What are hospital corners?
That's essentially a flat sheet that is folded into a fitted sheet.
Okay. I was just wondering if it was like the hotel thing where they
A squared cornered sheet.
where they like basically pack it in so that you feel like
No, that's the opposite of that.
Okay. Because yeah, I hate the hotel thing where you get in and you're like, oh,
You're in a burrito.
I feel like I've been stuffed into a tiny little envelope and I hate it.
Michelle Maynard gave the flat sheet team. Awesome. Thank you. Alita. Team flat sheet plus weighted blanket, then dual control heated blanket. So hubby can have different temperature than comforter, then blankie to squish. That is a lot.
I want to get a Mrs. Runkle doesn't want a heated blanket. She's worried that it's gonna like set fire to the house. And okay, fine. Sometimes that does happen. I get it. Fair. That said, I really want to get like they make this thing that like pumps warm or cold air to different sides of the bed. I want to get that thing.
The bed jet. I think someone was commenting about it last week.
Yeah, I want one. They're stupid expensive.
But they're cool. Cool concept.
Yeah, one of the best things ever is like freezing cold day and you're in a very warm bed. That is the best.
Yeah, I do enjoy that very much. Cherry Mills, thanks for being a member for 20 months. Much appreciated. Mom Smith, thank you. She says there are inculpatory, and you corrected, exculpatory, shows her as a victim, exculpatory videos on her phone that the state didn't download. I love you guys. You don't get the phone back. You get a forensic image of the phone. And for those of you who are curious, the motion for the return of property was denied.
The likelihood that there were videos on that phone that were not downloaded is 0.
That whole phone is downloaded.
Yeah, it is. They downloaded every single thing on that phone. And yeah.
Jill and Brian says, thanks for F&F. Here's me laughing. Glad that you're laughing and having fun. And hi, Brian. Laughing Coyote says, for good advice, took an old project out of mothballs, started coding on it again. Creating something feels really good. Told you. Make something, you'll feel better. Promised.
And making something can be all sorts of making somethings.
Miklas. Why did I know that you would show up? My friend, you didn't show up. You said you would. I accepted invite as an apology. Granted. Give me a minute to get through these. Kimchi. Wait. So if Joe beats his spouse, Bob, and Bob tries to ouchie stick Joe, but instead sticks Runkle, does Bob get to use battered spouse syndrome as a defense for macheting?
This is the ouchie stick.
Oh, Mac,
McAfee.
that's the Mac.
That's this thing.
Yeah. This is a lot. Hang on. If Joe beats spouse Bob, Bob tries to swing that at Joe, but instead hits Runkle. Does Bob get to use battered spouse syndrome as a defense? So technically speaking, self-defense is self-defense. If you are committing an action in self-defense, right, apply that logic to discharge of a firearm in self-defense. That defense is still a good defense. I don't know. The facts on the battered spouses are complicated, though. Could be. That one gets more questionable. Jedi Jen, did you get your sheet back yet? Team flat sheet. Not yet. I have been promised that when we raise $5,000 for Ian's charity, that I will get my flat sheet back. We're at 3,930.
Where are we on this one?
3,930.
All right, people.
Yep.
We're about
Smith,
$1,000 away from Rob getting this, getting comfortable
me
sleep.
getting my flat sheet back. 70 Smith, spoiler alert, the judge denies the motion to strike the defense. Yep, we saw that. Sir Merrick, did you go over the part where the state says that the defense can't question Boone because she will lie and it would be unethical? I didn't, but I don't really care what the state says. The state doesn't get to dictate what can or can't happen at trial. That's the judge's job. So the state's going to say anything. The state tried to say that she'd be forced to testify, which is not the case. Chris Mullen, thank you very much. Donut Extra Life. Also, go team flat sheet. Gretchen Call. By the way, if you guys are anti-flat sheet, you can still donate. Like it's not exclusive to one side of this argument. Gretchen Call, listening to law explanations while working on jigsaw puzzles is a great chill way to wind down a Friday night. That's exactly what this is intended to be. And sometimes some feisty debate. Helen Nichols, thanks for breaking these cases down for us. Thank you, Helen, for being here and listening to us. Julian Whelan, I've crocheted more than 3 blankets listening to Rob's Just Make Something You'll Feel Better. If anyone wants any, let me know. There you go. That's awesome. Glad you're doing that, Jillian. Adrian Angevine, couldn't she couldn't she wear her own clothes? I know she probably lost her apartment, but does she not have family that saved her stuff? Is all her stuff gone? You can absolutely wear your own clothes. Like street clothes or street clothes. People can go and buy you stuff too, and you can wear whatever as long as it's clothing that is suitable. Yeah, she can wear her own stuff. Okay, let me do this. Let's go ahead and end the poll on the sheets because, we're going to get into the Diddy stuff, and the Diddy stuff is a little bit dark. So let's see. We, on this current poll, we let it run for a while. So we've got 2,666 votes. 2,666 people have voted. Holy crap. So 62% say team flat sheet. 29% say team blanket, no flat sheet. 9% say what is a flat sheet. I will put the 9% that say what is a flat sheet in the no flat sheet. So 62 to 38 with 2,676 votes in. Far better poll.
I've got some video I wish I could show you right now. I am watching my
Private
3-gun.
chat, I can.
I'm having to edit out I'm editing it down to just the bits of me shooting, but I also need to, what do you call it? The shooting club I'm at wants videos vetted before they go online.
Yeah.
Because they, what is it? They just want to make sure that you're not doing anything really dumb with in the videos.
That's fair. Okay. All right. So let's do Alan Muller. Thank you very much. Hair and makeup is a bona fide request. After all, making up is hard to do. All right. That was solid. Calypson's Vixen, pro flat sheet and pineapple on pizza. Don't at me, bro. I added the bro in there just because it's funny. Nice. Let's see. Let's see. Oh, Chris and M96, Clemson on the Clemson game. Not talking trash this year. I don't know how we're going to do tomorrow. There may be a delayed trash talk next week, or I may be really quiet. I might be too. NC State has been rather disappointed this year. So still early in the season. We shall see. So Diddy, let's go through how Diddy came to be indicted.
He did.
Because he is indicted. Diddy, and he did. So here's the thing. Cassie Ventura, this all kind of started with Cassie Ventura. And from my understanding of this, Cassie Ventura originally hired, call it a PR team, a bunch of individuals that came to Diddy's group and basically said, oh no, I've got a swoop. I'm being yelled at. I'm sorry. So Cassie Ventura came to Diddy's team and basically said, here's the thing. I have this book that's filled with all of these details from the time that I was with you. And I plan on running with this book and for this book to be published. And wouldn't it be great, if you didn't want this book to be published? Perhaps for a certain amount of money, I could not publish this book. Say, hypothetically, $30 million. $30 million, and I'm not going to publish the book. And Diddy's team came back and said, nah, go away, too small too. So Cassie then went to a law firm, really reputable law firm. Law firm said, you know what? The things that you're saying in this book, they also happen to be civilly recoverable. These are torts. These are things that you can recover against him for personal injury actions. So what if we put this into a lawsuit? So the lawyers go to Diddy's team, and the lawyers say, dear Mr. Combs, Diddy, Daddy, however you want to call it, there's a lawsuit that we're about to file. If hypothetically you didn't want this lawsuit to be filed, going through all the specifics of your relationship with Ms. Ventura and what used to occur,
We could take $30 million.
we can take $30 million. And Diddy's team said, go ahead and file it. We don't care. Go figure, that wasn't a bluff. Cassie Ventura's legal team filed their complaint, and within a matter of hours, there was a settlement announced for $30 million. The problem is that allowing the lawsuit to get filed at all opened the door to everyone else who saw this as an opportunity to file claims of their own. They also saw that one person stood up, had the courage to file, and was willing to fight that fight, and they all jumped in and filed their separate lawsuits. Some probably seeking money, some probably, joining in the band of individuals that were trying to seek recrimination against an individual that did terrible wrongs. And somewhere in the ether was a federal prosecutor who looked at this lawsuit and was like, this is very well researched, and these factual allegations seem very interesting. This would be a lovely witness. And lo and behold, there's 3, 4, 5, 6, 7, 8, 9 additional witnesses. And they detail out these allegations with remarkable specificity. I bet I could probably impanel a grand jury and issue a few subpoenas here and there and maybe get an indictment. And if you're a federal prosecutor indicting Diddy, one of the moguls, Nick has a link. I sent him one.
Nick might have gone to bed.
Nick might
The super chat was a while ago.
He's let him sleep. Everyone's saying let him sleep. He can sleep. You're talking about an indictment and a federal prosecution of one of music's largest moguls that are out there. You can't tell me there aren't prosecutors chomping at the bit for that. That is a name maker. That is you want to ride to the federal bench. You want to ride to politics. You make that.
Not only that, but like if I'm a prosecutor, you're spending a lot of time dealing with dog shit, right? You're spending a lot of time dealing with like, crap. Dude stole a liquor bottle from the liquor store. And you know what? That stuff isn't really what you got into being a prosecutor for. You got into being a prosecutor because you want to be the big damn hero. You want to be the guy taking down the powerful shithead. And now this lands in your lap. You're like, for the thing is you might be the guy who's like, I want to be a judge one day. I want to be like the chief DA. I want to be whatever. But you might also just be the guy who's like, all right, I get to put my Crusader hat on and take down, like, I'm going to slay me the dragon. And because I'm betting that for that prosecutor, that probably felt pretty damn good.
I'm also a cynic, so maybe that was the cynical approach to it.
I am a bit of both, but I mean, this is the kind of file, like, if you ever wanted to lure me into being a prosecutor,
This is one
this
that would
would
do
be
it.
the kind of file you'd have to dangle in front of me to be like,
Oh yeah,
all right, this is what I feel good about.
you take those lawsuits, the Lil Rod lawsuit, the Cassie Ventura lawsuit, you take those allegations that, you know, have got sworn pleadings, you go to a grand jury, you get a grand jury subpoena, you get a search warrant of the home, and the writing is on the wall. I mean, you know, the second you get those computers with someone that's that arrogant, you have to talk peak of arrogance when you are in a hotel physically assaulting a woman, throwing, pushing, shoving, dragging, kicking, knowing you're on security camera. You are the peak of arrogance. So the prosecutor announced charges against Diddy this week. He was arrested and taken into custody. And we've got an indictment. The indictment reads like a terrible, terrible thing.
It reads, yeah, it's basically a horror movie.
You got to appreciate a prosecutor that puts this much in the first sentence. For decades, Sean Combs, aka we're just going to call him Diddy, the defendant abused, threatened, and coerced women and others around him to fulfill his sexual desires, protect his reputation, and conceal his conduct. To do so, Combs relied on the employees, resources, and influence of the multifaceted business empire that he had led and controlled. That's a tip-off that there are more indictments coming, by the way. Creating a criminal enterprise, another tip-off that more indictments are coming, whose members and associates engaged in and attempted to engage in, among other crimes, sex trafficking, forced labor, kidnapping, arson, bribery, and obstruction of justice. All the bad.
I feel like this last one is like, oh, now the obstruction of justice is actually a huge deal
It's a
here.
big charge.
Just normally obstruction of justice can be pretty minor, because obstruction of justice can be anything from, like, the cop asked you for your ID and you told him, or asked you for your name and you said, oh, I'm, Bob Jorgensen. And he's like, no, you're not.
But in this case, it's not. In this case, it's witness intimidation.
And it's also what gets him denied bail.
Yes. And properly so.
Oh, absolutely. I mean, I think he should be denied, like, every day and twice on Sunday, right? So this one is just obviously a case for denial. But yeah.
So at all times relevant to this indictment, Diddy engaged in a persistent and pervasive pattern of abuse towards women and other individuals. This abuse was at times verbal, emotional, physical, and sexual. As a part of this pattern of abuse, Combs manipulated women to participate in highly orchestrated performances of sexual activity with male commercial sex workers. At times, Combs and others acting at his direction made arrangements for women and commercial sex workers to fly to Combs' location. Combs ensured, that's the trafficking part. Combs ensured participation from the women by, among other things, obtaining and distributing narcotics to them, controlling their careers, leveraging his financial support, and threatening to cut off the same, and using intimidation and violence. Physical abuse was recurrent and widely known on numerous occasions from at least in or about 2009 and continuing for years. Go ahead.
Do you feel like the DA is kind of telling on themselves here? They're like, the abuse was widely known. It's like, and it took you from 2009 to get him.
It's a bit.
It's like, whenever people are like, why don't women call the police? It's like, well, because, they're not always all that good.
Yeah. Yeah. On numerous occasions, from at least in or about 2009 and continuing for years, Combs assaulted women by, among other things, striking, punching, dragging, throwing objects at, and kicking them. These assaults were at times witnessed by others and included one instance at a Los Angeles hotel We've seen that video in or about March 2016, which was captured on video and later publicly reported, where Combs kicked, dragged, and threw a vase at a woman as she was attempting to leave. When a member of the hotel security staff intervened, Combs attempted to bribe the staff member to ensure silence. That's the obstruction part. Combs' violence was also not limited to these women. It extended to his employees, witnesses, to his abuse, and to others. Combs used the Combs business to include certain employees to carry out, facilitate, and cover up his abuse and commercial sex. Those employees, including security staff, household staff, personal assistants, and high-ranking supervisors, and other close associates, acted as Combs' intermediaries, and their conduct was facilitated and assisted by Combs' control of the business. The DA was very smart in drafting this indictment, almost like, so you don't need to go into this level of detail to bring these charges. You do this because you are teeing it up on, I mean, the DA knew that the big issue was bail before they filed the indictment, before they brought the indictment. Because what the DA lays out here, the employees, the hotel staff, personal assistants, high-ranking supervisors, and other close associates, their conduct was facilitated and assisted by Combs. They're bringing up here that if you allow him to be out on bail, you can't just monitor him. There's a whole network. You cannot allow him to be out and orchestrating a network of people that could be obstructing justice or obstructing their witness testimony, etc. So other members of the enterprise engaged in, among other activities, sex trafficking, forced labor, interstate transportation for purposes of prostitution, coercion, and enticement to engage in prostitution, narcotics offenses, kidnapping, arson, bribery, and obstruction. Wait, arson?
Yeah, he set fire to someone's car.
Oh.
The allegation is that he went up to somebody's car, used a knife to cut open the the convertible top, and then dropped a Molotov cocktail in there.
That's a very specific allegation. I imagine they have a witness several witnesses are going to testify to that exact fact.
Yeah, I suspect that just about everybody in his circle right now, I suspect that a lot of them are being brought into rooms going, so we got 100 people. We got 50 deals.
Yeah. Does this sound familiar at all to when we were talking about SBF, right? Where Caroline Ellison suddenly became very quiet and Sam Bankman-Fried was talking and we were just going, they're all cutting deals. Everyone is cutting deals. They're begging for deals and they're willing to say damn near anything on these deals. So,
yep.
Diddy's left stranded. Wait, it was Kid
And
Cudi's
the other
car?
thing is, now that he's in custody, he has no way of he's got no way of like trying to keep everyone in line, which is what he very much wanted to do.
No, he can't make threats. That's the point.
Exactly.
Can't make threats, can't carry him out. God, this is a house of cards that is just like stacked perfectly. Like this is, oh, there's a whole lot of hurt coming this person's way. Let me see. Enterprise constitutes an ongoing organization whose members function as a continuing unit for a common purpose of achieving the objectives of the CONSTRUED. So that's the RICO. That's a conspiracy. At all times relevant to the indictment. Who was the leader of the enterprise? Okay. Participated in unlawful activities related to the conduct of the Combs Enterprise Affairs. I'm going through the indictment quickly because I think the bail issue was far more interesting to me. We knew that all of this was coming. You just knew it was coming. Lifestyle, power, personal desires. I mean, the DA is hitting all the points here. Acts of violence, interstate transportation, securing absolute loyalty from members. That's for the bond issue and for the obstruction charge. Protecting the Combs Enterprise and its members from associates, including Combs, from detection and prosecution by law enforcement authorities through acts of intimidation, manipulation, bribery, and threats of retaliation against individuals who witnessed the crimes. That's the obstruction charge. Means and methods. would bring them into the orbit under the pretense of a romantic relationship, then would use force, threats of force, and coercion. That's a reference directly from the statute, I think. Force, threats of force, and coercion to cause victims to engage in extended sex acts with male commercial sex workers. Freak-offs. The freak-offs were elaborate and produced sex performances that Combs arranged, directed, there's the word, masturbated during,
Yep.
and often
Oh,
electronically
yeah.
recorded.
When that word came up, I was just like, I'm going to skip over this word because somebody's going to clip it.
In arranging these freak-offs, Combs, with the assistance of members and associates of the Combs enterprise, transported and caused to be transported commercial sex workers across state lines and internationally. Well, that's a problem for you, Mr. Combs. Freak-offs occurred regularly, sometimes lasting multiple days, and often involved multiple commercial sex workers. During freak-offs, Combs distributed a variety of controlled substances to victims, in part to keep the victims obedient and compliant. Sometimes unbeknownst to the victims, Combs kept videos he filmed of victims engaging in sex acts with commercial sex workers. After freak-offs, Combs and the victims typically received IV fluids to recover from the physical exertion. And drug use. Well, business employees facilitated it by booking hotel rooms, stocking the hotel rooms in advance with the required freak-off supplies. Do you think there was a shopping list? There had to have been a shopping list.
Oh, there's got to have been shopping lists, and somebody out there still has one on their phone,
It's
like a
gotta be
text
there.
message that says, please buy
Don't forget the
12 gallons of baby oil, 6 bottles of this brand of lube, 1 novelty size dildo, the one the size of the
Make sure
one
it's
modeled
red.
after Mike Tyson's
Make sure it's the
fist.
red, not purple.
We also need the live goat and 42
God.
spoons and
Just listen to this. Controlled substances, baby oils, lubricant, extra linens, and lighting. Cleaning the hotel rooms after to try to mitigate room damage, arranging for travel for victims, commercial sex workers, and Combs to and from, resupplying Combs with requested supplies, delivering large sums of cash to Combs to pay the commercial sex workers, and scheduling delivery of IV fluids. This is the part that everyone's been talking about. In around March of 2024, we covered this. During searches of Combs' residences in Miami, Florida, and Los Angeles, law enforcement seized various freak-off supplies, including narcotics and more than 1,000 bottles of baby oil and lubricant.
I like how they separate those things out. Like baby oil isn't itself a lubricant.
But are they 1,000 little bottles, or are they 1,000 commercial size
I am
bottles?
thinking that they are the size of my vodka bottle here.
Kind of where my head was. It's just kind of troubling to even comprehend. Did he have a container, like a shipping container at one of the houses with did they have a big label out front of it saying freak off supplies, just across of it?
I'm just picturing a helicopter flies up and sets down a crate out of some old military movie where it's a resupply of ammo and it just drops in.
Parachute.
There's the parachute on it.
It'd be better if it was just a pallet wrapped in plastic so you can see the bottles.
I mean, this is all terrible, but
it's terrible, but you have to, you can't.
You got to laugh because otherwise you just go insane, right?
Oh my God. That's so great. So there's a comedian that does a joke about his daughter finding a bottle of this substance, lubricant, in their drawer. He says, the 6-year-old daughter walked up to him and says, "Daddy, what's lubricant?" And Daddy says, "Yes."
That's terrible, Rob.
It's not my joke. It's someone else's joke, but it made me laugh because I'm immature.
Jesus. Oh.
It's the only part of this complaint that you can laugh at. The materials.
Yeah. You can also laugh at the fact that like Diddy is in jail right now. I feel like that is entertaining.
It is. That's why I like folks in the bond hearing, because it's also why. It's terrible. So Combs maintained control of the victims through, among other things, physical violence, promises of career opportunities, granting and threatening to withhold financial support, and by other coercive means, including tracking their whereabouts, dictating the victim's appearance, monitoring their medical records. Well, that's controlling their housing and supplying them with controlled substances. During and separate from freak-offs, Combs, among other things, kicked, threw objects at, and dragged victims at times by the hair. Assaults often resulted in injuries that took days or weeks to heal. Threatened their careers and livelihoods, including if they resisted participating in freak-offs.
Can I show you something less horrific than this?
Yes, you may. He used the embarrassing and recordings. So he used the recordings as collateral to ensure their continued obedience. Of course he did. Of course he did.
Here's something less horrific than this.
Please. That is less horrific than that. Is that the orange CZ?
That is not. That is
Dummy?
that is not an actual gun. It shoots little ceramic balls or pepper balls, except the pepper balls are illegal in Canada. So yeah, I'm doing testing of whether or not it counts as a firearm legally in Canada.
Well, I see you're putting the skull to good use.
Oh yeah. I've been through, this is like the third skull.
Yeah. It's less creepy than I thought it was going to be.
I'm just going through videos and I was like, oh, right. Yep. All right. So back to that.
Back to the terrible. So career opportunities, financial manipulation, prevented victims from leaving locations. So false imprisonment. Victim was required to remain in hiding, sometimes for several days at a time, to recover from injuries inflicted without being publicly observed. Members and associates helped assist. One of them is facing charges at some point. Reputational harm. So you just basically get the premise of terrible human racketeering.
I'm not sure I'd agree. I agree with the terrible part. It's the human part that
that's fair.
That's where I've got some differentiation. So
this is, I mean, all of it, man. Combining, so this is the racketeering, this is the RICO issue. Enterprise engaged in and the activities of which affected interstate and foreign commerce, knowingly combined, conspired, confederated, and agreed together with each other to violate the racketeering laws of the U.S. Kidnapping, multiple acts involving kidnapping, chargeable under the following provisions of state law. Multiple acts involving arson, chargeable under the following provisions of state law. Multiple acts involving bribery, multiple acts indictable under Title 18 USC, Section 1512, tampering with a witness.
You know what the minimum punishment if he's convicted on all of this is?
Isn't it 60?
The minimum is 15. That's the minimum.
That's the minimum. But some of these carry, I mean, he's got 30 to 60 is what I was seeing as being the predominant for all these things.
Yeah. Oh, I mean, the maximum is life.
Yeah. Drugs. Notice a special sentencing factor. Ah, there it is. Force
And
threats
for the
force
folks
fraud.
who
There it is.
for the folks who aren't really aware, anytime you have something special in like a special sentencing factor,
Which is not a good thing.
it's not good. It's not like, ooh, a special surprise, or something like that. It's yeah. It's bad.
Yeah. Uh-huh. Sex trafficking by force, fraud, and coercion. He's fucked. This is the sex trafficking charge.
Yeah.
Transportation to engage in prostitution.
Yeah, in terms of the law, state lines can be magical boundaries that result in massive increases in sentence.
Here's the government's favorite thing to do that causes a lot of pain. Forfeiture allegations. As
Oh,
a
yeah, they
result
wanna
of
take all his
committing
money.
the offense. Oh, they're going to take all his shit. As a result of committing the offense alleged in count 1 of the indictment, the defendant shall forfeit to the United States pursuant to Title 18, Section 18 U.S.C. Section 1963, any and all interest the defendant acquired or maintained in violation of Title 18 U.S.C. Section 1962. So basically, all proceeds traceable to any of these offenses whatsoever, directly or indirectly, are forfeited. Which means that if you can cause some arguable connection to his money, it's coming to the United States. Wow. This is going to be a whole ass thing. Okay, so Diddy is
done.
He's so screwed. So the U.S. in anticipation, after the arrest was made, before a motion, I think this is before the motion for bond was filed. Where was the motion for bond? Where's the motion for bond? Letter RE bail. That's the bail appeal. Diddy letter RE bond. Where was that one? That was September 17th. So these letters come in same date. So Diddy files this letter requesting bond. Bail. Interchangeably. Mr. Sean Combs, through his counsel, submits this letter to the court for release on certain specified conditions. Yesterday evening, Mr. Combs was arrested on an indictment charging him with the following offenses. All.
Now, did he put the letter in first or did the state?
I thought the state did. Hang on.
I thought the state did.
The state did. Yeah, because the state, they addressed that in their letter. Hang on. There. The defendant, Sean Combs, was taken into custody this morning after a grand jury sitting in this district returned a 3-count indictment charging him with crimes related to his decades-long pattern of physical and sexual violence against multiple victims and his use of force, threats, and coercion to enact his will, protect his reputation, fulfill his sexual desires. There it is. The government respectfully submits this letter in anticipation of the defendant's appearance before this court later today and in support of the government's request for the defendant's detention pending trial. Like I said, that indictment reads as if it is aimed at securing pretrial detention. They absolutely know that the pressure on Diddy to start talking increases exponentially if they can keep him detained. And they want not just Diddy, they want the whole damn network. They want all of it.
But the thing is I don't think they've got a lot to offer him to talk.
No. But the other thing is if you keep him in isolation, you scare the shit out of everyone else about what he might be talking about. So you have everyone else coming forward.
Well, the other thing is you can also keep Diddy scared shitless about what everyone else might be talking about.
Exactly. So you keep them in isolation. Now you have, you have
the other lovely thing. What do you want to bet that he Hannah Gutierrez is himself?
You mean voluntarily speaks stupidly and his lawyer lets him?
I mean that he gets on the jailhouse phone. and starts saying the dumb things.
Oh, please. You would expect that there's no way he's that dumb.
I mean, $5.
I don't know.
I
don't know, because I imagine he's going to try and come up with some type of code.
see. This is the thing: is you're not sufficiently sure that he's not that dumb.
It's not that. Here's the thing. It's the Alicia makes the comment. Not that dumb, but yes, that cocky. I don't know if he's that cocky.
I could really see him.
I could too.
So, yeah.
So here's the thing. The government comes in immediately. As set forth below, there's no condition or combination of conditions that will reasonably assure the appearance of the defendant as required for the safety is required and the safety of others in the community, not to mention the integrity of the proceedings. Basically, they're saying, Judge, there's nothing you can do in pretrial release that will guarantee that this case is not fucked.
You know, the other thing I really want to see, have you ever seen like the pictures of rappers like just sitting on like giant stacks of cash?
Yeah.
I want to see that picture of Diddy, but it's all like ramen noodles.
I don't care what it is. It could be, I want to see that picture of Diddy, not just ramen noodles. It could be a bed of nails. So here's the thing. Serious risk of flight.
Being king of the ramen noodles.
Serious risk of flight. Yeah, the dude has his own damn private jets. Now they can seize it. He can turn it over, but he still has resources to get out of there. Most glaringly,
He
also
says he's going to sell his private jet.
And with the proceeds from the sale of that private jet, hire someone else to fly him somewhere.
I mean, the thing is he could go and Sarah Boone himself with a friend of his and just fly his luggage.
Yeah, but it's this. That was creepy. But yeah, poses a significant risk of obstructing justice. Yeah, that's the part that the judge sticks with. As set forth below, during the course of the charged conduct, the defendant has attempted to bribe security staff and threatened to interfere with witnesses to his criminal conduct. He already tried to obstruct the government's investigation of this case, repeatedly contacting victims and witnesses and feeding them false narratives of events. You know what's a really good way of getting yourself detained pre-trial? Reaching out to people that are speaking to the government.
Yup.
We don't have to go through the indictment. We went through that and all the other stuff. They attempted to leave the hotel, all the above.
I would like to make an offer on his jet. I will give him $500 for the jet. And the reason why is because the jet is probably worth millions, but I have to deduct for the cleaning costs. And the cleaning costs are all the rest of that money. The gap between millions and $500 is cleaning costs. Tell me I'm wrong.
You're probably right. I think 500 might be light for the cleaning costs. You have an allegation of him and a co-conspirator kidnapping an individual at gunpoint to facilitate breaking into and entering a residence of another. Wow. 2 weeks later, co-conspirators set fire to individual. Oh, so this is Kid Cudi's car.
Yep.
Since 2008, defendant's physical abuse of women and others have been publicly reported in the media. And why are these the first fucking charges we've seen? That's the part that pisses me off.
Mm-hmm.
You knew this was there. You were too afraid of him.
And too freaking lazy.
Yeah, didn't he have a couple of guns in the house that had the serial numbers filed?
Yep.
Yeah, there it is. Yeah, it's pictured below in a close-up image. The serial number of one of the AR-15s is visibly bored through and obscured. Yep. Two
That
of the
said,
3D
that
faced
looks
AR-15s.
that looks restorable to me.
Yeah. Broken down into parts along with ammunition is depicted below. One of the AR-15 10-round magazine loaded 10 rounds of large caliber. That's dumb. That's the government trying to say scary gun scary. A drum mag. Interesting. 6 with serial numbers. Oh, some of those firearms are licensed to Combs' staff. Well, that's stupid. That's dumb. Don't hold other people's guns. Just as a general piece of advice.
Unless you're like at the range.
Correct. Coercion fostered culture of fear. Bribed witnesses and obstructed justice. So this was the hotel incident. Hotel security staff intervened. The defendant attempted to offer the security officer a stack of cash to ensure his silence. He refused the bribe, and after coordination between the defendant and his employees, the defendant's staff contacted other members of hotel security. At the same time, they were in close communication with the victims of the assault as well, all in an effort to cover up the defendant's assault and to prevent the incident from being publicly disclosed. Within days of the incident, the surveillance video disappeared from the hotel server. That rings all the fire alarms for the judge, all of them. And it's not so much what Diddy did; it's the other members of his staff, defense staff. Late 2023. Oh, that's close in time. Immediately following public allegations of certain defendants' crimes, including his physical and sexual abuse of women, the defendant and other members of the enterprise made repeated phone calls to victims and witnesses, during which they provided victims and witnesses with false narratives of events in an apparent effort to conceal the defendant's crimes. On at least 2 occasions, the defendant recorded those calls with the co-conspirator's cell phone, thereby attempting to obscure his involvement in the obstruction. All right, so applicable law, they go through this, about everything else, discussion, dangerousness. Yes, he's charged with all these crimes. We can clear that he's dangerous. There's a risk of flight. The intimidation factor is there. Contacting the witnesses was probably the dumbest thing he could possibly do. The obstruction charges. This little lovely key there, as detailed in the indictment, you knew that this was going to be the big ticket item they were fighting for. And by the way, that force that in the indictment, where is it? This language. This language, the sex trafficking, the force, fraud, and coercion, that's what flips the burden to him.
Yep.
To prove that pretrial detention is not required. So what does he say in response? Mr. Sean Combs, through his counsel, submits a letter to the court for release on certain specified conditions. Letter will walk the court through a series of actions taken by Mr. Combs over the past 6 months that prove he's not a risk of flight or a danger to anyone in the community. You know what? You have to give it to the lawyer for putting together his best shot at this.
They're going to take all his money.
I think they are. I don't blame them. Where is it? These actions prove that Mr. Combs is eminently trustworthy. He's demonstrably committed to showing his innocence in court. In the context of this case. Okay. How about no? First thing the court should know is that when it became apparent to his counsel that Mr. Combs would at some point soon be formally charged, he did something extraordinary. He
See,
left his
all of
home
this
in
tells
Miami.
me that his lawyer should get bail and that he should be detained.
This lawyer's good. The lawyer's solid. It's just
Oh yeah.
you don't have anything to work with. First thing, so he left his home in Miami and traveled to New York, the very location of the prosecutors and agents investigating him. Through counsel, Mr. Combs promptly told the government that he had voluntarily come to New York, offered to tell them specifically where he was, and offered to turn himself in at the appropriate time. You know, that is more to avoid the circumstance of SWAT coming and breaking down your door than anything else. And yes, to show cooperation. Even though Mr.
But
Combs came to New
also,
York.
yeah, I mean, a large portion of that is that you just want to avoid,
SWAT breaking
yeah.
down your door. Yeah, you don't want the feds knocking on your door, the FBI knocking on your door and forcing their entry to your home and taking it. Because here's the thing.
You also don't want the perp walk.
The FBI, because the FBI in their indictment and in the evidence they have, they already know there's guns with serial numbers scratched off. There's other firearms that are owned by other people. There's security staff that's on site with firearms. You don't think that they're going in there hot? Like if they're making that arrest and he's not voluntarily surrendering? I mean, that's a no-knock warrant. This, we know, is the government's right. However, the travel to New York self-surrender is also something the court should consider. Not the first action he took to show his trustworthiness and lack of flight risk. Indeed, is part of the pattern since before, March of 2024, searches on the homes. Mr. Combs and his counsel have been fully aware that the United States Attorney for the Southern District of New York has been conducting an investigation involving allegations concerning racketeering and sex trafficking. Really? How did you know about their investigation? Is it possibly because you were contacting witnesses and saying who you talking to and what you're doing? Knowing for these many months that he would be indicted, Mr. Combs has done everything, as we set out below, to work with prosecutors in a way that are unusual, if not unprecedented. The proposed package. This is what he wants. Bail. He wants $50 million bond, co-signed by Sean Combs, his mother, his sister, the mother of his oldest daughter, and his 3 adult sons. Secured by the equity in Mr. Combs' residence located at the West Star Island in Miami. Appraised value of the home is $48 million. The home is unencumbered in anticipation of bail. On August 20th, he paid off the remaining mortgage of about $18 million so the home could be used to secure a bond and be free of a mortgage. U.S. government's like, that's a lovely forfeited item now.
Yep.
Mom's home goes up as collateral. Travel restricted to Southern District of Florida and Southern District of New York. So he wants to be back in Miami at the home. Passport surrendered. Already surrendered to the counsel. Counsel advised prosecutors this fact in an email directly the same day. Provide passport to pretrial services. Passports to the following family members who have already surrendered their passports to counsel after the raids on Mr. Combs' homes. I will tell you, this damn attorney is pulling his fucking weight. He is doing his damnedest. He got Combs to surrender his passport. He got the family to surrender their passport. He gets mom to put up collateral on the house. He gets the sons to sign the bond. He gets everything. This lawyer is just
he put the work in.
Making efforts to sell the airplane. We informed the government of these efforts in May of 2024. As explained further below, just this weekend, Mr. Combs entered into a letter of intent with the party to sell it. He understands not to travel to LA, where the plane has been located this week, and further, the plane is not to be brought to any district in which he is located until it's sold. That's a smart paragraph. That is so smart. Yep. Home detention with GPS monitoring. All other standard conditions of pretrial supervision. I mean, God, I appreciate the hell out of the lawyer trying his hardest.
The thing is, I was a little on board right up until I saw the response, like the state's position, I think, does some real damage to this.
You mean the next one, the letter on the appeal?
Yeah, they trounce him.
Now, the nice thing, this when the lawyer filed this letter, he attached 12 exhibits that show the lien being discharged, that shows the valuation of the home with an appraisal. It literally goes through. I mean, this was the best shot I think he ever had at bail.
Yeah. Oh, yeah, absolutely.
Assistance to the government concerning the subpoenas. The lawyers assisting with serving of the subpoenas.
And be right back.
Paying off the mortgage, the legal standards. So there it goes, yada, yada. They argue back and forth. Lawyers basically saying, give me, oh no. Mr. Holmes's history and characteristics are best demonstrated by the way he has responded to this investigation from the very inception. Nope. You see, you're kind of glossing over years of bad decisions and bad behavior. He's never run from a challenge and will not run from this case. That's an interesting choice of words. Instead, he takes these challenges head on. He moves forward toward them confidently and with assurance that right is on his side. Well, the actions of Mr. Combs over the last several months conclusively prove this. Okay. I don't know if I agree with that. Oh, we're going to rely on philanthropy and education. That's what we're going to do. Generously given to charitable causes. You know what that doesn't excuse? Any of that other shit. Oh, sweet. He supported organizations including the National Foundation for Teaching Entrepreneurship, further emphasizing his dedication to creating opportunities for young entrepreneurs. Well, what we just read in the indictment is that you promised to create opportunities for young entrepreneurs and then also use those promises to get them into a situation where you were feeding them illegal narcotics and pressuring them to do other stuff that they didn't want to do. So I think this argument here is not going how you think it would be. He's also been proactive in health and disaster relief efforts. Oh, fuck off. $2 million in New York City public schools. $4 million to provide personal protective equipment to healthcare workers in the front line. Oh my God. He created the vote or die slogan through Citizen Change, which, oh my God, this is so stupid.
I would have left that slogan out.
I would have left a lot of stuff out. He goes in
Like-
here. Look at this. This part here. Further emphasizing his dedication to creating opportunities for young entrepreneurs. Did you not read the indictment, my guy?
Yeah, I mean, they're just going to say this is fucking grooming, sir.
Yeah.
Like, sure, you were creating opportunities to groom
You were
people
creating
into
opportunities.
horrible, horrific shit. Yeah, I think the prosecution dunked on him less than they could have, because I would have dunked on that hard. Yeah.
Few
I did
people have
not
done more to
like
advance the
that.
cause of Black people in the music, entertainment, and fashion industries than has Sean Combs. You know what else doesn't advance the cause of Black people or any people?
Freak offs?
That and every single fucking element involved in that. Trafficking, minimizing, degrading, treating people like property and not like they're actual humans, which is what freak offs, what the definition, that's what it was.
Yep. I feel like, there should be a fire and he should be thrown into it. I don't know.
Oh, look, he supported women-owned businesses, Ian.
I bet he did. Did he only buy his large quantities of baby oil from women-owned businesses? Is that what he means?
I don't know what the fuck he did. You remember, what's funny? This is the same court as Sam Bankman-Fried was tried in. Different judge, same court.
Oh, I'm
I'm
sad that it's not the same judge.
I know, but do you know how well Sam Bankman-Fried's argument of look at all the charitable things I've done and look at how I'm just a lowly individual that does a lot of very good thing, effective altruism and all the above that I'm doing. How did that play for Sam Bankman-Fried?
I seem to recall that he was released without charges and was also given a puppy. No,
No, it wasn't that way. It wasn't. He was released with certain conditions. They gave him a leash and a collar, and they said, "Be good and don't do anything stupid." And Sam Bankman-Fried proceeded to do stupid things, and he played a game of fuck around and find out. So the court gave a little bit of care, and the court was like, we're gonna give your argument and give your statements here. We're gonna give you a little bit of rope. How much you want?
Like about what, 3 foot drop?
No, I'd say 12 feet. 12 feet should do. You can properly tie something with that. But here's the thing. In Sam Bankman-Fried's case, I'm actually willing to bet that the district attorney's office for the Southern District of New York learned a lesson from SBF, which is why their indictment in this case focused so heavily on the obstruction issues. I think if the Southern District of Attorney's office, Southern District of New York, if their DA's office had an opportunity to do Sam Bankman-Fried's case over again, they would have brought an
I'm
indictment.
glad you included the word case.
Yes. Their indictment would have read a lot more closely to this and conduct that he engaged in to manipulate other potential witnesses, because I think they would have gotten to that point for pretrial detention earlier. So I think this is a learning thing. So you actually see adjustment from the attorney's office here.
They're learning.
They are.
It's a learning monkey.
Sean Combs has never evaded, avoided, eluded, or run from a challenge in his life.
Yeah, no, when he sees the challenge of a woman getting away from one of his freak offs, he gets right in there, fists swinging.
Oh, when he sees the challenge of a woman running away, he runs towards that woman to chase them down in a hotel room or a hotel hallway. He has handled every hardship. He will meet this case head on. Here's the thing. A lot of this whole we have all seen the video. The hotel video. We've all seen the video. That one action is so inexcusable, so egregious in that one video. And there's no denial that it's him. And there's no explanation as to what, there's honestly no justification for that behavior whatsoever. You could not put anything, you could not tell me anything that would justify what he did in that. And I think that saying that video is there, but then saying, oh, but look at all the good things he does for the community. But how do you get past the fucking... He will work hard to defend himself, and he will prevail. If you believe that, I've got a bridge in Brooklyn to sell you.
Maybe he's just got a different definition of prevail. Like, by prevail, he means he's going to continue to be able to have freak-offs. They're just going to be of a very different sort. Maybe they steal some canola oil out of the kitchen.
To defend an eminently defensible case.
The
fuck are you talking about? What are you talking about? Please don't detain him at this place where everyone else is being detained, at the MDC, which is where Sam Bankman-Fried was detained, at the Metropolitan Detention Center in Brooklyn. They're not fit for pretrial detention. Well, it worked just fine with Sam Bankman-Fried.
I mean, the thing is, the MDC does suck. I get that. But I do kind of hate the argument that it's like, now that he has money, it's, you know, it's good for all the poor people, but not my moneyed client who is used to like caviar and like somebody to fluff his pillow and freak off. I mean, nope, not freak offs. I didn't mean to say that, you know, like, yeah, nope. I got mic issues. 1 second. I'll sort that out.
It's just terrible. It's the stupidest argument in the world, like to make this argument about the MDC. So it's fine for everyone else. Yes, it sucks for regular ass people too. It absolutely does. You don't get special treatment, sir. Especially not on these allegations. Like, I did great, therefore put me in a nice wing of the prison because I did good things while I also beat these other people.
I'm fine with giving him special treatment in prison. In the same way of the special sentencing. Yes.
Special sentencing enhancement.
Exactly. That kind of special I'm down for.
Ian, I'm gonna blow this up. I need a second here though.
All right.
Here's the responsive letter.
You need me to read it?
If you wouldn't mind.
The government respectfully submits this letter in advance of the bail appeal by defendant Sean Combs, aka all the things, including love. Yeah, that is special. For the reasons set forth below and in the government's September 17th detention letter and argument before the magistrate court, the defendant presents a danger to victims and others, both through physical violence and through obstructive conduct, and a risk of flight. He must be detained. Additional background. The relevant factual background is set forth in detail in the September 17th letter and incorporated by reference herein. The defendant was arrested on September 16th and arraigned on September 17th before the Honorable Robin F. Tarnofsky, United States Magistrate Judge. Following arraignment, the government sought the defendant's detention on 3 grounds: dangerousness, obstruction, and risk of flight. Pretrial services similarly recommended detention for the defendant. I understand that their statement was not so much a recommendation of detention. It was just like 30 minutes of screaming into a microphone. But yes. You want to take over?
Yeah. So after an extended bail argument, the court found the defendant had failed to rebut the presumption of detention in this case. Judge Tarnofsky noted that the crime of sex trafficking is a crime that happens behind closed doors and expressed concern that such conduct could not be monitored by pretrial services. The court further found that detention was warranted based on the defendant's history and characteristics. There are also indications, so this is a quote from the judge's findings and judge's ruling. There are also indications in your history and characteristics that I think are a reason why the presumption in favor of detention has not been rebutted. Prior substance abuse and the fact that the alleged violence seems to occur hand in hand with times when you are not necessarily in control of your actions because of that substance abuse. Your lawyer asked me to trust you and to trust him, and I don't know that I think you can trust yourself. And I don't believe that counsel has the ability to control you, given the very significant concerns I have, particularly because substance abuse and what seem like anger issues. I would say anger issues is putting it lightly, Judge.
I mean, I would be telling him to go trust himself.
Trust yourself that you can fly when you jump off of a very tall building. It's a bad
Or a
joke.
very
It's-
short building into like very tall rats or spikes. Yeah.
In addition, the court noted the weight of the evidence is significant, given that the government has proffered that there are multiple witnesses who are saying that they have witnessed significant serious violence. Finally, the court concluded that the danger posed by the defendant was quite serious due to the defendant's access to weapons, use of violence, and coercion of witnesses. This court should reach the same conclusions. Judge Tarnowski's findings are well supported by the record before the court today and demonstrate why the presumption of detention is not rebutted in this case. Moreover, defense counsel's most recent letter fails to seriously contend with the findings, most glaringly related to defendant's unpredictable dangerousness and inability to be monitored or controlled. Go back to how that indictment was drafted, guys. It was very, very well drafted. The defendant poses a significant and ongoing danger. Despite public statements by counsel minimizing the defense conduct, both to Judge Tarnowski and to the media, oh shit. See CNN interview, of course. Combs' attorney, whether Starr was surprised by his arrest. Ruh-roh. Counts 1 and 2 of the indictment, among other crimes, the defendant used violence, threats of violence, and coercion to cause women to engage in commercial sex acts. In other words, the defendant committed sex trafficking, a crime so serious that Congress has determined that there is a presumptively no condition or combination of conditions that will reasonably assure the safety of the community and the defendant's appearance in court. That charge, that one charge is so significant. And this other part is something I think that the court should weigh. If it was me, the crimes have also spanned over a decade. So the fact that that spanned over that amount of time and continued through this year, I mean, it kind of demonstrates that he doesn't respect anything, Judge. He's been doing it for so long, there's no way. The nature of the offenses and defense history and characteristics demonstrate that the danger he poses and weigh heavily in favor of detention. The defendant's repeated acts of domestic violence, which are recurrent and, as noted by Judge Tarnowski, often occur behind closed doors, are not disconnected to the offense conduct. They are an element of it. The physical force and coercion the defendant repeatedly used during and apart from freak-offs caused victims to engage in this sexual activity. That is sex trafficking. This DA is solid. I like this writing. You know, that defense counsel might have had a shot against a DA that wasn't this. Well, I mean, I see what you mean, though, about leaving points on the leaving things off the board, though. Like, this could have been a more aggressively written.
I mean, I think that he's being gentle because he knows, yeah. This is don't spike the football.
Yep. So these acts are not corroborated not only through victim testimony, so this is a preview here, but also through, among other things, victim communications with the defendant spanning years, oh my God, of the charged time period. Witness testimony, video footage, photographs capturing injuries, and law enforcement records, among other things. The same is true of defendant's coercion. The communication between defendants and multiple victims, which include communications sent as recently as this year, capture victim resistance to engaging in freak-offs, even in light of defendant's abusive tactics. The defendant's years-long use of force and coercion speaks directly to dangerousness. When was the Cassie lawsuit filed?
Earlier this year, I think, like January or February this year.
November of 2023.
Oh, okay. So like a year ago, almost exactly, almost.
All right. Are you fucking telling me that lawsuit was filed November of 2023 and this asshole decided it was a good idea to have freak offs after that fucking lawsuit got filed?
I mean, how do I put this? I very strongly suspect that nothing else works his dick.
Holy shit.
So, yeah. Rob's like, and you said that. Okay.
No, I'm like, it's just, I understand what you're saying. I'm not actually mad about it. I'm more mad at the other fucking thing. You're telling me that you get that lawsuit, and that lawsuit, which literally reads like a damn indictment. I mean, that thing was. You settle
I
it
think
the
he
next day.
thought that nobody would ever say shit about it. And also he I really suspect that that it is meeting some psychological need for him, that having been used to it for however long, he probably doesn't consider himself able to be without. So I think prison's going to be interesting for him, or jail's going to be interesting for him, and I wish him all the interesting. I wish him all the interesting.
It has to be that he settled a lawsuit, and he thought it was a lawsuit. He expected additional lawsuits, but even if you're expecting additional lawsuits, why are you doing any of the fucking freakouts? Why are you texting about the freakouts? Why are you doing this other shit? Shut the fuck up. Like, just, it's Friday. It's a good time for it. Shut the fuck up, Friday.
It's always a good day for shut the fuck up.
It is. So you're sitting there and you get the lawsuit, and you had to imagine that there are people in his inner circle that have half a brain. They're lawyers, or someone is contacting him.
They're not in charge.
And honestly, I know they're not in charge, but they're contacting him. They're saying, hey, so here's the thing. That lawsuit was a public filing. Funny thing about public filings, the public can see them, like DAs everywhere. So I know that you might not have been a very good boy in the past, but you are going to be on the straight and narrow, and you ain't going to do this shit anymore.
I mean, personally, if I was Diddy and that lawsuit had been filed, I would have been like hiring a lawyer to be like, I need a list of non-extradition countries where I can buy a citizenship.
Yeah, where do they not extradite from? Because I'm looking at plane tickets.
And I need to be able to buy a citizenship right now. So like where will take like $5 million in a briefcase to, make me a citizen, and I'm gone there. And you know what? He lives the rest of his life in exile, and that's better than where he's likely looking at the rest of his life. So, yep.
To be clear,
I'm not recommending this. I'm just saying.
No. I was going back to reading.
Yeah.
To be clear, despite the indictment naming one victim in count 2, this case is not about just one victim. The government's evidence to date. Oh shit, this is about to be good.
Oh yeah, this is we got more.
Yep. The government's evidence to date, including the defendant's own communications, great highlight, demonstrates that the defendant has used force and coercion against multiple victims. In addition to these women, the defendant has assaulted a host of other individuals, including his employees and witnesses to his violence. For example, the defendant directed his rage towards his employees and those close to victim 1, who had seen him physically abuse victim 1, including by throwing these witnesses against walls and onto the ground, choking them and throwing objects at them, among other things, particularly when they attempted
how
to
much
protect
meth did he have to be on to?
The level of violence that is described here is pretty fucking scary. In doing so, the defendant has demonstrated that he is not only a danger to victims and witnesses, but is also obstructive and willing to engage whatever is necessary, including physical violence to instill fear in witnesses to keep them silent. All of this violence against victims, witnesses, and others factors into the analysis of the defendant's dangerousness. The defendant has consistently obstructed justice. Equally, as outlined in the government's December 17th letter, he poses a significant risk of obstruction. The argument that his recent contacts with witnesses to the charged conduct should not be considered obstruction because he was unaware of the government's investigation simply cannot be credited. That was what I said when we read that sentence. Like, are you fucking kidding me? The defendant has been aware of the government's investigation of this case since at least on or about January of 2024. And yet, he continued to have freak-offs. What the fuck? And even earlier, directed the following to filing of a civil lawsuit in November 2023. The defendant was aware of the potential for criminal charges. Or directly following, yes, exactly. Nevertheless, since that time, the defendant has continued his long-standing pattern of engaging in obstructive conduct. Thank you, DA, for making my point.
Yep.
Defense counsel acknowledges the defendant has contacted witnesses in this investigation. Apparently, oh God, that's a bus. And you just got thrown in front of it. Wow. Did you catch the plate? Apparently with counsel's blessing. Oh no. Whoops. But claims that the defense has studiously avoided interviewing grand jury witnesses. Fact is, the defendant has personally and repeatedly contacted multiple witnesses, including at least one he himself knew was a grand jury witness. The defendant contacted these witnesses, including at least one whom he had not been in contact with for years. Oh, shit. So, hey, you randomly called him out of the blue. You know, you haven't talked to him in 6 years, but they testified in the grand jury, and then you called them.
Normally, when somebody calls you out of the blue from like, years back, you expect that they have like found a, you expect that they have like found an MLM. Yeah, I bet they would have really preferred the MLM than from hearing from this guy again. Yeah.
Oh. So the defendant contacted these witnesses, including at least one, yada, yada. Okay. Defendant's behavior illustrates Judge Tarnowski's point that the counsel cannot control their client. Moreover,
oh shit, I got to apply for this. Sorry.
Contrary to counsel's protestations to the contrary, that's duplicative. You don't need to do that. Contrary. I don't like that. Contrary to counsel's protestations to the contrary, there's ample evidence from which to infer that the defendant's contacts are not innocuous. Indeed, the government has multiple examples of the context of such communication between the defendant and or his intermediaries and victims and witnesses. These communications include feeding victims and witnesses false narratives of events that they observed and or personally experienced. And they include communications were even made in the aftermath of the November 2023 civil lawsuit, during which the defendant was clearly concerned about the possibility of potential law enforcement act scrutiny, as during several calls, the defendant expressed his, oh God, they have calls.
Of course they have calls.
Yep. There's the wiretap. This is also the government saying, by the way, we have wiretaps. The defendant was clearly concerned about the possibility of potential law enforcement scrutiny, as during several calls, the defendant expressed his concern that his communications may be monitored. God, I love when the government says they were expressing concerns that their communications would be monitored. Insert quote of monitored communications. And that's what we have. See example. Quote, I can't really talk on this phone. You feel me? End quote. Quote, I'm not even supposed to be talking on the phone. End quote. Quote, I can't be on these phones and shit like that. You feel me? End quote. Quote, I can't even talk on the phone. Like, Please don't send no text or do nothing. People misread and shit. End quote. Oh, that's good. That's good. He was concerned about the monitoring of the communication. Insert 5 separately monitored communications. Oh. Finally, it bears noting that within the first 24 hours of this case unsealing, there are already new concerns about witness interference as well as interference with fair trial based on the defendant and his counsel's attempt to publicly discredit one of the victims. Oh, nope. Power imbalance. Defendant as alleged in the indictment and public known. Immense power. Consequently, his ability to coerce victims and influence witnesses is outsized. Just yesterday, during the bail argument and a subsequent appearance on CNN, defense counsel impugned the allegations made by a statutory victim, challenging the motivation and timing of her claims. In addition to being factually inaccurate, this sort of attack comes close to the limits set forth in Criminal Rule 23.1. Could also be expected to intimidate other witnesses who feel tremendous pressure to go against the defendant. Remember what it was that got Sam Bankman-Fried put in detention?
Yep.
For those of you who are wondering, oh wait. For those of you who are wondering, Sam Bankman-Fried was released on pretrial detention or pretrial supervision, and he was allowed to do all kinds of stuff. He misbehaved left, right, and center. He communicated with the press. He did all this other shit. You know what got him put back in the jail or put into the MDC until he was ultimately convicted? It was not just the interview. It was reaching out to Caroline Ellison, reaching out to other people and talking about getting on the same page. It was reaching out to, well, intimidating Caroline Ellison through the interview and using the saved Google Diary, the Google Diary communication. The judge was like, no.
The best wiretap I've ever had for a client, because they wiretapped my client, and the prosecutor actually cut him a break on the sentencing because of what they overheard on the wiretap. And it goes like this. Other guy calls and is like, hey, man, you're in a lot of trouble. We should meet up and talk. And he says, fuck you. I don't want anything to do with any of you anymore. Don't call me ever. And, you know, I'm done with all of that. And he just says, you know, and so other people call and want to talk to him. And he's just like, no, I don't want to talk to any of you guys. The prosecutor was just like, he had every opportunity to like try to work with his co-accused and so forth. And he was just like, no, I'm done with all of this shit. They cut him a break. They cut him a real break. So that's way different than that. And Apple Silver saying, what are the odds Diddy made everyone sign NDAs? NDAs don't mean shit. This is a criminal proceeding. They can say, they can testify.
Julia 543 pointing out very, very astutely, Rob, keep reading. Moreover, the government submits that this is yet another example of defendant's ability to obstruct these proceedings, even through the media. That's mistyped. C, United States versus Bankman-Fried. Remanding defendant who disseminated materials to the media in an effort to discredit and intimidate a trial witness. Yeah, exactly.
Oh, you gotta love it.
I do. And remember what I said on the prosecution learned from that case? Yeah. Both in argument yesterday and in the press, the defendant has emphasized his supposed cooperation with the government. Yeah, sure. The court should take that argument for what it truly is. Attorney-crafted theater designed to convince this court that the defendant can be trusted and is not a risk of flight. Yeah, that's a fair shot. That's pretty good. I actually might borrow that. Attorney-crafted theater. I like that. Attorney-crafted theater designed to convince this court. Huh, I gotta remember that. Attorney crafted theater designed to convince this court. I like that. Make no mistake, the defendant's recent behavior shows that he cannot be trusted or controlled, particularly now that he's facing serious charges that carry significant penalties. Yeah, the whole life possibility means that your life is literally on the line. Therefore, what are you going to do to, eliminate the risk that your life is taken away from you? Just about everything. As Judge Tarnowski observed, your lawyer asked me to trust you and to trust him. And I don't know that I think you can trust yourself. And I don't believe that counsel has the ability to control you. Yep.
Sucks to
Indeed.
suck.
Since at least in or about January of 2024, when the defendant was unquestionably aware of the criminal investigation, the evidence shows that he has engaged in multiple freak-offs. Oh, God. Some involving interstate transportation of individuals to participate. Contacted multiple witnesses and used narcotics. Some of the contacts has even taken place since the defendant had arrived in New York. No. No. There's no way. Some of this conduct has even taken place since the defendant arrived in New York City.
Now, I don't have the ability to upload videos, but just imagine that I am playing why this stuff's made in New York City.
So your lawyer gives you every bit of correct advice. Literally every bit of correct advice. Pay off the mortgage, secure the deed, do all of the things. Give me your passports, give me your friends' passports. You know what? Let's go to New York so that you can voluntarily surrender. The lawyer convinces you to do all the right things.
The thing is his compass just points to wrong.
By his compass, you mean his dick?
Yes. That is indeed the compass that he lives by.
Oh my God. Bro, you were in New York. He was in New York for like a month before he was detained, wasn't he? Like maybe a month?
I told you, it's the only thing that does it for him.
The defendant's attempts to distinguish recent sex trafficking cases in which defendants were detained pending trial are unavailing. Review of the case law confirms that pretrial detention in this case is consistent with the rulings, blah, blah, blah. For instance, it's bad when your case is getting sided with Epstein.
Yep. To be fair,
Epstein.
Things did not work out so great for Epstein.
No, really didn't. Blah, blah, blah. Case history. Proposed bail conditions to fail to adequately address the risk of danger. So, what do we think the judge is gonna do? What did the judge do, guys? Do we know? Do we know? I didn't mean to be condescending in that regard. I just was. Bond hearing as Sean Combs held on 9/18. AUSA Emily Johnson, Madison Smizer, Mary Slavic, Meredith Foster, and Mitzi Steiner. Is that an all-female team?
Oh, that's a choice.
Yeah. Holy shit. Is that an all-female team? Emily Johnson, Madison Smizer, Mary Slavic, Meredith Foster, and Mitzi Steiner. I fucking love that. I think that's phenomenal.
If I was Diddy, I would not love that.
No, if I'm Diddy, I'm terrified. Fuck yeah. That's awesome. He is so fucked. Oh, he's so screwed. And he's got male defense attorneys. Oh no, he is so dead.
The thing is, it doesn't play
Oh.
that much of a role, but it is gonna be.
It plays though. You know it plays.
It plays in front of a jury, and if I was him,
And in
I would
front of a
be adding.
judge.
If I was him, I would be adding to my defense team, a Camille Vasquez,
Find one that will jump on
possibly
Diddy's
actually
case.
Camille Vasquez.
Find one that will jump on his case. Do you know the hellfire that will rain down on any? And that's just a practical implication. I think it's wrong. I think that he's entitled to have a defense from and by whomever he can hire. But
there are
if
tactical
you're
considerations.
exactly, if you're a female lawyer that you're practicing, do you want, you've got to have a bunch of other clients going forward.
The dude, I think he doesn't want the female victims cross-examined by a male lawyer. Like, sorry.
That's a 5 female prosecution team. That's
going to hit him like a freight train.
Awesome. With these allegations, with the trafficking allegations, that is awesome. He's so fucked. That's so, God. Oh no. For those of you who are like, this is not a sexist thing. This is just an appearance thing. You have these individuals who, if Diddy calls witnesses, are going to be trying to justify conduct or explain around the conduct to a female lawyer when the conduct is alleged as against the female and males. Like, this is, So continue to read on. The bail's been denied. Joint status report is due on September 23rd. Status conference set for October 9th at 2 p.m. Defendant remains in custody and remanded to MDC. So Diddy's in jail.
And that's where he belongs.
Mm-hmm. And apparently he is on a certain type of watch for individuals that are at risk of engaging in conduct that
they're worried he might give himself an expiry date.
Which, to be honest, facing charges like this, I understand why they have that concern. I just hope they have better supervision over him than, well, let's just say past cases.
I personally don't much care if he goes bad like milk.
I do, and here's why. There were a whole lot of people that engaged in conduct to prop this up and prevent it from being.
And he ain't saying shit.
I know that.
So, like the notion
here's the thing. Here's what happens. Once the head of the snake, right? If the head of the snake goes bye-bye, you're not really as concerned about the body of the snake anymore, or at least the body politic, the people around it aren't. I am personally. I'm looking at this and saying, yeah, Diddy might have done a certain thing and no longer with us. Hypothetical, folks. And for me, I'm like, that's not the end of the story. You have to keep prosecuting. But for a prosecutor, for other people, they're like, no, we can accept this. Me, I can't. Not knowing that these organizations are built around this to basically facilitate this and protect it and insulate it from everybody else. Because he was friends with everybody. The reports of who were at these things, suffice it to say, you've got Kardashians, Jay-Z, Cuba Gooding Jr., you've got everybody. So a whole lot of very important people.
Yep.
So actually, I was curious. Let me see, because 50 Cent has been my favorite person who trolls Diddy, did he have anything going on with the arrest when the arrest was made? Please tell me he made a remark on Twitter. Hmm. He did. It's worth it. Hang on. Give me a second. 50 Cent. Other news, takeover, self-promotion. Cool, cool, cool. Love it. Or was it? Here I am keeping good company with Drew Barrymore TV and $1,000 of lube at the house. It had more Viking stuff, but class act, right? All right.
I am becoming a fan of
50 Cent.
Yeah.
The trolling, his trolling is top level. But a lot of people have gone aground, and you have a bunch of people that are calling their lawyers. And if they can't reach their lawyers, they're calling, perhaps in certain circumstances, prosecutors to say, so hypothetically, if I had information to offer, would there possibly be an immunity deal?
I mean, I imagine there's going to be some people out there going, I would like to make a deal. Like, I got all sorts of information, but I want some immunity, please.
And the prosecutor's going, well, here's the thing. We have videotape, so you better have some good information.
Yeah. I suspect there's going to be some people walking in going, so I want an immunity deal. And the prosecutor's just going to look at them and go, you ain't getting shit.
Or
and
the
he's gonna be
prosecutor's
like,
going to look at him and look at him and look at him, look at their board and look at the photo on the board and be like, hey, that's you. We've got something for you. Here's some paperwork. Take that, give it to your lawyer, and appear at the courthouse on this date for arraignment. This is going to be interesting. And by interesting, I mean, look, Ian and I have talked about the Diddy stuff for quite some time. And I have been right in my predictions thus far about the pending charges, about the fact that they were going for this, about all these different things. I imagine that we are going to see additional indictments announced as to different individuals associated with this, but it's going to be quiet for about maybe 2-3 months, because right now the DA's office is handling a very high volume of calls right now from individuals that are very much wanting to not be charged.
Yep.
So we'll see.
Suspect.
Catching up. Two Dogs Mom, thanks for a great year. Been here since Depth You Heard. Glad to have you. Two Dogs Mom. That's awesome. Jan V, my oldest kiddo sleeps in a sleeping bag under his flat sheet, comforter, weighted sheet, and fleece blanket layered on top. That's a whole lot of warmth.
Mm-hmm.
That's a lot. Francie Lou Who, flat sheet equals covers when too warm for blanket. That's my logic. Bop it. Can't believe it's been 2
have
weeks.
used a sheet for that, but I don't normally use a sheet. Like, I don't normally have a sheet.
Bop it. Can't believe it's been 2 years. Woohoo. Glad to have you, Bop it. Always a friend. Krista, limited edition. Rob, you making a pen and pencil set for the auction this year? My autistic ADHD son wants a set for this year for his first year at university. Yay. November 2nd.
There's time.
There is, and it's
if your shop is up and running.
If the shop is up and running. So tomorrow is already taking a hit because it's 1:24 a.m. So hopefully the shop's up and running by the end of the weekend. Please. Please. I don't know if it's because I'm older and move slower or what, but I feel like I can't achieve nearly as much as I need to in a day anymore. I
Oh,
will
I'm
try
feeling
to,
that.
Yeah. Brissy girl, might have found my cat. Been missing since August 7th. Wow. Wait, might have found my cat? If you found your cat, that's amazing. Especially if missing
Please
since
tell me
August
this
7th.
isn't the cat that's been connected to the whole internet thing.
No,
Okay, good.
I'm just reading that as might have found my cat. It's been missing since August 7th. If that's the case, congratulations. I talk about Bruno. My 18-year-old is working at the local scare fest as a second job. No clowns is the rule in my house, so Kidlet is a psychotic butcher. Proud mama. I don't do clowns either, but proud butcher or butcher is a good one. Angie,
Rob got annoyed at me when I played a
no, I don't do
clip
clowns.
of a clown.
I don't do clowns. I don't like clowns. Clowns not cool. Let's see. Angie, it was Kid Cudi's car. He confirmed one of his cars blew up around the same time, and allegedly Diddy and his accomplice did the blowing up. Why was there no arrest? If he bragged about it, why was there no fucking arrest? Cindy Collins, I'm very, very late, but zooming to catch up. You've got time. It's almost 5 hours. Legion News, how is corn? I imagine that is voluntarily sex work, not prostitution, but Diddy will try to argue he hired porn actors and actresses. They arrested Diddy early so he could not self-surrender. They showed up at the location that he announced he would be.
The other thing is, if you are trying to film whatever,
That
you can't, like, putting yourself as an actor is a great way to go to jail forever.
Mhm.
Or putting
Actually, there are
yourself
certain
as
actors. Aren't there actors that have gone away to jail for that?
Yeah. Also, like, you got to keep your hands north of the border. Yeah.
Yeah. And I imagine he's going to try and argue this. I don't know it's going to play very well.
We'll see what
Not
he
if you-
argues. It'll be interesting.
My thing is, if they're on videotape, we'll be able to confirm or deny what occurred pretty quickly. Legion News, how do you attach all the income and his wealth to the crimes? He does not make money off his freak offs. His income appears to all be from his music. It is the commingling and pooling of money. So let's say that money goes out for purchase of materials. Some money comes back in. If you can't distinguish between the two, here's the thing with forfeiture. The government takes it first, and then you have to argue to get it back. You might be right in getting it back, but the government takes it first, and you got to argue to get it back. So it's a hurdle he's got to go through.
And he may not be able to succeed. It might be, some of these things might be like assets used in crime, like his plane. They might say you use this to ferry women to, events, and therefore, yeah. But the other thing is they're alleging that, like, his entire empire is an engine of this crime, right? So I think that may also cause them some problems.
Yep. I think you're probably right. Jamie F. Wonder if Freakoff came from Freaknik in Atlanta. I don't know. I don't. Allegiant News. Rob is sexist and thinking a woman that joins Diddy's team should have fire should rain down on her. Never mind presumption of innocence. No, actually, that wasn't what I said. I said that there are practical implications to any person, female, that would want to join his team. It's an actual consequence. If you are a female attorney and you are joining on with Diddy, tell me this to my face. Do you really think that the next client you sit down with that's a female that might be a victim of a sexual crime is going to ask you about who you represented in the past, especially if it's a high profile case and Diddy was one of your clients?
And the thing
Do you
is
think
female lawyers get judged for this
all the
so
time?
much worse than male lawyers. It is like straight up so much worse.
No, I'm not calling about fire rating down on them. I'm saying as a practical matter, they will have fire rating down on them. It is going to happen. I'm not saying what should or shouldn't happen. I'm saying it's going to. Tell me right now, based on how the media reports stuff, female attorney blank joins Diddy defense team in sexual trafficking case.
Yep.
What happens?
Oh, I mean, it gets, it absolutely gets reported.
Never mind the presumption of innocence. As to that remark, oh no, there's a presumption of innocence. There is. Presumption of innocence on the charges that are alleged. He has a very large uphill battle. He is presumed innocent. I am willing to bet a whole lot, as we have discussed in the past, during those raids, during the seizures, during the different lawsuits that have been filed, 9 of which we can count right now, all of which have been corroborated by third parties and have receipts attached, including photographs, videos, etc., that the government is not bringing this charge frivolously. So they have to prove their case. I think they've got a long way. They've already come. So will Cuba Gooding Journey be a witness or charged? I don't know. Honestly, I don't. Rose Lee, thanks for being a member. Hi back. We have a great weekend. Sandy, thank you for gifting memberships. Very much appreciated. Even though you're a mod and shouldn't be doing that, thank you anyways. Alan Muller, the problem with non-extradition country, he needs a place that will tolerate his behavior.
There
Other
are countries
places,
that will put up with a lot of shit for.
And a comment by Allegiant News that I could not agree more with. Civil asset forfeiture is bullshit. Yep.
Oh, absolutely.
Oh, it has been forever. Doesn't mean they don't get it. Absolute bullshit. So happens in every case. It's a statutory power that I think is way too overblown. It's used everywhere, and it's used to put leverage and pain on the defendant in every case. Lynn, charity at 4K, need 1,000 more for my flat sheet to return to me. Charity is at 4K. We hit 4K. You know what? That's a really good endpoint. I will go without the flat sheet for that anytime.
I have scaled down my initial.
Tenny Garagos is female. I see. Tenny Garagos is female.
Okay.
Why shouldn't mods give membership? Mods gifting memberships is the mods contributing monetarily to the channel, and they contribute their time and significant amounts of that time. So I tell them that I love that they grow the community, but that they don't have to do that. That here, we'll do this. Let's see. Yeah, the mods don't have to do that because they already contribute so much in the time that they're spending here moderating chats. Let's see. Allegiant News. There were a lot of people that attacked Camille Vasquez.
Oh, absolutely, there were.
Tons of people attacked Camille Vasquez. If Johnny Depp's case went the other way, what should happen to his female attorneys? I think nothing the same as if a male attorney was on his case. The practical implications that you are ignoring by this statement Camille Vasquez was attacked. If you have to remind yourself, go back to what was being said about her during her defense of Johnny Depp. Did we agree with any of that? No. But was it happening? Absolutely it was. Any female attorney that jumps onto a case involving sexual violence, etc., there is a certain outlash that comes from the community of individuals in the ether. Just all the people. It's not fair. It is wrong. It is terrible. But it is a backlash.
Basically, people suck.
People suck. And a lot of people are of the mentality then rather than deal with that suck, I would just rather not do it. I cannot ask someone to stand up to that level of hate that's spewed out there all the time because it gets ugly. People make remarks about male lawyers, but I've never seen anything as disparaging as what people will say about female lawyers. It's really awful what people say. And it's wrong. Diane Tincher, how many times you're having fun? 2 years? Thanks for being a member for 2 years. That's awesome. The world wonders one of the junior lawyers helping on JD's case was basically canceled as an alumni at her law school. Would not have happened to a guy. That's the point I was making a little bit. Elysian News, you and I are just not, you're not hearing what I'm saying. Ian, can you help explain this?
He wasn't arguing for it. He was noting that Diddy is fucked. Also, this is not a civil asset forfeiture case. This is a criminal asset forfeiture case.
He was not arguing for it. I was saying the government's going to get it. Not arguing for it. The government's going to get it. They're going to get it because the statute gives it to them. Look, I would love to argue and tell you that things are not the way they are, but shit, the things are the way they are. So, my God. All right. We have reached the end of a 5-hour live stream.
Do you want a palate cleanser?
I would love one. Hang on. Let me read this first. Yellow Pill. Diddy having a female attorney cross-examine female witnesses is probably not a bad idea. It's a good idea. It's a very good idea. 1. 2, I wouldn't be bothered to have a female attorney that represented him. It takes a lot to advocate even for trash. It does. There's a lot of, yeah. You got to go through a lot of shit to get there.
Yeah,
I can ignore
absolutely.
it. I think. And I give massive props to the people that do. Elysian News. I get it. You want to make this argument, but you're not gonna make headway.
He's saying that there are
not
costs to doing it. That doesn't mean it's like it isn't fair, but he's pointing out that there are social costs. That is just straight true.
You're arguing, like you're telling me that I can't tell you that when it rains, the ground gets wet. When something happens, there's an actual natural consequence to that thing happening, whether it's right or whether it's wrong. You know, when a volcano erupts near a town gets hit by volcanic ash. I wish I could tell you that it didn't happen, but fuck, it happens. I'm not going to lie to you. I'm not arguing it's right. I'm saying that it is a challenge that anyone has to face if they're making that decision.
All right, palate cleanser time?
Yes, please. My God.
All right. Let me just pull this up here. And
yeah. Oh, you have this video. You have this view.
And yes, there's Rob off
Yeah,
to the
that's
side
me.
there.
Yeah, that's me. Wait, hang on. I need explanation. So here's the thing. Ian got nominated for the Gundies for an award at the Gundies, which is I don't want to say influencer, but it's basically content creators who create content surrounding gun advocacy, Second Amendment advocacy, that type of stuff. Ian was nominated for an award. The award ceremony took place in Vegas. It also happened to coincide with his birthday. So a bunch of people got together and put money. A bunch of people got together, put money into a pot, and basically,
And they did this all in secret. Nobody told
They
me
did.
what was going on.
Devin, the individual that was visiting up here in DC, down here in DC, because he's in Canada, was the one that coordinated the lovely idea of allowing Ian to drive a tank and drive it over a car. So we took a car out to this place where you get to drive a tank over a damn car. They drag a car out, and Ian is the one that's driving the tank. Like Ian is physically driving the tank.
It was
That's
a lot of fun.
that is not your phone that is filming that. That is the phone belonging to Mrs. Runkle, correct?
I think that was actually. I think Devin told me to bring my GoPro.
Was that the GoPro footage?
I think that's the GoPro, and
Yeah, because you see a little bit lower than everything else.
and it wasn't me filming it. It was what is it? I think it was Devin filming it. And if you listen carefully at the end, you can hear Mrs. Runkle laughing.
Yeah,
Because she's
and
also on the thing there.
not.
Devin
not
says the
using
GoPro
real
was
names.
on his head. Yeah.
I'm not using real names. Devin is Devin. Devin is Devin. Devin is Devin. Not surprising anybody. But yeah, it was a GoPro. It was pretty awesome, and the crunch that thing made. So I was filming it. They were filming it. It was a blast. A lot of people were watching. It made everyone the noise that car made being smushed by the tank. That was so satisfying.
They noted that they get the cars on, like, they keep an eye out for like deals on cars, and then after they crunch them, they resell the cars. And apparently there's still like a bunch of parts that get pulled out of those cars before they get like melted into a cube. So it was a lot of fun.
It was an interesting experience. I can tell you that I never saw a tank run over a car before, and yeah, the sound was something.
Just the crunchity crunch was yeah. We've got a few requests to play it again.
Let me see if I can find my video of it. You can play it
Your
again.
video might show Mrs. Runkle, so
Oh, it does. I don't want to play that one then. Oh, that's right, because my video is awesome, but it shows. Yeah.
it such is life. All right, play. And the guy in front is like slow, and then he's like, got it. so tempted to get a tank if I could. And at the end of it, they're like, please park tank on top of car.
They did. They actually instruct you to park the tank on top of the car.
And yes,
so-
this was used in one of the Bond movies. I forget which one.
GoldenEye. This was the tank
Yeah.
that was the one that came out of the tunnel. So this was used in GoldenEye. It was a retrofitted tank to make. It was made to look like another tank. I forget what one is specifically, but yeah, that was that was a lot of fun. Where is Ian sitting? Ian is sitting right up by the you're
Sort
forward
of.
of this.
I'm forward of this. So forward and down and inside,
In the
basically.
barrel, like you're way down there.
Yeah, I'm like a little bit to the left of the barrel and down on, inside.
Pallet is cleansed. Right.
I figured we needed something that was, yeah.
Message to Missive. Think ahead. Menopause and hot flashes. You won't want to be in the same room as a blanket. Allegiant News. I do appreciate the back and forth. Sorry, Rob. I do enjoy the show. Have a good weekend. You too. I don't mind the pushback. I try to give explanations. I really promise. I do. All right, folks. We're going to wrap. It's been 5 hours and 16 minutes. It's been a while since I've done a 5-hour stream. Ian, thank you for being here, my friend. Ian has been putting out videos damn near every day, except for the fact that he gets sick from time to time.
Yeah, the sick sucked. I've got a bunch of videos I want to talk about. Did I tell you? You remember Mark Jerome Johnson Blunt or whatever it is?
It's a whole lot of names, Ian. It's a whole
He's
lot of
the
names.
guy who filed
Yes.
he filed pleadings with his LSAT score.
Yep. I know. I'm
got a new
depressed. You have
job.
to say the answer. You said this out loud and you told me in text.
Yeah, I really want to do a video on that one because
Do you want to preview the punchline or no?
I'll give the punchline and then I'll go into more detail on the video.
Julia 543. Yes, it's Dred Scott, dude.
It's Dred Scott, dude. He's a prosecutor. Like he became a prosecutor. And the thing I really have, I've decided against it, but I had an ethical question about it, which was their press release about him becoming a prosecutor actually included a thing saying, call if you have questions about this release. And so I really wanted to call them and be like,
oh, no.
Did you know when you hired him that he filed something citing Dred Scott? And not like for some random small principle, but he cited Dred Scott for the principle that some Americans have more rights than others, which specifically Dred Scott meant Black Americans have fewer rights than white Americans. That's what the case was about. A prosecutor who thinks that that's good law is fucking terrifying to me.
Mm-hmm.
So I just kind of wanted to be like, did you guys know that this is the guy? And yeah, but I've decided it would kind of be a party foul, kind of be a dick move to phone them because they might fire him. But then I go, would that not be a good outcome? I don't know. But if I was a defense lawyer in his area, I would be absolutely putting that shit into my back pocket.
Mm-hmm.
So
Prosecution
yep.
seems to think that Dred Scott is still good law. So do we really believe what he's telling the court right now? Yeah.
Or, hey, they have a Brady violation, and my client happens to be black, and he has previously espoused racist views in, in these filings as a pro se person, and so maybe this is also just specific animus towards my client. So,
Yep.
yeah, that I think, like, of all the jobs he could have gotten, and you know what, I don't want this guy to be like out of work forever, but like, my dude, wills and estates or contract drafting or some shit other than prosecutor.
You mean to say anything other than prosecuting cases?
Yeah, just anything other than prosecuting cases. So,
yeah, anything other than arm of the state.
Yep. So, yeah.
I'm with you on that one. So, well, keep an eye out for that one because I'm sure that Ian's going to be very restrained in his remarks. I'm positive.
That's totally my brand.
He will be civil and restrained and will not actually express his true opinions. So
I'm just trying to think of some of the things. On my Discord, there's a Runkleisms channel. Mm-hmm. And I'm just trying to think of some of the things that they have like quoted me on.
There's a lot. There's a lot of good ones.
There's a quote, "This filing is the equivalent of whiskey dick of the soul."
Can't say I read that one.
That was Carrie Morrissey's like 52-page whatever.
I'm gonna concur with the assessment, by the way.
It's not wrong, but
could have been worded differently, but
yeah,
decisions were made.
Yeah, I the other thing I think I need to do is like make a book of Runkleisms, or maybe a like a calendar of Runkleisms, and then
calendar, definitely calendar.
Maybe I should make a calendar and just like maybe I should put them up for like Extra Life donations or something like that.
Calendar, solid calendar.
Fair. Then I have to get pictures for that, but I can figure that out.
No, you don't. You just have to. You have to do like a meme text, like just the quote with the meme text, and then Ian Runkle, and then, so they peel off the calendar. Nope, that's not going to be said out loud. That is not going to be said out loud. I think I remember when you said that too. I don't know how your brain gets some of this stuff, but it gets there.
I just kind of take the leash off my brain and it does these things. So
it can tend to do that. Yep, and we all benefit from it.
It's but I was also the person, like, people are like, you wouldn't ever do this in court. And then I played my Supreme Court appearance where I described the situation as like a 10 beer situation.
I forget how you describe it, but I remember something.
I basically noted that, like, sometimes somebody might get pulled over for, drunk driving, and they say, I've had 2 beer. It's like, okay, 2 beer is like, maybe they're over the limit. So they're like tiptoeing up to a limit. But this is more of a 10 beer situation. This is not like a little, that they're a little over. This is way over. and they should have known that they should never be in a car, or similarly to apply to this the situation. They should know they were violating the this guy's rights. But yeah, I had somebody later being like, wait, a 10 beer situation? You said that to the Supreme Court? And I was like, yeah.
I don't take it back either. Okay. I'm going to wrap up. We have to wrap the stream. Okay.
All right.
Arlene, Nava, will you guys be at SHOT Show again this year? It
I
depends.
hope to, yes.
When nomination opens, you guys have to nominate Ian Runkle and we have to get him voted in.
I'm also going to, I will probably go to SHOT Show either way. Just to go to SHOT Show. But yeah. Lara M is saying bonus stream this weekend or just Monday. I just bought a new webcam, like the Logitech Reach. I need to get into the leather shop to make something for this. So yeah.
That means we get bonus stream.
That I'm thinking bonus stream. Yeah.
Usually we get bonus stream with that.
So that is the idea.
Keep an eye out for Ian going live this weekend. Guys, follow Ian's lead. Go out, make something. You feel better. Get outside. Enjoy the weather while you still can before the winter comes and freezes us all out. Cheers to all of you. Thank you for being here. Very much appreciate every single one of you for the contributions to the chat and the lovely discussions that we can have. Ian, thank you for being here as always.
Thank you for having me.
Will,
This is always a great time.
Oh God, we're just laughing over and over again. Always goes longer than we think it's going to go. 5 hours and 26 minutes ain't too bad. So
yeah, but it
good night,
feels
guys.
shorter than it is. So, good night.
Good night. Cheers. Have a lovely weekend. Go out there, make something. You'll feel better. I 100% promise. Let's find where the outro is, and I'll see you next week. Night, guys. Bye.